Welcome to a Legalbytes presentation of the Karen Read murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Read case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Read murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Read says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. All right, everyone, welcome back. Welcome back to day 30 of the Karen Read trial. We've got a lot today. So if you guys have been following along, we are now in the defense case in chief, and the defense has already put on 3 witnesses. Those were Lucky Loughran, Dr. Marie Russell, as well as Richard Green. So we've already got a couple experts. I think the rest of them are supposed to be experts. From what I have heard, because I think Alan Jackson made a statement to the press. I think he said that what was I going to say? He said that their plan is to have 3 more witnesses. I think they anticipate getting all 3 of those witnesses finished today, which would mean closing arguments tomorrow. It's been a long trial, but it feels like so sudden now that we're in the defense case in chief. And I kind of thought that that was going to be the case once we got to the defense, because most of their work has been done during the prosecution's case in chief, telling the factual story, using all of these witnesses through their cross-examinations. So now it's really just a matter of calling the witnesses that the defense or that the prosecution didn't want to call, like Lucky Loughran, and then giving their experts to explain this information, to explain what a lay witness cannot explain, the physics, the math, the medicine, all of that kind of stuff. So that's what we're going to be seeing here. Also, Perky Potato, day 30 on my 30th birthday. Happy birthday. Thank you so much for spending it with us, or at least part of it with us today. I hope you have a wonderful, wonderful birthday. I hope that you were able to celebrate over the weekend as well. And if not, celebrate next weekend. Continue celebrating all month. Alrighty. So we also, let's see here. Also, questions in the chat, as always. Tag me in it, or add a bunch of Q's for question, or big red question mark. That way it'll help me see them so I can save them. We'll be pausing and catching up on the testimony. We'll fast forward, of course, through all the recesses, as we love to do. And yeah, so let's get going, shall we? Okay. And also, oh yeah, there's a day 29 recap is out. That went out a few hours ago. And yeah, so everything's up to date. The Lally tally is something that I sat down and I realized, oh my goodness, I forgot to post that. I forgot to set all of that up. So I have the numbers. I just have to put them together. I'll probably end up posting that something, like during the lunch break or something like that, or maybe at some point, during the stream. I don't know. I'll find a minute at some point to do it and get caught up on that again. So I apologize. I don't have the Lally tally handy at the moment. We will for sure. Okay. All right. Let's get to it, shall we?
Now sitting in Dedham within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
22117, the Commonwealth versus Karen Read.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I'm going to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left here on Friday? Yes. Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no. Shook their heads. Thank you very much. All right, Mr. Jackson.
Good morning, Your Honor. Defense calls Dr. Frank Sheridan.
Great.
Dr. Frank Sheridan. This is the forensic pathologist. So we are going to hear Frank Sheridan talk about the autopsy results, things like that. And it's going to be done by Miss Little. That's awesome. Elizabeth Little.
This way. Just watch your step for me.
Yeah.
Remain standing and basic work.
You solemnly swear the evidence you give the court and the jury in the case now and here ensure the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning, Doctor.
Good morning.
I'm going to ask you to, when you testify, sir, please speak into the microphone if you can, loud and clear.
Very well.
All right,
Okay.
thank you.
Is it working?
It should be. All right, thank you.
All right, Ms. Little.
Good morning. Could you state your first name and spell your last name for the record, please?
My first name is Frank, and the last name is Sheridan, Sheridan.
And if you can make sure to keep your voice up just because the air conditioner is very loud.
Yeah, I noticed that. Okay.
Dr. Sheridan, what is your profession?
I'm a physician, and my specialty is forensic pathology and neuropathology, but most of my career has been primarily forensic pathology.
He sounds like Alan Rickman. Folks in the chat who are from the UK, if you guys can help us pinpoint which accent this is or where this comes from. But as he's talking, I'm like, this sounds like Professor Snape. So yeah, anyway, that was instantly endearing.
What do you currently do for a living?
Nothing. I'm retired.
What role or position of employment did you hold before you retired?
Okay, I was the chief medical examiner for San Bernardino County, California, and I was in that position from 1991 until 2017. That's when I retired from that position, but I stayed on a part-time basis for another few years to help out because the office was understaffed. But a few years ago, 2021 or 22, I've lost track of the time, I finally stopped altogether.
Dr. Sheridan, if you could just pull the microphone a little bit closer. I don't know if
I'll put myself closer to it, I guess. Okay, is that better?
Irish.
And Ms. Little, if we need to, just let us know and we'll turn off the air conditioning.
Your Honor. Describe your educational background for the jury.
Okay, well, I was born and raised in Dublin, Ireland,
There you go.
and
Dublin, Irish.
I had all my initial education there, including primary school, secondary school, and then pre-medical school at the university I was at was the University College Dublin, Ireland, which is part of the National University of Ireland system.
Now that he said the word part, I'm like, okay, I can hear the Irish.
So I did my pre-med and medical school training there. And I graduated from medical school in 1971. Then after that, I did a one-year rotating internship, as it's called, of medicine, surgery, and some psychiatry as well. That was a requirement for all doctors for licensure. So that's basically my initial education. After, should I go on with my CV or base or not?
Yes. What did you do after medical school to complete your training?
Well, in the years after medical school, I wasn't in training anymore. I was working in Africa, actually, as a medical officer. And that wasn't training, that was a job. And I was there for 3 years in Central Africa. And I was a general medical officer with various duties that included some teaching, but also seeing patients. So I did that for basically 3 years. I then returned to Ireland and I spent the next 2 years, we're now talking about, by the way, the years I'm about to mention are 1976 to 78. So I was back in my home country, Ireland, and I spent those 2 years doing research and lecturing in pharmacology. Pharmacology is the study of drugs and how they act in the body. And I did that back at the same university where I had originally trained for medical school. So then in 1978, I came to the United States, initially to the University of Oregon, and I spent the next almost 3 years doing research there and lecturing in the field of genetics. It was during the time I was there that I decided to do forensic pathology. So starting in 1980, let me think for a second, 1982, I then had to start what's called a residency program in pathology. And the first part of that, the first year of that, was in Loma Linda University Medical Center in Southern California. I then had to interrupt my residency training, and I had to go and work in family practice for a year. This was because I was going through the immigration system of the United States, and they required that people in my position work for a year in family practice in a manpower shortage area, as they designated it, an area where there weren't enough doctors. So I did that in a place called Yucca Valley, Y-U-C-C-A Valley, California. But then after that year, I returned to the residency program and continued it on at Loma Linda University Medical Center. And this training was in what's called anatomic pathology, which in a way you can think of it as general pathology. It involved autopsies, it involved surgical pathology, looking at slides from surgery. It involved a few other things as well. And so I was doing that there at Loma Linda. Then from 86 to 88, I went to Los Angeles County, USC, which stands for University of Southern California. So LA County, USC, as it's generally known, for 2 years of training in neuropathology.
Interesting. So the same hospital as Dr. Marie Russell. That was LA County Hospital, USC Medical Center. She also had her ER work was there. But that's interesting that he worked in the same hospital. This is fascinating. It must be that there was some kind of a personal connection through Alan Jackson's network to have this sort of connection through Los Angeles for some of these experts.
Neuropathology being disease and injury of the brain, spinal cord, so forth. So that was from 86 to 88. And then in 1988, I went to the coroner's office, as it was then called. It's now a sheriff coroner's office, but at that time it was a coroner's office. And in San Bernardino, I did my 1 year required training in forensic pathology there. When I finished that year, I stayed on at the same office. And then in 1991, I was appointed chief medical examiner for the county. And as I mentioned earlier, I was in that position up until 2017. And I'm board certified in anatomic pathology, which I mentioned before is general pathology in a sense. Also neuropathology, as I mentioned about the brain and spinal cord primarily. And then finally, forensic pathology.
In other words, Dr. Sheridan, you're triple board certified. Is that correct?
I am, yes.
That's awesome. It's great because his answer was very, very long and very full. And then she's just like, so basically just to put a bow on this, you're triple board certified. Yeah. You're a triple threat. He's like, yeah, basically. So, and because that's one of the sticking points that Lally has liked to point out, and this is any trial. This isn't just Lally, right? Any trial. If you've got an expert witness that is board certified and the other side has an expert witness who isn't board certified, you want to point out that your expert is better because they are board certified. You know, whether or not that makes a difference, I think to most juries that probably doesn't make that much of a difference. But it's just it's always fun to sort of like which side is going to show that off, you know, and this one for him to be a triple board certified is pretty impressive. Diane Luch, waiting for Avada Kedavra. Morning, beautiful people. Good morning. Good morning. And yeah, I don't know if we'll get an Avada Kedavra from him because he's used to looking at cadavers already. But yes, I am. I still now that I've heard him talk for a little bit longer, I'm hearing less of Alan Rickman, which is a little bit like it kind of saddens me a little bit. But I still love his accent. It's a beautiful Irish accent.
and that's in anatomic pathology, neuropathology, and forensic pathology.
That's correct, yes.
Can you describe any relevant teaching positions that you've held?
Yes.
You can keep your voice up. I'm sorry, it's hard to hear back here.
Okay, I'm sorry. Yes, I still do some teaching, actually. First of all, I'm on the staff of Loma Linda University Medical Center, the place where I did my initial training. And I give lectures on a regular basis there to the pathology residents, like I used to be myself. And in addition to that, for a long time, for about 20 years actually, up until COVID, I was also giving annual, well, no, actually twice a year, courses on forensics at the University of California, Riverside Extension, as it's called. And I did that for, as I said, essentially 20 years, I think. But that stopped with COVID. So I haven't been doing that since the beginning of COVID epidemic. I've also given annual lectures, or not lectures, but courses, 3-day courses, to the California Criminalistic Institute, which is part of the forensic system in California. And then in addition to that, I was associated with another university for a while, but that sort of gradually elapsed. And that's basically it. I give occasional lectures at, well, actually at least once a year at various other places, just individual lectures. I'm a visiting lecturer, in other words, and at community colleges and even high schools, actually. And then I forgot to mention one more thing. For 2 years, I was a visiting professor at a university in China, in what's called Hangzhou, I don't know if I pronounced it correctly even to this day, but Hangzhou, H-A-N-Z-H-O-U, whatever, H-O-U. It's a big city in China anyway, somewhere. And I was there for 2 years, on two different years, I mean, giving courses on forensic pathology.
And Dr. Sheridan,
It's so funny. He's like, well, you know, I've learned and worked in so many places around the world that it's like, whatever, this part in China. Like, you know, like I think I'm pronouncing it correctly. Maybe not. I'll try to spell it. Okay, no, I can't. Like it's a part of my resume. I just happened to be in China for a bit as part of my work. It's just so funny.
are you a member of any academic or professional societies?
Of societies? Yes, I've been a member, although I've let it lapse recently intentionally, but I've been a member of the National Association of Medical Examiners for many years. I'm also a member of the American Academy for the Advancement of Science, and also the American Forensic Institute, or the AAFS, American Academy of Forensic Science. I'm also a member there.
And have you authored any peer-reviewed articles or publications in the areas of forensic pathology or neuropathology?
Yes, but not recently. When I was working, it was too busy to publish. But yes, I did author a few papers earlier on in my career. One of which it wasn't really neuropathology, but it was urology more than, well, it was actually neuropharmacology. And then I did author another paper on that was related to my forensic pathology work on organ donation, organ and tissue donation for transplantation. Those are the two main ones, but there were a couple of other lesser papers.
Can you describe your duties as the Chief Medical Examiner of San Bernardino County?
Yes, as Chief Medical Examiner, I had some administrative responsibilities. Fortunately, not too many, because there were other people to do it. But most of my responsibility there was supervising the medical part of the coroner's office. In other words, the autopsy section. And I was supervising other pathologists, but I was also working full-time doing autopsies myself. So I spent most of my time actually performing autopsies. But I did have, as I said, administrative roles and the role of supervising colleagues. And of course, as a medical examiner, as a forensic pathologist, I frequently had to testify in court, rather like I'm doing now.
Sounds like it.
So that was another part
That's
of my
where the
duty.
experience comes from.
And during the course of your professional experience, approximately how many autopsies do you believe you've conducted?
It's between 12 and 13,000. I think it's closer to 13,000.
And have you qualified as an expert in the areas of forensic pathology, neuropathology, and anatomic?
In courts, yes. Yes, well over 400 times.
How many was that?
Over 400.
And did you review materials related to this case in furtherance of coming to an opinion and conclusion about Mr. O'Keefe's injuries?
Yes, I did. I reviewed quite a lot of materials.
What did you review?
Okay, I reviewed the autopsy report on this case. Along with that, there was the neuropathology report, which was separate. There was a toxicology report. There were autopsy photographs. These were all of primary importance to me, all these things. Then I also reviewed the complaint in this case, outlining, in other words, the basic details of the case. I reviewed photographs taken at the scene of death of Mr. O'Keefe, photographs of the vehicle that was allegedly involved in his death, photographs of the decedent himself before the autopsy, while he was at the hospital, at Good Samaritan Hospital. Then there was also some videos of the scene of death. I also saw the death certificate, a document by CERT, S-C-R-T, police reports from Canton Police Department. Am I missing anything out? I don't think so. Yeah.
Your Honor, permission to publish what's been previously marked as Exhibit 19.
Sure.
Dr. Sheridan.
Here's the thing before we really get into it. So remember how his testimony is to come up right up against the testimony of Dr. Stonebridge and Dr. Scortibello from the prosecution side, the two the medical examiners who actually examined John O'Keefe's body. I anticipate that that's going to be something, by the way, that Lally is going to ask him to be like, well, you didn't actually examine his body up close, right? Like you didn't actually do the autopsy, you didn't do this and do that, like physically get your hands on his body. Okay, sure. But there's, will that really matter to the jury? I don't know. Maybe, maybe not. Probably not. I don't think so. But remember that the conclusions that both of them came to from the prosecution side, Dr. Stonebridge, Dr. Scortibello, they both came to basically uncertain conclusions. Yes, they said that there was some sort of head trauma, right? There was blunt force trauma to the head. That's how he died, plus hypothermia. Then, however, when it came to the actual mechanism or the object that caused the blunt force, I don't know. So there's a lot of uncertainty coming from their testimony, and plus the undetermined manner of death conclusion that Dr. Scortibello came to. So here, the defense has, let me back up before I say what I was just about to say. Already, the prosecution side experts are fairly helpful to the defense because of the fact that they're uncertain. They're not very, very clear. And what the prosecution needs, they've got the burden here. They need to be the ones to say, this is how it happened. And if it is the case that they can't convince the jury as to what happened because there's too much uncertainty coming from their own side, they would end up losing. Now here, the advantage for the defense is there's an opportunity here. And the question is, what is this expert going to say? Is he going to say it's still uncertain? Or is he going to come to a definitive conclusion and give a very thorough and nuanced reason why he says what he says? This is going to be very interesting to hear what he has to say. P. Doggy, thanks so much for the super chat. New Paul Hoslong to return acquittal verdict. That's going to be after closing arguments. That is a perfect question. Thank you for putting it that way. I'm 100% going to steal that. Also, Debbie Faison Cook, one of our awesome mods. Thank you so much for putting this up in the chat. Trigger warning: you might need to step away for a while, mute, or catch the next stream. Look after yourself. Yeah, we're gonna be getting into some of these details again. YouTube's not gonna like it. Whatever, it's fine. That kind of stuff tends to be disfavored by the algorithm gods, but it's whatever. We're going to go through it nonetheless, and I'm not going to censor whatever is going to be talked about because they're not going to show us the images anyway. And before we do, if you guys are here, we've got over 1,000 people watching. If you haven't done so already, please do like the stream. It really does help with the YouTube algorithm gods. And that way we can have more people coming on in. It really, really, really does help the whole channel as a whole. Okay, let's continue on.
And is this one of the photographs that you reviewed in reaching your opinions and conclusions in this case?
Yes, it is.
Could you describe the injuries that you see in this photograph?
These injuries that you're looking at here on the arm are abrasions, which are friction injuries, basically. We classify them under the general category of blunt force injury, but these particular ones are abrasions. Abrasions being where the outer layer of the skin, the epidermis as it's called, has been scraped off. These are friction injuries, essentially.
And based on your review of the information discussed earlier, can you tell, as well as your review of these photographs, can you tell whether these injuries were sustained before or after death?
These injuries were sustained before death. We call them ante-mortem, A-N-T-E, mortem meaning before death. And that's based primarily on their color. And you have to take other things into consideration, but that's the basics of it. If these had been post-mortem, they would have a more yellowish, orange color, usually yellow.
Really good point for the defense there, because they want to rebut this rebuttal theory by the prosecution that they might be anticipating, which is maybe there was some sort of another animal that came by after John O'Keefe was laying there for a while and scratched him up and bit him and walked away. Like some kind of a scavenger is going to do that. A number of reasons why I don't think that would be the case, but pointing to these specific injuries themselves and saying this is ante-mortem, this is before he died that this happened. So it's not after he was laying out there for a while that something like this would have happened.
In your professional opinion, based on a reasonable degree of scientific certainty, are those injuries consistent with being struck by a vehicle while holding a drinking glass?
Objection.
Sustained.
May we approach, Your Honor?
Sure.
Okay, they're going to approach. In the meantime, Connie, thank you so much for becoming a YouTube member, supporting the channel, helping to keep the lights on. Thank you so much. Welcome to Bike Club. Hope you can join us for our next members only live stream at 10 a.m., usually on Fridays. And this week, probably going to be on Friday because we'll probably be ending this trial before that point based on what we have heard. So I hope you can join. And also you can enjoy other membership perks like early access to videos, things like that. So thank you so much for joining. And like I said, for helping to keep the lights on. It's wonderful. And if you guys want to be a supporter of the channel as well, you can join Bike Club either through YouTube memberships or become a supporter on Patreon as well. So it really does help. But otherwise,
I'm going to take this opportunity to ask you again to keep your voice up, please, sir.
I'm doing my best. My voice is not as strong as it used
There
to
we
be.
will.
Unmuted.
and also Dionysia Jaclo, member for 5 months. Thanks for being a member for so long. Is my last month of croissant baking. Yes, 6 months. You'll get an upgrade, I believe, to pizza.
We'll stop the AC for a while then. We'll stop the air conditioning for a while then. We want to make sure we hear you.
Okay.
And Kayla Park, thanks also for becoming a member. Welcome to Bike Club. Very happy to have you here as well. Thank you.
Dr. Sheridan, are these injuries consistent with a motor vehicle accident, in your opinion?
Sustained.
I would say in general, no. I mean,
So that objection was sustained. I think Ms. Little's going to put it to you in a different way.
I'm sorry.
If you could assume for purposes of this question that this individual was involved in a motor vehicle collision as a pedestrian, based on your review of his photographs, are those injuries consistent with having been struck by a vehicle?
Objection.
Sustained. Why don't you come back for a minute?
I think it's because she's leading a little bit too much. It's basically she's asking for a yes no question. It is quite leading. So that's probably why they keep doing it. She can ask to get the information. It's just she's being a little bit too direct on that. Also, Brent Rychak, also thank you for becoming a YouTube member. Welcome to Bike Club as well. You guys, thank you so much for all the support for the channel. Really, really appreciate it. Let's fast forward.
individual-
Oops, sorry, going back.
Dr. Sheridan, how many autopsies have you conducted on individuals who are involved in pedestrian vehicle motor collisions?
Involved in what pedestrian vehicle?
Yes.
Versus, yeah, well over 100.
What other experience do you have in terms of conducting autopsies with individuals who have been involved in motor vehicle collisions?
Well, I mean, if you take motor vehicle accidents in general, they'd be probably nearly a quarter of my total number of autopsies. So in other words, that'd be close to 3,000. Yeah, that's about right.
Based on your professional experience, what is your opinion regarding whether those injuries are consistent with the pedestrian being struck?
Objection.
I'm going to allow it.
You can answer
So that was the issue then. It wasn't that it was leading. Okay. So it was the fact that she needed to lay a proper foundation in order for him to give his expertise, which is fine. I mean, honestly, if I were Lally, I don't know if I would have objected to that, because now his answer looks even stronger. Like I really want to know what he says about his conclusion here, because of the fact that he's like, well, I've done close to 3,000 autopsies that were motor vehicle collisions. So, I've got a few to compare this to.
that, Doctor.
Hmm?
Can you answer that?
I can answer it, yes.
So go right ahead.
Okay. But the question was, to be precise, can you just rephrase it? I mean, I said yes, I can answer it, but I can't remember exactly how you phrased it.
Yes, based on your extensive training and experience, what is your opinion regarding whether those injuries are consistent with an individual being struck by a vehicle?
If you mean struck in that part of the body, on the arm, like
Yes.
directly, I would say no, it doesn't look like that at all. Mhm.
And can you explain that?
Well, if you're hit by a vehicle, whichever part of your body is hit, if it's a significant impact at all, you're going to get bruising, and we don't have any bruising here. We just have what I would call linear abrasions without any bruising. So that does not look to me at all remotely like an impact from a motor vehicle.
What would you expect to see if an individual's arm were struck by the rear of a motor vehicle?
Well, as I just said a second ago, primarily a lot of bruising, and that's what we don't see here. You might see, well, depending on the circumstances, you might see other things like a fracture or fractures, but you would at least expect bruising.
In your professional opinion, based on your many years of experience, have you conducted any autopsies involving individuals who were involved in any sort of animal attack?
Animal attacks in general, yes, quite a few actually. Well, when I say quite a few, it's not an enormously common event, but I've done probably at least a dozen or so involving deaths where an animal was involved one way or another.
Have you conducted any autopsies in which any individual was attacked by a dog?
Yes, I have a few.
Can you describe that for the jury?
Well, I'd have to just refresh my memory out of the blue here. But first of all, I had a number of cases, 3 or 4, I think, over the years involving children. It was primarily children who were killed by feral dogs. And the dogs attacked the kid and killed them. So I had that a few times. But then I've also had cases where an animal, or a dog particularly, was involved, but wasn't the actual cause of death, so to speak, but they were involved in something that was happening and left some traces of their activity in the form of bite marks or scratch marks.
In your professional opinion, are those injuries consistent with an animal attack?
Are they consistent with what?
an animal attack?
I would say they are, yes. I'm not 100% sure about this, but my initial reaction when I saw this photograph was that it was probably an animal mark, and most likely I would say a dog. Scrape marks with the paws, and possibly also a bite mark from the teeth as well. Possibly. I'm not 100% sure. I didn't get a chance to analyze it right there on the spot, so to speak. But my basic impression is that these are consistent with marks caused by, say, a dog using his paws or claws, if you want to put it that way, and possibly the teeth as well.
And if there's a pointer up there, would it be possible to direct the jury to the injuries that you're referring to on the screen? There should be a little laser pointer up there, I believe.
I don't know that I see one.
It's not there.
May I approach, Your Honor?
Sure.
Okay.
Using the laser pointer, could you indicate the injuries that you believe you just testified are consistent with scratch marks?
Actually, in a sense, they're all consistent with scratch marks in the sort of the more generic sense of their, whether it's the paws or the teeth, they're going across the skin rather than going straight into it. So they're all of these marks are generally consistent with, if you want to call them scratch marks. So I don't know if this will work on the screen, but you basically got what looks like there's one pair there, but possibly a third one in the middle. There are two very clear parallel marks there with another one fainter in the center. Then you have, going closer to the elbow, you've got another 2 or 3, whichever way you look at that. At the elbow itself, you have, that part of the elbow there is what I would think is the most likely candidate here for a bite mark, because it has something of the configuration of the outline of teeth. And then the ones on the forearm are a little bit less obvious, but they're still consistent in general with, I would say, claw marks or maybe from the teeth.
Dr. Sheridan, if you assume that the decedent was standing with his arm extended in this manner, and he was struck with the rear taillight of a 7,000-pound Lexus only on the arm, such that it spun him around and propelled him 30 feet, do you have an opinion as to whether or not these arm injuries are consistent with that scenario?
Objection.
All right, I'll see you inside. Go on.
Might be a little bit outside the scope of his expertise. Desiree Morgan, thanks so much for the super chat. Question: witnesses seem difficult when cross-examined. Do they have a vested interest in the side they testify for wins? Wouldn't most want a fair outcome? It depends on how the questioning is going. You know, if you are a professional and it feels like your professional expertise is being questioned, some people will not take too kindly to that. But the ones who are testifying in their professional capacity, who do this, like who are cool under cross-examination, like for example, Dr. Russell and Richard Green on Friday, both of them were cross-examined very well. They came across as very well, very calm, very chill. In fact, Richard Green seemed like he was having a good time on cross. So it depends. Sometimes people will get very personal about it on cross, and the best thing to do, in my opinion, is to not get personal. Keep calm. You have to understand what the purpose is of the cross-examination, that the attorneys are not taking it personally. They are just trying to elicit information that helps their client. But you know, if you are anyone other than an expert witness, especially, you really should be coming forward to testify in a way that is fact-oriented as opposed to party-oriented. Expert witnesses, little bit of a gray area there because they are hired by one side, but usually, I mean, that still should be coming from their reasoning, their professional experience, and all that kind of stuff, and not because they're being paid by one side. Also, Alexis Simone Trainer, welcome to Bike Club. So happy to have you here. Thank you so much for helping to support the channel and keeping the lights on. Kai S also became a YouTube member. Thank you so much. Welcome to Bike Club. Debbie Faison Cook gifted 1 Legalbytes membership. So kind and generous of you once again. Lisa B, you have been gifted a membership by Debbie Faison Cook. So welcome or welcome back to Bike Club. I think that's a welcome. I see some blueberries in the chat. Folks sometimes call them dingleberries, but they are in fact blueberries in case you are confused. Love seeing lots of blueberries in the chat because it means we've got some new people here to Bike Club as well. So thank you so much, guys, for helping to really support the channel. It really does help because these trials do take a lot. And even just the regular content as well. It does take a lot of time and a lot of work. So I really appreciate your support on all of that. Okay. Still got some sidebar here. So let's fast forward. Oh, uh-oh. Okay. So now we're going to have some discussion outside the presence of the jury, maybe. We will not be seeing this. Okay. Well, then the fan is just going to spinny spin. Okay. So just a basic recess here.
You are unmuted.
And also, Ray Woodward just gifted 1 Legalbytes membership. Thank you so much for gifting 1 more membership here. Thank you so much. So kind and generous of you. Coffee Star 62, you are also now a member of Bike Club. So welcome to Bike Club. Very happy to see you here. Okay. Jury is coming back.
So just keep your voice up for this question.
I'll try.
Assume the decedent was standing with his arm outstretched like this and was struck by the rear of an SUV only in his arm at 24 miles per hour. Are the injuries in Exhibit 19 consistent with that scenario?
No, I do not think so.
Can you describe that?
Well, as I think I've already mentioned before, one thing that's not there that should be there, given that idea, that scenario, is there should be bruising, at least bruising, if not perhaps even more than that, but bruising for sure. Secondly, the appearance of these injuries, their pattern, if you want to just call it that, the way they're distributed doesn't seem to fit the
Pattern
idea of the rear of a vehicle being the impacting object.
And at 24 miles per hour, would you expect to see fractures or breaks in the arm?
You could do. There'd be other factors involved as to it would depend on a lot of things, but it's possible, yeah.
I'd like to direct your attention to the injury that Mr. O'Keefe sustained to his head. Do you recall that injury?
To the head?
To the head.
Yes. Mm-hmm.
Could you describe that injury for the jury?
Well, there were a few minor injuries on the face, but the major injury, and indeed the main cause of death, was an impact to the back of the head, slightly to the right of the midline of the back of the head, and where there was a laceration. A laceration is another type of blunt force trauma, but this is a laceration is where the skin is actually opened up or it's split, so you get bleeding from a laceration. So there was a laceration, as I said, in the back of the scalp, in what's called the occipital area, and beneath that, when the skin was moved away as part of the autopsy, there was extensive bruising, hemorrhage in other words, in the scalp at that same point. There was a fracture that started at that point in the skull, but traveled all the way forward to the frontal areas of the skull. So you have the impact. The impact site is clear because, as I said, you got the laceration. That's where the impact was. So you have that the impact with the scalp hemorrhage there, and the skull fractures. Then the brain itself it had injuries, significant injuries. First of all, there was bleeding on the surface of the brain. And that's very common in situations like this. But in addition to that, there were extensive bruises, contusions is the real word actually, but they are essentially bruises of the brain substance itself. And that they were in several different parts of the brain, including the frontal areas, which are near the forehead, and also the temporal, which are towards the side, more or less. And then there was also hemorrhage deep inside the brain, in the ventricles, which are open areas in the center of the brain. All of these things were described in the neuropathology report, and you can see them in the photographs that were part of the neuropathology report as well as the autopsy. Because of, as a result of, I should say, the injury to the brain began to swell, and that's what it usually does after major trauma. And as a result of the swelling, you had what's called herniation, where the brain, if you want to think of it this way, the brain is trying to expand, but it can't because the skull is around it. So it begins to put pressure, pushing, especially downwards towards the top of the spinal cord. And eventually, as happened in this case, it's quite clear from the photographs, the brain herniated downwards, the brainstem particularly herniated downwards, and this would have been the final straw, so to speak. That's what would lead to respiratory failure and death.
Whoa.
So this was a fatal injury for certain.
That's very interesting. That's very interesting. The way that it's funny because what he just said totally tracks with what Dr. Stonebridge said about these various things that were going on in the brain, but he left out the complex medical terms. So you didn't have to use brain calories to try to figure out the definition of these words or try to understand the definition of these words. He used plain English in order to explain it, which is very, very useful to just get the concept. And you could almost picture the process of how it happened in the brain, and then eventually, moved downward towards the brainstem, and then how he said it would have led to respiratory failure. I don't remember Dr. Stonebridge saying that before. Maybe she didn't, maybe she did, but this is the first time that I have registered someone saying that herniation, that downward pressure on the brainstem was what caused respiratory failure. This is so interesting.
What impact would that type of injury have had on the individual after sustaining it?
Yeah, once this impact occurred, Mr. O'Keefe would have been unconscious. He would still be capable of breathing for a while until that brain swelling took over and pushed the brainstem down. But he would immediately from the point of impact, he would have been unconscious for sure.
He had been able to stand up, move, or walk?
No, he would have been unconscious completely.
Do you have any opinion regarding whether that injury is consistent with having been struck on the ground on dirt or grass?
I'm sorry, I didn't quite get the question.
I'll rephrase it. That was a poorly worded question. Is that injury consistent with striking dirt or grass?
Like, for example, falling onto grass?
Yes.
No, I don't think so. If there's a fall involved here, and there could be, it would be onto a hard surface. But the grass, and as I understand from all the material I reviewed, there was also some snow, and so that might even cushion the impact even a little bit more. But even without the snow, grass is basically too soft for somebody falling and hitting their head on it to get the injuries I've just described.
Interesting. So that is also going directly to where this could have happened, because that was not something that the medical examiner really either again, maybe I missed it because of the nature of the questions or something, but this is another reason why there's a distinct advantage for the defense, strictly because of their skill at asking questions. You ask clear questions that are easy to track, easy to follow along with. It's much easier to get the answer that is coming. So, regardless of who is right and who is wrong, if you don't even hear one side, you're less likely to be able to say that side is right. So this is just an example of, like, this feels like the first time that I'm hearing that kind of analysis as to, could this have happened on grass? Could this have happened on snow? Could this have happened on dirt? And he says, no, based on the extent of these injuries, it had to have been a hard surface. None of those things could have worked.
In addition to focusing on the injuries that were present, what significance do you place on the absence of injuries in conducting an autopsy?
What significance do I put on what?
In addition to focusing on the injuries that are present, what significance do you place on the absence of injuries when conducting an autopsy?
Well, as you put it there, it's a rather general question, but I mean, when you're doing an autopsy, you obviously want to see what is there and what's not, and everything can be relevant, including absent things. Now, in this particular case, there are a number of features of things that are absent that are important. I've already alluded to one, and that is on the arm. If that was an impact from a vehicle, I would expect bruising. But do you want me to continue?
Yes.
Yeah. But if Mr. O'Keefe was struck with, it depends obviously what part of the body is theoretically involved. But if a vehicle hits you, whether it's the back of the vehicle or the front, you're going to have, as long as it's not going extremely slowly, if it's going at any speed at all, any significant speed, it's going to cause at least bruising. And that in this particular case, one of the things that struck me was that there was a distinct absence of bruising on the torso. It was the chest, abdomen, hips, whatever. And also, in most cases that I've ever been involved in where a pedestrian was hit by a vehicle, there are injuries on the legs, including fractures, which are very common on the legs. So the absence of all of these things in this case, I think, is important.
Have you conducted autopsies involving individuals who were involved in fights or altercations?
Yes, many, many times.
Approximately how many?
Gosh, I have no idea, and it's but a lot. I mean, I've done. I said earlier that between over 12, maybe 13,000 total autopsies. Of those, I'm only giving you estimates here, but over 1,000 would have been homicides. Of those, probably maybe a fifth, or about 200, would have involved blunt force trauma instead of, for example, a firearm or something like that. And in those cases, and of course, so all of those, and other cases involving sharp force, homicides involving sharp force may have evidence of a struggle as well. So it's in the hundreds, yeah.
In your expert medical opinion, are Mr. O'Keefe's injuries consistent with a fight or a physical altercation?
In a general sense, they can be. They could be, yes. He had, I alluded to it just briefly before, but the head injury, the major head injury I've described, but he also had a laceration over his right eyelid. He had some scrape marks on his face. He also had some bruises on the back of his right hand, which that kind of injury on the hands can be what we call a defensive injury. In other words, an injury that occurs when you're protecting yourself and you're hit hit either with another fist or with a hard object, and you're protecting yourself. So I would say that some of these findings I've just mentioned are consistent with the possibility of a physical altercation. Yes.
Thank you. If I could have one moment.
Sure.
Oh, is this going to be a short and
No
sweet
further
direct?
questions.
Oh,
Mr. Wells?
short and sweet. I like it. Hopefully, Lally has gotten some rest over the weekend and is less
Morning, Doctor.
Good morning.
cranky as he was on Friday.
Injuries that you were just testifying about to with regard to Mr. O'Keefe, they were on his right knee, his right arm, as well as the back right side of his head. Is that correct?
Yes, I forgot to mention the knee, but yes, there were injuries in those places, yes.
And understandable, but this isn't an autopsy you performed yourself, correct?
I did not perform myself, no.
You never saw the body.
I called it, right? Did I call it or did I call it? Of course, that was going to be something he'd go through. You weren't actually there in person. You weren't in the room where it happened,
You're looking at photographs and reports, correct?
Yeah, I'm going by the photographs and the autopsy report, yes.
And contained within the materials that you reviewed, did you ever look at Mr. O'Keefe's medical records from the Good Samaritan?
Look at whose medical records, Mr. O'Keefe's?
Yes.
I looked at the medical records from Good Samaritan Hospital where he was pronounced dead, yes.
Okay, so you did look at those as well.
I did look at those, yeah. I thought I mentioned it earlier, maybe I forgot.
Now, with regard to what you reviewed of Mr. O'Keefe's injuries, you saw no injuries to his left arm, correct?
To his left arm? No, I don't think so, no.
No injuries to his left leg, correct?
No. Mm-hmm.
Injuries to his torso that you saw?
That's correct. Mm-hmm.
And no injuries to the back left side of his head, is that correct as well?
That's correct, yes. Mm-hmm.
Now, you indicated that you observed or reviewed the autopsy reports as well as autopsy photographs and the death certificate, correct?
I did, yes. Mm-hmm.
Now, do you agree with Dr. Scortibello's determination as to the cause of death being multiple blunt force type injuries in conjunction with hypothermia?
I do agree with her, yes. Mm-hmm.
And you reviewed also the neuropathology report by Dr. Stonebridge?
I did, yes. Mm-hmm.
And do you agree or concur with the findings of Dr. Stonebridge contained within that report?
Yes, there were photographs taken during the neuropathology examination, which were independent confirmation for me of the things described in the report. Yes.
Now, with regard to autopsies that you performed in the past, well, let me ask you this first. As far as the injuries that you observed in the photographs to Mr. O'Keefe's right arm, they were not the cause of Mr. O'Keefe's death, correct?
No, they were not. Mm-hmm.
With regard to autopsies that you performed in the past, in regard to there being some sort of animal involved, as you were testifying before, is it normal to see just injuries related to an animal attack on just one portion of one piece of body?
Why didn't he ask Dr. Marie Russell that? Probably because he knew the answer that he would have gotten from her would not have been favorable to the prosecution. She's the dog bite expert. This expert has testified about, or he has done autopsies involving dog bites, but not nearly as extensive in his history as Dr. Russell is on that. So, it's always interesting to note what questions were asked of one expert, but not of another. And this is one of those. Did he ask that? Hang on. Casey Morgan, he did ask. Did he really? Oh, I must have missed it. Oh, she said possible. Oh, okay. Well, fair enough. I take all of that back. I apologize. That must have been an attention lapse on my part. Thank you. And the question was, he said, we'll go back for a second so that you can hear the question again, just to say it was relating to an attack being on one part of the body.
Just injuries
Sorry.
related to testifying before past in regard to there being some sort of animal involved, as you were testifying before. Is it normal to see just injuries related to an animal attack on just one portion of one piece of body?
Yes, in a general way. I mean, as I mentioned, I think when I was answering the question about the cases I've done involving animals, I tried to divide them into two groups because there's an important difference. Some of those cases were cases where the animals were responsible for the death itself. As I said, a bunch of feral dogs in one case, particularly that I remember. Another was a case where it wasn't a whole bunch of them, but there were two dogs, large dogs, and they killed the victims, children. So those individuals had multiple injuries, including deep bite marks that were fatal, particularly in the neck area. But they also had, and I'm stretching my memory a bit because it's a while since I did these cases, but I do have a general recollection that in in those cases, I should say, in addition to the fatal injuries, there were also some non-fatal sort of things like paw marks. And I can't remember the distribution though on the body.
Can you remember as far as whether or not these injuries that you observed and not taking the child fatalities with the dog's maw, I'm presuming that those involved injuries to significant and extensive parts of the body. Is that correct?
Yeah, those are the ones where the animals caused the death, yes. Mm-hmm.
So in the other instances that you were talking about, do you recall even whether or not those injuries that you observed were ante-mortem or post-mortem?
I'm sorry, I couldn't hear the last part.
The other ones that you were talking about as far as the other animal attacks that you've seen,
yeah.
Do you recall whether or not the injuries that you observed in those instances were ante-mortem or post-mortem?
Oh, ante-mortem. Well, actually, in one of the cases that comes to mind, the marks appeared to be post-mortem, and that was this person was actually a homicide victim, and they were lying outdoors, and their own dog. This was according to police, though, who came on the scene. When they arrived, there was a dog that turned out to be the victim's own dog. Was pawing at the body, but the person was dead. But in another case that I can think of, the scratch marks from dog paws were ante-mortem, and they were confined to one place only. I'm trying to remember what part of the body. This case, I had to testify later on. In this case that I'm thinking of now, the paw marks were limited to just one location. I can't remember exactly where they were, though. Whether it was the leg or the arm, I can't remember.
And that was post-mortem injuries that you're talking about there, correct?
No, in the second case here, they were ante-mortem. So in other words, there's been post-mortem and ante-mortem. Yes.
The injuries that you observed on Mr. O'Keefe's arm were to the posterior part of his arm, correct?
Yes, basically the posterior.
No injuries that you observed on the anterior portion or the other side of the right arm, correct?
That's correct, yes.
No other injuries that you observed consistent with what you're talking about as far as an animal attack on any other part of Mr. O'Keefe's body, correct?
That's correct, yeah. Mm-hmm.
And from what you observed in the reports and the photographs, you can't say definitively what type of animal, correct?
That's correct, I can't.
And you can't say even if it was an animal or was a dog, what breed of dog that was. Is that correct?
No, but if I had to try, and if I said...
Not asking you to try, sorry. I'm just asking whether or not you can say whether or not that, what breed of dog it was.
No, I can't tell you what breed, no.
You can't say whether or not those injuries were inflicted inside a house or outside of a house. Is that correct?
What?
Yeah, I have no idea.
Who would say that?
You can't say when they occurred, correct?
Only that they were when he was still alive. Yeah, but other than that, no. And they are fresh looking. I mean, in this generally, so they look like they happened very shortly before death.
And when you say short time, you're talking about hours.
Minutes to hours, I would say.
Minutes to hours, but you can't.
I mean, I'm talking just based on the injuries themselves alone, leaving anything else out. You can't time injuries as exactly as you might think from CSI or one of these television programs, but they are generally fresh for sure. And but just looking at those on their own, I would have to say minutes to hours, yes.
Now, at some point, were you given or did you review any files from a lab at the University of California, Davis?
I'm not sure. In relation to what?
So are you aware that the State Police Lab in Massachusetts swabbed areas of the sleeve on the right arm of Mr. O'Keefe and sent samples from that in the areas of where the injuries occurred on his right arm, and then sent that to a lab at UC Davis? Are you aware of that?
I'm not sure that I remember that, no.
And so you're equally unaware then that when that was tested, there was no canine DNA found from any of those swabbings in the area where the injuries that you're describing as scratch marks or bite marks occurred?
I wasn't aware of that. I must have missed it.
Are you aware of any sort of bite history or a specific animal at 34 Fairview being involved in attacks on other dogs?
I'm sorry, I don't think I understood that question.
Were you aware that there was a dog that resided at 34 Fairview Road?
Am I aware that there was a dog there?
Yes.
I was informed there was, yes.
Were you also informed that that dog, months later, after January of 2022, was involved in an incident in which it attacked another dog? Humans intervened, and one of the humans was bit.
Again, I don't understand why Lally's going there. Why is he bringing that up to the jury again? Why is he showing like the connection potential between Chloe and this bite mark by like reminding the jury that Chloe has in fact physically aggressed against another animal, which could potentially mean maybe she would aggress against a human. That's like, just because Lally loves an open door. Lally very firmly believes that love is an open door. I wonder how many times he's watched Frozen. I don't know why he would want to go there. Why remind the jury about that? That doesn't help the prosecution here.
No, I didn't know that.
Were you aware that there were photographs of an actual bite mark from that actual dog months after January 29th? Were you shown any of that?
No, I don't believe I was.
Now, sir, did you write a report in relation to what you observed or anything in regard to your opinion or your testimony that you're testifying to here today?
I didn't write a report as such, but I signed a declaration early on in my involvement in this case.
And that was a declaration or an affidavit that you signed under the pains and penalties of perjury back on January 31st, 2023. Is that correct?
Sorry, what did you say about that?
When you're talking about a declaration, you're referring to an affidavit that you filed with the court under the pains and penalties of perjury in January of 2023.
I didn't think it was January, but however, I thought there was only one, so whatever you have.
Now, at any point in time were you made aware that there were microscopic pieces of the defendant's tail light as small as 1/16 of an inch by 1/16 of an inch that were found in Mr. O'Keefe's clothing?
Object.
Once again, why is he referring to it as microscopic? That is inaccurate. You don't need a microscope to see these pieces. Yes, they are small, but why are you calling them microscopic? It bothers me. Stop it.
I'll allow it.
That were found in Mr. O'Keefe's what?
Mr. O'Keefe's shirts.
I don't remember that specifically.
And that those pieces were then found to be consistent with the defendant's tail light.
Like I said, I don't remember that particular part.
Were you ever shown any material indicating that there was DNA from the defendant's taillight housing that was consistent with Mr. O'Keefe?
I asked about that myself, but I think the answer I got was no.
Now, were you ever told about a piece of human hair that was found on the right rear quarter panel near the area where there was a dent on the back right of the defendant's vehicle?
No, I don't remember that.
So then you weren't also told that that was then sent out for mitochondrial DNA testing and it was consistent with that of Mr. O'Keefe to a degree of 99.895%.
You're talking about a hair sample now.
Yes.
Yeah. No, I didn't have that.
Now, doctor, would you agree that in blunt impact injuries, the characteristics of a blunt object can then be transferred to the victim in the form of pattern abrasions that match the characteristics of that blunt object?
Yes.
Now, of the photographs, you reviewed photographs of the scene, photographs of the vehicle, is that correct?
Yes, I did.
You're aware that there were a number of different pieces of the defendant's taillight that were photographed as well. Did you ever see those?
I did, yes.
Do you recall seeing any piece of a clear plastic taillight piece that was recovered on January 29th, along with Mr. O'Keefe's sneaker that had dimpling on the outside of that clear piece of plastic?
I can't. I remember seeing the pictures of the glass fragments, but I don't remember any more specifics than that.
Do you know what a compression abrasion is?
What?
Compression abrasion.
Yeah, although it's not a term we use all the time, but however, yes.
And a compression abrasion can occur when there's direct pressure from a blunt object together with slight rubbing movements that produce skin and epidermal crushing. Is that correct?
Yeah, you have to have some lateral movement as well, though, to get an abrasion.
Now, when you were talking about prior autopsies that you've done involving pedestrian collisions, is it fair to say that most of those pedestrian collisions that you were doing autopsies on involved pedestrians being struck by the front of the vehicle?
Yeah, mostly the front.
So mostly it's a pedestrian sort of crossing the street or standing in the street who's then struck by the front of the vehicle, correct?
Yeah, I think they were all. I have actually done a couple of cases where children were hit by the back of a reversing vehicle. This was in the days before they had the rear videos on cars that they have now. But so those cases were impacts against the back of the vehicle. But most pedestrian cases, yeah, are, as you say, the front of the vehicle hitting the person.
Yeah, just briefly on that, as far as the defendant's vehicle itself, are you aware that there were rear backup cameras and a 360-degree overhead view from the back of her vehicle?
I remember reading that, yes.
Now, understanding what you're talking about as far as a rear vehicle pedestrian collision, is that typically sort of the wear on the vehicle? Let me ask you this first. When you are doing an autopsy in relation to a pedestrian collision, much of the information that you're gaining about that is what you receive from the investigating agency, whether it's the police or something like that, correct?
It varies a lot from one case to another. Sometimes you get or virtually no information about the accident, because some of these cases I've done, some of them were witnessed, some weren't. Let's put it that way. Yeah. So when they weren't witnessed, and when the person was just found later or sometime afterwards, you wouldn't have necessarily any. The vehicle would typically not be there. These would be hit and run type situations. And so in those cases, you wouldn't have all that kind of information. So it varies. It varies.
And understanding that it varies, but primarily what I'm saying is whatever information as far as a body comes in and you're going to conduct an autopsy, there would be some information from law enforcement or witness statements or something as to what type of death this is, as far as gunshot wound, stabbing, pedestrian collision, something like that.
Yeah, absolutely. But like I said, in those unwitnessed cases of pedestrians, I might be given the information that it's probably a pedestrian fatality from a car.
I don't know where Lally is going with this exactly, because if what he's saying is it's very important to get this information from Trooper Proctor, I don't know that actually helps the prosecution here.
And when it comes to pedestrian collisions, and most of which that you've seen are, again, from the front of the vehicle striking a pedestrian on the roadway, is that correct?
Yeah.
And are you familiar with what role sort of the center of mass of that person versus the center of mass of where they're struck plays in reference to their injuries?
Yeah, it could be that can have a big effect on how the body reacts to the impact.
So most of the time when you're talking about sort of lower extremity injuries or pelvic fractures or things like that, that's in a frontal collision with the pedestrian, correct?
Most of them were, yeah. I mean, the ones that involved being backed over, and they were children. I can't remember the exact distribution of their injuries, except the vehicle went right over them. I do remember that. But anyway, the answer to your question, maybe I'm wandering in my mind, so can you ask me again?
I think you've answered it. So my next question, sir, is when it comes to the rear end collisions, primarily being children, you would agree with me that they have a lower center of mass than a 6'1", 200 something.
Oh, yeah. Yes.
And so as far as them being run over, they're going to get struck. They're probably going to fall to the ground, and then the vehicle is going to go over, correct?
That's right, yeah.
And so how...
I mean, is he trying to say that adults have the ability to fly? Like, what is he saying as to, I understand, yes, there is a difference in terms of the center of mass that will make a difference in how those injuries will appear on the kid. But you still have a 7,000-pound vehicle that's hitting someone. Like whether someone is, 50 pounds or 150 pounds or 250 pounds, it will make a difference, but it won't make that much of a difference. It's not like an adult is going to be able to stop a car as if he is the Hulk or Thor or something along those lines.
How many autopsies have you conducted in regard to pedestrian collisions where they've been sideswiped by the back of a vehicle?
I can't remember.
Can you remember any?
Not off the top of my head, no.
And so if someone is struck by the right rear portion of a vehicle and then projected away from the vehicle based on speed, based on force, based on whatever, would you then expect to see those same type of pelvic fractures or lower extremity injuries?
That's a very vague question.
Well, it depends on the exact position of the victim at the moment of impact. And of course, it could be a lot of different things. They could be, the victim could be facing the vehicle, they could be sideways on, they could have their back. But you're going to see bruising somewhere in that area, in one of those areas, either on the back, the side, whatever, or the front. I would expect to see bruising, significant bruising.
And now also that question that he just asked about, is it possible for someone to be sideswiped by a car, have a pedestrian collision, and then this and that happens and this and that happens. On redirect, Elizabeth Little can also come in and correct, not correct, but she can contextualize by saying, in this particular case, do you believe that they're based on the positioning and the what you saw in the car and what you saw on the injuries on John O'Keefe, does this look to you like some sort of a sideswipe situation based on where all of this damage is, where he could have been sideswiped by this vehicle here? Then he'll be able to affirmatively state probably not.
But earlier on direct, it's sort of dependent or variable depending on how the victim pedestrian interacted with the vehicle. Isn't that correct?
Yes, but I'd expect bruising for sure. I mean, whether you get fractures and so forth will depend on, or for that matter, internal injuries, depends on a variety of factors. But you're going to get bruising for sure.
Now, you did see bruising on Mr. O'Keefe's right hand, correct?
Yes, a small bruising. It looks like two.
Well, you saw this teeny tiny little bruise right here, right? You saw that? You saw this teeny tiny little fleck of a bruise on the side of his right knee? That's a bruise. That's not the kind of a bruise that he's talking about. It's like Crocodile Dundee. That's not a knife. That's a knife. That's not a bruise. That's a bruise.
2, possibly 3, almost confluent or close together bruises.
Were you aware from the materials that you reviewed that Mr. O'Keefe was last seen sort of on video exiting from a bar at about 12:11 a.m. holding a cocktail glass in his right hand?
I vaguely remember that, yes.
Were you also aware that there were pieces of the cocktail glass with Mr. O'Keefe's DNA on it that were found right in the general vicinity of where his body was found?
That I don't remember.
You talked about a couple of different patterns to the injuries that you observed on Mr. O'Keefe's right arm. So my question for you, doctor, is it your testimony that those, what you're terming as animal bites or scratches, were they caused at one time or multiple times, or how many times are we talking about?
You mean on different occasions?
As far as in, there are multiple abrasions as you've termed them, and you're attributing them to an animal attack, correct?
I think that's the most likely explanation for these, yes.
And so my question is, sir, is that from the dog or the animal or whatever it is scratching Mr. O'Keefe once, more than once, based on what you observed in
Well, it's more than once. When I had the laser pointer here, I think I pointed to roughly, 1, 2, 3, 4 different areas. So it looks like, and you have, maybe there's an additional, the ones on the lower forearm, I should say, are harder to figure out. But it looks like 4, maybe 5 separate.
4 or 5 separate sort of swipes, whether they be with mouth or claws or whatever.
Yeah, that's correct.
And so is it your testimony that it's not possible that Mr. O'Keefe received that from some part of the motor vehicle, or a glass shattering, or shattering from a taillight, or any sort of metal pieces underneath contained within that taillight housing as far as his interaction with the vehicle?
Such a long question.
They don't look remotely like that to me.
So it's not possible, is that correct?
In my opinion, no.
You were asked about some questions with regard to the surface of the ground as far as dirt or grass. Are you familiar with what the weather was like at the time that Mr. O'Keefe, you testified earlier, you were familiar that he was found in the snow, correct?
Yeah.
Bingo. Anybody? I mean, that's the free space. Snow is the free space on the bingo card, right? But like, I mean, really, we should have had a countdown for how long it would take for snow to come up in this cross-examination. You do know it was snowing, right? Oh my God, you guys. Lally loves an open door. It's everything is snowing. Yo, he's Elsa. Like, he's got to be Elsa. Like, that's the only explanation that I can give for Lally's obsession with the snow. Like, what other connections have there been that I may have missed at this point? I'm gonna have to go back and think about it. Like, maybe he's just obsessed with the movie Frozen. I don't know. I'm gonna put this to the back of my mind and see if anything else sticks, like snow.
Yes.
Do you know what the temperature was like as far as, my question is this, sir. Understanding cushioning of grass and dirt under normal conditions, but if the ground is physically frozen based on the temperature of outside, would that impact as far as your understanding of the injuries to the back of Mr. O'Keefe's head?
No, I mean, even if there was a small coating of ice, I wouldn't change my opinion based on that, no.
I'm not talking about ice, sir. What I'm talking about is the ground itself being physically frozen based on the temperatures outside.
Objection.
Sustained. Did you see? Even the captions agree. Frozen was capitalized by the captions. I think this is a whole new theory that we've got going on. Background theory to this case. Lally's obsessed with the movie Frozen.
Now, as far as the hard surface that you're talking about, would that include asphalt pavement?
Yes, it could.
And as far as those injuries, the speed, if Mr. O'Keefe was struck by a vehicle and was projected away from that vehicle and then struck his head on the ground, would that be sufficient force, in your opinion, to cause the skull fracture on the back of his head?
If all that happened, yes, and onto asphalt or something like asphalt, yes, if that's indeed what happened. But like for other reasons, I don't think that is what happened.
Now, you testified, or you asked some questions about your opinion and as to or consistency with the physical altercation. Is that right?
Yes.
And the sort of swelling in Mr. O'Keefe's eyes, as far as the ecchymosis is concerned, that was related to the brain injury. Is that your understanding?
Well, the skull injury rather than the brain.
Skull
Yeah.
injury, which
Yeah.
leads to the bleeding of the brain, which then leads to the swelling of the eye. correct?
Well, yeah, but no, I mean, let's be clear about this. I mentioned the fractures earlier on that came from the back and went all the way towards the front of the skull, including what are called the orbital plates, which are the bones, the parts of the frontal bone that are right over the eye sockets. And the bone there is very delicate. It's the thinnest part of the skull. Anyway, the photographs and the autopsy report clearly show that the fracture involved that on each side, both orbital plates, in other words. And it's that fracture, it's not the brain itself, but it's that fracture which leads to the bleeding that causes the black eyes, if you want to call them that way.
And as far as what your review of the medical records, your review of the autopsy report, photographs, things like that, you observed nothing as far as fractures to Mr. O'Keefe's eye sockets, correct?
Well, the orbital plates, in a sense, are part of the eye sockets, but they're the roof.
He's like, no.
Were there any fractures to the orbital bones?
There were no fractures that appeared to be coming from the front, no.
As far as the sclera, was there any broken blood vessels or anything that you observed in either the notes or the reports or the photographs or anything else that you saw?
Broken blood vessels were?
The sclera.
Huh?
Sclera of the eyes? You know what that is?
Oh, the eye, yeah, I'm sorry, I couldn't hear, just couldn't hear what you said, yeah. No, there just, as far as I know, the eyes were clear, yeah.
So this part actually is a little bit helpful to the prosecution here because they're trying to limit the likelihood that the jury is going to be convinced by this idea that John O'Keefe was punched in the face, like punched in the eyes, and then fell backwards, right? So the point that he said that this witness agreed with, which was no fractures appear to be coming from the front. It looks like it originated in the back and then reached forward towards the area of the eyes, the occipital bone. Anyway, the bones up in the front around the eyes, rather than seeing a fracture start around here and move backwards. So that's at least, I mean, maybe Elizabeth Little will come on redirect and say like, okay, but someone could still be punched in the face and not have a fracture to their face, right? Is that possible? I'm wondering if she's going to come back and redirect on that. Maybe not. Maybe it's not a big enough deal for them. But that's just something that is interesting.
The eyes themselves were clear. Yeah.
Now, as far as the minor injuries that you were talking about, as far as the eyelid or the nose, as far as those minor lacerations you were talking about, there was no bruising around any of those lacerations, correct?
The eyelid laceration, don't forget, is in the same area where we have the other injury, and it's a little bit hard to figure out whether how much hemorrhage, how much of that black eye could even be related to the laceration, because you've got two possible explanations for the black eyes. One is the skull fracture I've already mentioned, but that doesn't rule out his getting an impact as well on the front, but there's no way you can separate them.
Well, okay, there you go. So now Elizabeth Little doesn't even need to come up on redirect about that, right? Because he's like, you can still have a black eye happen without a fracture to the skull. So he could have been punched. That's one reasonable explanation for those black eyes. One is from the skull fracture causing that. Another one is from being punched. So this scenario does lead to the possibility of both of those happening. This is a great witness.
As far as around those minor lacerations that you're talking about, you didn't observe or see any record of any bruising or any broken bones in those areas whatsoever?
No, the main one that I was relating to when I spoke about the altercation question was the laceration on the eyelid. That's not related to the head injury that we've been discussing. So it's a separate injury, and it's from some kind of blow to the front.
Oh.
Minor lacerations that you observe, would they be consistent with being struck by broken pieces of glass or broken sharp pieces of plastic?
If it was indeed a laceration, as it was described, then no, because lacerations by definition, although this is a term that's often misused, by the way, even by some doctors, but a laceration by definition is an open wound caused by blunt force, not sharp.
And that's consistent with what the ME said as well. She said a laceration is not the same thing as an incision by some kind of a sharp object, like a knife or a shard of glass or something like that. So this is perfectly consistent with what the ME said in terms of definition. He's like, look, I'm going off of the definition that the medical examiner used for this part right here. Blunt force opening of the skin is a laceration. And he's just giving this witness so many opportunities to clarify why these various injuries actually support the defense's proposition here, which is that there were multiple blows, some of them to the front even, and ultimately the one in the back is what killed him.
So blunt force, as far as what I'm asking is it possible that the lacerations to his face were caused by a blunt object that then shattered and caused the lacerations to his face?
I find that hard to imagine. I find that very hard to even conceive of.
So it's not conceivable? Is that what you're saying?
To me, no.
Inconceivable.
And from your review of whatever reports and medical records and everything else, what, if anything, did you see, or did you see anything that had
He's even getting some what if anythings in on cross. It's great.
to do with an animal being present on scene, or an animal being near Mr. O'Keefe's body, or Mr. O'Keefe being inside the house?
I don't know. I mean, but I heard there was an animal somewhere around the place, a dog. I think you mentioned the dog earlier.
So somewhere around the place, but no evidence that you've seen that animal interacted with Mr. O'Keefe in any way.
No, I wasn't there, obviously, and all I can say is what I've already said, but I don't know any more than that.
I know you weren't there. What I'm saying is, from the material that you reviewed, was there any indication or any evidence of that animal ever being near, close to, or interacting in any way with Mr. O'Keefe?
Not that I'm aware of, no.
I have nothing further.
Little? Thank you.
Okay, redirect.
Your Honor, if I may approach.
Sure.
Thank you.
So, Ms. Mullally?
Yeah, she's great with all of these medical witnesses.
Dr. Sheridan, if you could just take a look at that photograph. Do you recognize that?
Yes, I saw this photograph before. Yeah.
Could you describe that photograph to the jury?
It shows the decedent's knees taken from the right side, but you can see both knees. Mm-hmm.
Your Honor, permission to mark this and then publish it.
Mark it. Put it into evidence. Okay, is there any objection, Mr. Lally?
No, Your Honor.
Wait a minute. How is this the first time that the photos of his knee bruise has been admitted into evidence? Maybe it's just because of, I was lulled into complacency with the other medical examiners, but how did they not admit photos into evidence of his knee with the medical examiner before, with Dr. Scornibello, when they're like, well, but maybe he was kind of sort of struck by his knee on the car. So therefore, there's a bruise on his knee. So they're referring to this bruise. The prosecution keeps referring to this bruise as if like, well, so there's a bruise. Therefore, there is an injury down below, in the lower extremities that could be consistent with getting struck by a motor vehicle. Now the defense is like, all right, let's take a look at this bruise, shall we? Let's look at this bruise. Let's all look at it together and determine just how likely it is that that is a bruise that came from this car. So the jury is now going to see more information from the defense than from the prosecution once again. And how is it going to look? We'll find out. I don't know if we'll see it, but they will.
That would be exhibit 657.
I also wonder if there's going to be any indication as to how old that bruise is at the time of his death. That's also going to be a curious question.
Yes, you may publish it, Ms. Little.
Thank you, Your Honor. Dr. Sheridan, you were asked on cross-examination about an injury to Mr. O'Keefe's knee. Do you recall that testimony?
What?
Yes. Mhm.
That's the bruise? That's the bruise that he says that the car could have caused from the bumper? I'm sorry. No, that's ridiculous. So it really is this teeny tiny little thing. Like, what? Oh, come on. Like this trial is like I feel like there's no more room for surprises in this trial, right? We're almost done. Like this is I'm pretty sure this is the last day of testimony. And like the defense pulls like this out of their hat, like, oh, by the way, prosecution didn't show you this. Here you go. This is the ladies and gentlemen, the all important bruise on the right knee that was caused by the SUV when he got struck by it at 24 miles per hour. A 7,000-pound SUV did this. I'm sorry. Come on.
Injury that you were testifying about earlier?
Yes, this has been mentioned before. It's an abrasion.
And that's the extent of the injury to Mr. O'Keefe's knee, correct?
Yeah, that's it. Yeah, in that area. Yeah.
Thank you. No further questions.
All right. All right, Dr. Sheridan, you are all set, sir.
Very well.
And
Thank you,
that's
Your Honor.
it.
Thank you, Your Honor.
Oh my goodness. Okay, next witness. Who is next? It's one of the ARCCA guys. One of the ARCCA bros, is someone in the chat I saw called them. I like that. I want to call them the ARCCA bros now. Or oh yeah, Crash Daddy, as Brandy Churchwell informed us. Oh, that's so funny. Crash Daddies.
Step right up and just watch your step for me.
All right, here he is, guys. Daniel Wolfe, PhD.
You solemnly swear the evidence given to the court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolfe, last name spelled W-O-L-F-E.
Dr. Wolfe, what do you do for a living?
I am the Director of Accident Reconstruction at a company known as ARCCA, A-R-C-C-A.
And what is...
Also, okay, yeah, sorry. There's a question in here to get caught up on questions. Yes, I thank you so much for the reminder, Dan Luch. Okay, let's go through these pretty quick because we want to get caught up, make sure that there's nothing referencing a past expert and, you know, when we're already thinking about the next one. Okay, Megan Rose, Legalbytes, how are you feeling today? I'm feeling very well. Thank you very much. Everything is, I've had doctors checkups and other stuff like that. So everything is going well so far, knock on wood. MKJ, question, who initiated this trial? Was it the O'Keefe family? I don't think so. I think that this was, you know, she was arrested like not long after all of this happened initially. So I think that this started pretty quick from whatever investigation started here. Also, let me see here. Have there been a couple super chats? Yes, there have been. Let me get these real quick. Cy Virus, thanks for the super chat. Question, what is that lady next to the witness holding over her mouth? It is it's a device for her to talk into a machine so that they can take the transcript down of the proceedings. She is the court reporter. A lot of times, you know, typically you'll see somebody typing to get the transcript down, but this is just another kind of a device. She's talking right into it. So, you know, poor woman, she has had to say more than 2,000 what if any's herself. Pour one out for the court reporter on this one. May Z Dancing. Thanks for the super chat. OMG, she'd have to She'd have had to hit him hard and hit the brakes to transfer the energy for him to fly. Otherwise, she'd go over or through him. She'd smash him. I would think so too. And I think that we're probably going to hear some physics on that will confirm what you said here from the Crash Daddy Bros. Tom McCabe, thanks so much for the super chat. Trooper Paul is somewhere hiding under his desk. Could be. He might be pouring one out for himself after today. We'll see. A-OK question. Do you think defense will rest today? I think so. This is so far pretty fast. So I think that's likely. Tish, Legalbytes, how likely do you think it is that we will hear closing statements today? What limitations / restrictions are put on the lawyers during closing statements? So just a little nitpicky thing. Opening statements, closing arguments, because you can make a statement at the very beginning as to what will happen, but you're not allowed to argue. But closing arguments, you are allowed to argue, and you should argue. This is all about the pulling in all of the evidence that the jury has seen over the days or weeks or hours, however long the trial is, and putting everything together in a perfect summation to argue your case to the jury. And the whole point is to basically arm your supporters on the jury, because there may be people who are pro-defense, there may be people who are pro-prosecution, or somewhere in the middle. But what you are doing is to arm your best people who can continue to advocate for your side in the jury deliberation room. And so that is what's going to be happening. And so whoever can arm those people the best is going to, well, not necessarily that automatically will win, but typically that's what happens, that along with the best evidence in the case. So likely today, possible. I don't know. I don't know that we're quite that close to being done. I would not be surprised if we hear from Dr. Rentschler in the afternoon, and then maybe it's just an earlier day closing for the day. Or if it's going to be, I don't know, maybe they get to it sooner. I don't know. It's possible. My expectation, though, is probably closing arguments tomorrow morning. What limitations and restrictions are put on the lawyers during closing statements? Well, you can't argue from evidence that the jury didn't see. So that's the main argument. And there are some things, like you can't be, too pejorative about the other side and things like that. There's just certain conduct that you don't want to be engaging in. But otherwise, like you're able to use the full passion of your voice, like full argument from the evidence. The opening statement is much more restrained in comparison to the closing arguments. And I fully expect fireworks from Alan Jackson in closing, because I expect he's going to be the one to do it. David Yannetti did the openings. It makes sense for Alan Jackson to do the closings. And plus he's the one who's got, they both have a lot of fire, but he's got even more spice than Yannetti, I think. Vicky with an I question, do you think it looks weird to the jury that all these experts are from California? Maybe, I don't know, but we've also heard a number of different accents as well. Otherwise. So, I don't know. I don't think that that's likely to make that much of a difference. It can, but in this case, I don't know. I don't see it. Solo Cup evidence, Legalbytes. I just bought 2 shirts. Looking forward to getting them. Awesome. Let me know how they turn out. I hope that they are what you're looking for. Thank you so much for doing that. And if anybody else wants to buy more merch, there are links in the description below, so you can buy stuff. We've got some memes from the trial. We've got some other stuff that's just Legalbytes merch, generic Legalbytes merch. But generally, for every trial, I like to add more that's specific to the trial that we've watched together. Mary Eller question: do you think that the jury will think differently of the experts who are retired? It's possible, because, maybe they're a little bit more removed from the practice. Maybe things have changed in the practice since then. But on the other hand, these obviously are very seasoned people as well, who have a lot of experience under their belt. And they also are not looking to add to their career necessarily. So there's also that side of it too. Like they don't need to testify. They don't have anything, that they absolutely need from testifying. It could also just look like, well, I just have a particular interest in giving my expertise in this context, and that's why I'm here. Cherry Ho, Legalbytes question: is it possible that L knows for sure the case would definitely fail terribly, yet the Corps decided they would like everybody to join their tea party and force him to put on the case? It could be. It's more like the DA's office would have been very insistent on it. But even as an individual attorney, his bar license is what's on the line for his case. So you also have an independent ability to make certain decisions for your own career as well, whether or not it's worth it to be pursuing a case that shouldn't be pursued. So, there is some autonomy there. Maybe that means a difficult decision for him to be or not be at the DA's office moving forward, or what? I don't know. Sue B question: do you think a lot of experts are retired because it's hard to get someone working? Unfortunately, as it gets good, I have a doctor's appointment. I don't know. I don't know why. I mean, I have a feeling that maybe because of the fact that these two also came from LA County Coroner's Office, I think that there probably is just a particular connection through Alan Jackson's network. I think that maybe they've testified in cases for him in the past. Well, not Dr. Murray Russell, but maybe Dr. Sheridan has testified before for a case with Alan Jackson and was like, "Hey, yeah, I'll come off the bench for this one." Possible. Desiree Morgan question: many witnesses, particularly for defense, seem difficult when cross-examined. Do they have a vested interest that their side wins? I would think they would still ultimately want a just outcome. I would think so too. Oh, I think you asked a super chat with that too later. Yeah, we answered this one. So sorry about the delay on answering that one, but we got it with your super chat. Dan Luich, 13,000. That's a lot of Avada cadavers. That is a lot of Avada cadavers. Let's see. Oh, we got that trigger warning there. The Lucian question: can you explain the difference between not guilty and truly innocent? Can a jury find a defendant truly innocent or not guilty? The best that the jury can do is not guilty, because in order to find someone truly innocent, it's like you have to, like, there's no legal question that allows for a jury to find someone innocent. And if there were, that would have to be something along the lines of, like, where there is an affirmative burden on the defense to prove that she is innocent. But here, because the burden is only on the state, there's no way for the burden being on the state for them to result in an innocent conclusion. I hope that makes sense. Florida Dad, thanks so much for the super chat. I've had worse bruising being struck by a 6-year-old traveling 10 miles per hour. Right. That last bruise was just chef's kiss for the defense. It really was. The Lucian question: can you explain oh, sorry, I already got that one. Haley Mouse, where are the furry helpers, Alita? Well, Indy has been on the floor around here, just laying around. And then the cats came by briefly when I first sat down, and then they went off. I think everybody's maybe napping at the moment elsewhere, but I'm sure they'll show up at some point during the stream. Travis James question: how long will Lally have to get his rebuttal witness? You mean how long will Lally have to get his rebuttal witness, first of all? But for Dr. Murray Russell's rebuttal, it was a week that he had. Now there was also this motion that was filed on Friday, I suppose, about another accident reconstruction expert. I don't know what's going to happen with that. I don't know if there have been any other conversations between the parties about that. So that one I don't know so much about. So I think that the rebuttal witness would be, I mean, maybe the rebuttal witnesses would have to, I totally forgot about them before closing arguments. So today, maybe we would see some rebuttal witnesses today. I don't know. We'll find out. L. Borate, Legalbytes, why don't they record trials, remove sustained things, and let the jury watch a trial? Because there are all kinds of problems. Look, I've talked with people when they've been in the courtroom as opposed to watching on a live stream. And, sometimes when they've participated in live streams and then been in the courtroom, It's a very different experience. There will be a certain vibe in the air. You feel an energy in the air sometimes with testimony. You can hear, the ceiling fan. You can hear creaking of chairs and things like that can also sort of impact the overall experience for what people are taking in during testimony in terms of, does it feel compelling? Does it not feel compelling? There are all kinds of things that you can observe from inside the courtroom or take in from inside the courtroom that doesn't quite reach through a live stream. We are so fortunate to be able to watch so many trials televised like this. However, it still doesn't beat the experience of being in the courtroom. So I think that to have a jury not be able to watch it live and showing them just a recording, it's an entirely different experience. And yes, to put a finer point on it, also, Jillian Spinoto, it allows them to put extra focus on things giving undue weight, because also then the focus is being drawn by the person who is operating the camera, right? We are seeing what the camera shows us, but there's a lot of things happening in that courtroom all at the same time. What the witness is doing, what the attorneys are doing, what the defendant is doing, what the judge is doing, all kinds of different things are happening all at once. And so, it can potentially improperly focus the jury on specific things if they are given a court feed instead of watching in person. Dayan Lujic, I can't grasp why they won't allow that question when I feel 30 days in the jury is also aware that the defense wants to ask the witness, especially after 3 objections opinion. So ultimately, I guess what it was a foundational issue from what it sounds like, based on the way that she had to break down her questions into going into his expertise, how he would know certain information, things like that. So that was it, as opposed to leading. Natalina Rose question, how do you think this guy is coming across? I'm so distracted by his breathing that I'm not able to really take in what he's saying. The breathing could be distracting. For me, it took a little bit of time to get used to, but after a while, his testimony was so compelling that it became less and less of an issue for me. Brent Rychak, thanks so much for the question. Should Karen win? Is she responsible for paying her legal fees? Yes, she is. That is one of the harder things of being a criminal defendant, that even if you are found not guilty, you still got to pay those hefty legal fees. James Games Classics, as a new Patreon member, how do I get a Blueberry, or is that only for YouTube subs? So that is for YouTube members. However, Patreon supporters get for all of the uploads, there is at the end a thank you to Patreon supporters. So there is a membership card which will be updated very, very shortly with all the new members as well, so that you can see your name in credits. So that's the benefit that the Patreon supporters get, as opposed to the member emojis in the chat. A-OK, Legalbytes, how long do final arguments take? 1 hour, hours, half a day. It depends on the case. There have been some cases where it's been days and days and days and days and days of closing arguments. However, I prefer a much shorter closing argument, because it's much easier to take in the information that's being expressed, get the argument, and be able to just take in all of the information into a single sort of idea of like what you should be doing with the case. So hopefully it will be relatively short, hour, 2 hours maybe, but maybe 2, but shorter is what I would hope for. Kristen C. Alita, does the jury have access to the expert CVs when they deliberate? Nope, that's typically not admitted into evidence. Letitia made this question. Didn't Lally ask specifically about frozen ground? Yes, he did. And the witness said, no, that's not going to change my opinion, even if it's a bit frozen. Pesky Pirouette, is the Lally tally still going, or did it exhaust itself after 2000? It is still going. I have to do those calculations for day 29 still. I completely forgot to do that over the weekend with all the stuff happening on my end over here. But I will definitely have that updated, and then tomorrow I'll make sure to have the Lally tally out on time as usual. Carolyn Small, thank you so much for becoming a YouTube member, supporting the channel, helping to keep the lights on. Welcome to Bite Club. So happy to have you here. Thank you. Let's see here. Stephen Dolgos. Legalbytes, if KR is found not guilty and CW comes up with a new suspect / theory, are they permitted to use any of the information KR's defense used in this trial and or reuse their own in a new way? Yes, absolutely. Absolutely. Daniel Evans, question, why is he asking that about the backup cam? His people fried the system. I think that his point was to say when Karen Reed was backing up her car, she would have had a full view of what was going on. So that sort of decreases the likelihood of her being able to use like plausible deniability of like, I didn't see anyone back there, to say she knew that someone was back there when she did it. That's what they would probably argue. Life on Makeup, Legalbytes, I love your video with the 13th juror. Great collab. Thank you so much. If you guys missed it, yesterday I had a 2-hour-long live stream with Brandy Churchwell from the 13th juror. We were talking about the prosecution's case in chief. It was a really, really great conversation. First time I had her on, but she was awesome. And I it was a great conversation. Would love to have her back. So hopefully we'll be doing some more collabs in the future for sure. Daniel Evans. Question. Well, then why isn't he letting this case go? Let it go. No, let it go. No prosecution anymore. I know. So his personality, Legalbytes, has anyone seen Elsa and Lally in the same room? I don't think so. This is a new theory. Sarah Beth, hey, Legalbytes, did you see what happened with Turtle Boy last night? I saw something about it. I haven't had a chance to really look into it, however, but I know that there's a lot of heated tensions going on right now, which is very unfortunate. Baz 80s, question, have they argued or started to argue jury instructions yet? Not that I am aware of. So maybe that would be a delay before closing arguments as well. Dan Luch, Legalbytes, how long are closing arguments in general? Like I said before, can be a massive range from 30 minutes to days long sometimes. Justin Perry, Legalbytes, I previously mentioned Trooper Proctor was main detective with Sandra Birchmore case, and I'm wrong. He was involved in it, but not main. Sorry about that. Many of the people in this case were, did I miss the second part of it? I am so sorry. I saved where I was tagged. So no worries, but thank you for the correction. I appreciate that. Ice Cool 2020, Legalbytes, I remember you mentioned that should Karen be found innocent, she won't be compensated for any attorney fees in this case. Is there any way she can sue the state for wrongful prosecution? Possibly. And there's also a question here from A Trucker's Tale. Same thing. Can she sue for malicious prosecution? Possibly. But in order to win on that, it's really tough to win. Very tough to win. Stable Marquette, question, will prosecution be able to drag out the rebuttal like they did their case in chief? Hopefully not. Rebuttals are supposed to be short and sweet, because it's very, very limited, only responding to things that came up on cross-examination. You can't like have a whole new redirect or sorry, a whole new case in chief, right? It has to be only the things that they really need in order to respond to the witnesses that were put up on in the defense's case in chief. Okay. That's all for the questions. Thank you so much, everybody, for those. And we will now get on to the next witness.
Is ARCCA exactly?
So ARCCA is a forensic engineering consulting firm. We have a variety of disciplines that include human factors, biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCCA, correct?
That is correct.
What sort of contracts does ARCCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government, as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
Is there other clientele that seeks out ARCCA for accident reconstruction or biomechanics or human factors issues?
In terms of beyond the parties that I just listed?
You mentioned the U.S. Department of Defense.
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy-absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCCA known both nationally and internationally? Is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of accident reconstruction at ARCCA, do you specialize in both accident reconstruction and the human factors that are associated with such reconstruction where necessary?
Yes.
Can you give me a synopsis of the professional discipline of what is accident reconstruction?
I think a simple definition in my mind would be the application of physics, engineering, science, and mathematics to collision events. I always like to think of it as if you open up a puzzle box and you dump the pieces out, and you've got a bunch of pieces, and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And
Great
what
metaphor.
is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night, there's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how do drivers respond based upon the hazard they're presented with. So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolfe, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCCA?
A little over 7 years now.
What education, training, and background qualifies you to perform the duties that you just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD?
Certainly. So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. Some of those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Are you trained in photogrammetry?
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object, spatially, without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes, by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Doctor, are you a member of any professional societies?
Yes.
Describe those, please.
So I'm a member of the Society of Automotive Engineers, SAE. I'm also a member of the National Association for Professional Accident Reconstructionists, the Optical Society of America, and also the Illuminating Engineering Society.
How many cases
First, I thought he was going to say the Illuminati.
would you say in your experience in your career have you reconstructed or attempted to reconstruct, you or your team members?
I don't actively track that. If I had to estimate at this point in my career, it'd probably be well over 1,000.
And how many of those 1,000, I know you don't have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
You've done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Absolutely. So we do a number of tests at ARCCA to look at the interaction between pedestrians and vehicles. One of the ones I know I did most recently where we were evaluating a vehicle essentially rolling over a pedestrian. So we wanted to understand the vehicle dynamics as well as the interaction between the pedestrian and the road surface. So we conducted testing at ARCCA to evaluate that.
Does ARCCA have any other disciplines other than just accident reconstruction?
Absolutely. So as I mentioned earlier, we have crash worthiness. So again, that's where you're going to be looking at the safety of a vehicle. How does it perform in a crash? We have human factors, failure analysis, premise liability, and biomechanics.
As an accident reconstructionist, doctor, do you or have you studied or tested the forces that are at play between objects interacting, a human being interacting with a vehicle, for instance?
Yeah, absolutely.
Part of what you do.
Yes, sir.
Describe that.
So we use hybrid instrumented dummies at ARCCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any matter, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
Have you ever authored any peer-reviewed papers in the field of physics?
Yes, sir.
Describe those for me.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, Sudden Braking History Recording Characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, or I should say the vehicle,
Jackson.
reaches...
May we approach?
Sure.
Interesting. It's like, I got to break this up, Your Honor.
May I, Your Honor?
Yes, you
Thank
can
you.
move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolfe, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You had never met Ms. Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agent.
So he's asked this question quite a bit of a lot of these witnesses, but with this expert witness and the next one, particularly what's interesting is the fact that they had both formed conclusions before meeting this defense team. So there's that's getting to, like, could they have been biased, for example? It's getting to that question of, like, could they have been biased? Are they hired guns for this defense team? The answer to that is no. Now, unlike Dr. Marie Russell, who Lally tried to paint as like making a hasty decision before she even had the information on it, these witnesses also had all of the information, so many records, basically all the information from this particular case before they even met the defense team and before they made a conclusion. I'm not saying that Dr. Russell made a conclusion before she had the information, but Lally was trying to paint her in that way. So this is a very interesting sort of point that the defense can make here, which is, you made this conclusion based on all the evidence in this case. You happened to have it before we were able to talk to you about it. You didn't even know us when you made the conclusion. So it's just interesting.
Agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
And you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides?
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
That is correct.
All right. Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
I would simply say it was looking more at the damage to the vehicle.
Okay, so in terms of your team and the responsibilities of each of the team members, you were more focused on the damage to the SUV. Dr. Rentschler was more focused on the injuries suffered by Mr. O'Keefe, correct?
I think that's a fair characterization, although with the caveat that we worked together as a team. So we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Were you provided or did you review certain materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those are the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Is this faster?
Sure. If you.
May I?
Sure.
Thank you.
How many categories of materials were you provided?
Provided, it would be approximately 10.
Could you list those off for the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570, report of autopsy, and autopsy photographs.
Based on these data that you were provided, were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do?
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
Mm-hmm. So from those photographs, I was able to identify there was fragments of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots, and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all of the other evidence.
Coming up on Cross. So you're saying that the crime scene couldn't talk to you then if you didn't have the ability to step into it? And then he dramatically looks at the jury, shakes his head. Didn't talk to the crime scene.
Or when it got there.
Correct.
Based on your review of all the materials that you've described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically that Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Did you perform an accident reconstruction specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe?
Yes, I think that's a fair characterization.
And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay. During your analysis, did you note the damage to the vehicle?
Yes, sir.
Describe that, please.
So the primary damage was to the right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper, more so on the wraparound section as it kind of curves around to the right side of the vehicle. There appeared to be some superficial scratches as well in that area.
Was there any other damage or deformation that you were able to glean from your review, the photogrammetry, damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there is some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the lift gate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely, yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
During your review and your investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think it's going back to the scene evidence. Again, we knew that there was glass fragments, what appeared to be from a drinking glass, at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper, in the taillight housing, the taillight mechanism, anything from the car, from the Lexus, that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not have come from the right taillight.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing was.
So we performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt.
Whoa, interesting. This is the first time we've heard this kind of theory from anyone. That is very interesting.
Right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
Yes.
You were not told that theory by the defense because you've never met us.
Correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data. You got a broken drinking glass, a broken taillight. Let's put them together and figure out if the drinking glass could be responsible for the taillight and vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay.
This is so interesting. This is so interesting because now, like, it's like we've been begging for an explanation as to what happened. Begging for an explanation as to what happened. And now here he's like, well, there was broken glass, supposedly from a drinking glass. Then there's a broken taillight. Now there's this interesting possibility that the two of them got into an argument in the car, really pissed because she thinks he's been cheating, what have you, blah, blah, blah. They're in the car for a bit. The Nagels, Ryan Nagel comes up, they see them in the car, et cetera, et cetera. They drive away, whatever. He gets out of the car, still has a drinking glass in hand. Maybe he tosses it at the taillight and then walks in. Is that a possibility? I have not heard that from anyone. From out of all of the possible, there have been so many theories in this case about what may have happened. That's not one that I have heard. That's not one that I've heard anywhere. So that's interesting that this is coming up on like the last day of testimony, seemingly. I don't know. It's very intriguing to say the least.
As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially you can think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Pretty cool job. Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that is a reasonable speed at which an adult male or an individual, for that matter, could throw a drinking glass at the taillight.
Had anybody up to that point, anybody told you any specific let me see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection.
Sustained.
What was the reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass at a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned, we ran 2 tests. The target speeds were at 30 and 40 miles per hour. And there was a little bit of variability in terms of what our target was and what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed, or ultimately the end result speed to that. So what I will say though is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
So interesting.
Are you saying, well, let me ask a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing a glass at 37 miles an hour directly at the taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where where it meets the lift gate into where it starts to wrap around to the side of the vehicle, that's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable at that point, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits a static object that's resisting, and that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass and the taillight were to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
It's a little too leading.
If the taillight were to make contact with a person holding a glass, would that replicate what you did in terms of you're firing a glass into the taillight? In other words, are they apples and apples?
No, I don't think it would be the same.
Okay. Why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, when we're talking about the taillight itself, that 6.5 inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
Sustained.
In all the information that you were provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Correct?
Objection.
Sustained.
Their approach.
Yeah, it's just, yes.
Just ask, like, were you provided any information that suggests that he threw it? Okay, we're gonna fast forward here.
He threw a glass. What? May I?
Yes.
Thank you. What information, if any, were you provided that suggested
What
that
information,
John
if
O'Keefe
any?
threw a glass at the taillight?
No information.
What information, if any, were you provided that suggested that John O'Keefe may have had a pneumatic cannon with him that night?
I'm not aware of any information regarding that.
All right. You also did some testing concerning a drop test. Is that right?
Correct.
Tell us about that drop test testing.
Certainly. So, again, through discussion with Dr. Rentschler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the back of a head. In this case, we used again, talking about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a tail light from the Lexus and the human head.
What height did you choose to perform this drop test?
7.5 feet.
Why did you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact.
Sir, that's cheating. You're not allowed to use physics in this case. That's what the prosecution side or decided.
Speed of 15 miles per hour at that. And
That height.
well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact speed of 15 miles per hour at that height.
And what was the significance of 15 miles per hour?
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into a parking stall. Most people probably don't go more than 5 miles an hour or so. So 15 miles an hour in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition to with respect to kind of just the nature of that speed, it's my understanding through discussion with Dr. Rentschler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with a vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do, 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again, cause damage to the taillight.
What was your conclusion with following that testing? What was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck and the taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour?
So strictly speaking to a damage perspective, the 15 mile an hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So if I were to ask you whether or not there would be more or less damage to the taillight if you increase the speed to 24 miles an hour, what is your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it from, again, a kinetic energy standpoint, kinetic energy is equal to 1/2 times the mass and the velocity squared. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with that. Probably, I could pull up my calculator, but you're probably looking at 2.5 more times energy than the 15 mile an hour test.
Which means 2.5 more times the damage to the taillight?
Certainly.
Which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate the injuries to his right arm?
Yes, sir.
What's the width of the taillight, specifically from where it meets the lift gate to the left side? I'm sorry, to the side of the vehicle, the right side of the vehicle.
To the right. So yeah, as I mentioned earlier, that is about 6.5 inches. It starts to wrap around to the right side. So really it's even though the taillight continues, it's not projecting out on the back end where it's again wrapping around. So in terms of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, to go back to your question about, I think if somebody was holding a drinking glass, right, and their arm was extended to cause that damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
What's the significance of whether or not there was damage between the dent and the taillight? In other words, that 20-inch area. Was it dented? Was it harmed in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle and we go to kind of where that right tail lamp just meets the lift gate, as I mentioned, there's another lamp assembly on the lift gate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the liftgate itself. And I think what stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Can you calculate, or could you calculate, or did you calculate the amount of force that would be required to strike a person just only on the outstretched portion of his arm in order to project him a number of feet, for instance, 30 feet in one direction or another?
Okay, I just want to make sure. Objection.
Take a distance out of it. Break it down.
I'll ask you the same question, but without the 30 feet.
Okay.
Were you able to calculate, or could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about this, the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Is the absence of the damage that you described, the absence of damage that you described between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent in my opinion.
They have just a moment, Your Honor.
Yes.
And what is your opinion, Doctor, as to the amount of damage that you would expect to see at 15 miles per hour or above on the taillight if, in fact, that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow or an arm?
Objection.
I'll allow that.
I'm sorry, can you repeat the question?
Probably not.
Sorry.
I'm trying. Physics, that's right. From your testing, what would you expect to be, what would you expect to see in terms of the damage to the right rear taillight? If in fact, that taillight were to make contact with a part of a human body, for instance, an elbow or an arm, at 15 miles an hour or above, what would the level of damage be as compared to the damage that you actually saw?
Well, if we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force and damage. So as I mentioned, if the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well.
Based on the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did, in your expert opinion, was that taillight damaged by striking John O'Keefe on the head?
Objection.
Sustained.
In your opinion, was the taillight damaged by either striking Mr. O'Keefe on the head or the arm?
Objection.
Sustained.
Can we approach?
Yes.
You are muted.
All right, fast forwarding.
In your may I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jurors, we will take our morning recess.
Okay.
All rise for court, please.
You are muted.
So, and then we're going to get to cross-examination probably. Okay. So we are going to zoom through this here.
Work. So again, by the time,
Okay.
not always.
Early morning hours is
Okay. Sorry, guys. I went a little bit too far. Oh, dang. I really went too far. Okay. There we go.
Please proceed. The court is in session.
All right, Ms. Tallali, whenever you're ready.
All right. But did the crime scene talk to you? What about the stuff that was present?
Good morning.
now you in conjunction with, I'm sorry, Dr. Rentschler, is that correct?
Dr. Rentschler, yes.
So you in conjunction with Dr.
Keep your voice up, Mr. Tallali.
Yes. You in conjunction with Dr. Rentschler and Dr. Klein wrote a report in regard to your analysis here, correct?
Correct.
And doctor, that report was issued on February 12th, 2024, is that correct?
Correct.
And in the first paragraph of that report, the last two sentences, you or whoever the author of that particular portion indicates, this analysis is based on information currently available to ARCCA and is only to be issued in its entirety. However, ARCCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
Correct.
And that's pretty standard as far as your industry is concerned. You can only work with the information that you're provided. Is that correct?
Certainly.
Now, in this,
So now he's going to ask him, you know, what other information were you not provided? Were you provided this? Were you provided that? Were you provided this? Were you provided that? And then it's going to be, you know, well, would this change your conclusion? Would that change your conclusion? And if this is a particularly strong witness for the defense, then his answer probably is going to be, no, it doesn't change it because here's why. Well, he probably wouldn't be able to answer here's why on cross, and then on redirect is when he would have the opportunity to say here's why.
instance, you were provided 10 things, and then there were 4 additional things that either you or the other doctors had reviewed as far as literature or things of that nature. Is that fair to say?
Correct.
And the 10 things that you were talking about were reports, an initial crime scene report, medical examiner dispatch removal report, is that correct?
Correct.
Photographs of the incident location, is that correct?
Correct.
And how many sets of photographs of the incident location were you provided with?
In terms of the number of photographs?
The number of photographs, or were there different sets of photographs?
Yes.
And how many sets?
I don't recall off the top of my head. I know that there was a series that were taken during the daytime, as well as ones taken what appeared to be in the early morning hours.
And you were also provided video from the early morning hours, is that correct?
From what I recall, I think it was daytime, but yes.
Photographs of the vehicle, photographs of recovered evidence, is that correct?
Correct.
CDR report from the 2021 Lexus LX570, correct?
Correct.
Autopsy report, autopsy photographs, is that correct?
Correct.
And then some other things those would be the 10 things that you were provided with, and then there were 4 other things that you reviewed or part of your team reviewed, is that correct?
Correct.
Now, in regard to, there's a section in your report called Review of Materials, and it talks about photographs and glass fragments and plastic fragments and things of that nature, correct?
Correct.
You also talk about a black drinking straw that was recovered on scene, is that correct?
Correct.
However, there's no mention in the report about Mr. O'Keefe's shoe or Mr. O'Keefe's hat. Are you aware of those items as well?
Yes.
And are you aware that Mr. O'Keefe's shoe was actually found dug out from the snow, sort of flush with the curbing in front of the area where his body was found?
Yes.
Now, over the course of your work as a crash reconstructionist, and again, I don't mean this in any way, shape, or form, but I'm just curious. Typically, you're reconstructing or you're looking at someone else's reconstruction in relation to something that occurred in the past, correct?
Not always, no.
Well, my question is, sir, how many times have you actually been on like a live scene where the vehicles are still in place at final rest, where there are bodies in?
There it is. There it is. You weren't actually there, were you? You didn't examine the car itself or something along those lines. Also, does the physics change if you weren't there when it happened?
Place at final rest. Have you ever been to a scene where those sort of conditions existed?
Certainly. We have a rapid response team that essentially we've been on site on the day of or the week of the incident. Yes.
Now, how often is that?
Not nearly as often as, like I said earlier, we primarily do litigation work. So again, by the time we're retained, obviously the scene has been is no longer present.
Scene's been cleared, items have been removed as far as evidence or other things. That's mostly what you deal with, correct?
Sure.
And as far as the hat that we were talking about before, are you aware that that was recovered as well, same day as the drinking straw on February 3rd in the area where the body of Mr. O'Keefe was discovered?
In the area of the front yard, yes.
Now, you have some familiarity through working as a crash reconstructionist with pedestrian collisions, correct?
Correct.
Is it common or uncommon for in the course of a pedestrian collision, for a shoe or glasses or a hat or something to fall off of that pedestrian in the collision sequence near where the area of impact occurs?
Well, I think that depends on the interaction between the two. If it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contacting the vehicle, no, I would not expect the shoe to come off. If it's something where the entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off. Yes.
So
that's interesting. That is also very interesting that he's like, if it's just the arm coming in contact with the vehicle, the shoe coming off doesn't make sense.
Consistent in general terms with a pedestrian collision of the shoe coming off, correct?
Again, based on the interaction between the two. I wouldn't say it's a blanket statement that, again, in all pedestrian interactions, you will have a shoe come off.
And that's not the question I was asking. So what I'm asking, is it generally consistent with pedestrian collisions that a shoe may come off during the collision sequence near the area of impact?
Shoes can come off in a pedestrian impact, yes.
Okay. Now, again, you were testifying earlier about the damage to the Lexus being isolated in the area of the taillight, correct?
Correct.
And that was based on the information that you were providing, correct?
Correct.
Now, with respect to any of the materials that you were provided, was there anything in the materials that you were provided that indicated that just the arm or an outstretched arm of Mr. O'Keefe interacted with the vehicle?
No.
And based on your review of any of the materials that you were provided, was there any information stating that Mr. O'Keefe had been struck in the back of the head by the taillight assembly of the Lexus?
No.
How does this help the prosecution? Lally, you want there to be information that suggests that just the arm was hit by the taillight because that helps Trooper Paul's assessment. Otherwise, once again, Trooper Paul has taken this out of his ass. Or if you prefer to be a little bit, less, callous about it, out of the air. Like, come on, man. You literally are eliciting information from the defense's expert that shows that your side is less likely. Come on, man. Was there any evidence, that you reviewed that suggests that his head came in contact with the vehicle? No. Well, then why are you saying that, Lally? That's just ridiculous. Let me see here. Did I? I am a little bit behind on some of these super chats. David Case, thanks for the super chat here. At what point does the prosecution's case become a waste of the court's time? It took them a month. I mean, it depends on who you're asking. If you're asking me, it's yes, there's been a lot of time wasted here. HS, thanks for the super chat. Question: why hasn't counsel stated the grounds for any of their objections? Neither side has had to state the reasoning. I wonder if Lally knows his grounds for half of his objections. That is because of a ruling by the court here. They don't want any speaking objections. They don't want the attorneys arguing in front of the jury about these objections because they can start making arguments to them. Essentially, that would be improper. It's a very extreme kind of decision by the court to not allow them to state the grounds for the objection. Usually there's, you say objection hearsay, objection leading, objection foundation, objection, fill in the blank. That is typical. That is normal. In this case, we're living in an alternate universe where that's not allowed because of the court's determination. Heather Miller, thanks so much for the super chat. Alleged incident. I love it. Yes. Yeah, he's not agreeing that there was this incident for sure. Mindy Corcoran became a YouTube member. Thank you so much for joining Bite Club and supporting the channel here. Like I said before, to others in the chat who have bought memberships, you are helping to keep the lights on. Thank you so much for becoming a member. Just because, thanks for the super chat. How familiar are you with Dane Cook's getting hit by a car joke, Mr. Or is it Doctor? You can call me Dr. Wolfe. I know. I keep thinking about that too. The shoes flying during a pedestrian accident. I wonder, like if that's, is Lally familiar with that? I am curious about that. All right, let's continue with the testimony.
And based on any of the materials let me ask you, based on any of the materials that you provided, were you aware that Mr. O'Keefe is on video exiting from a bar minutes before crash occurs at approximately 12:11 a.m. holding a cocktail glass in his right hand?
I'm not aware of that video.
But it still supports his theory. The dead air is deafening.
Now, other than the materials that we just went over, as far as the 10 things that you were provided, you weren't provided anything else, is that correct?
That would be correct.
And so sort of the questions that you endeavored to answer, those were questions that you didn't know from any of the materials that you were provided, is that correct?
If I understand your question correctly, there was nothing in the material that indicated the questions we were to answer, if that's what your question was.
That is my question. So there was nothing in there, is that correct?
Correct.
I have a moment, John.
Yes.
I don't understand what is he asking? Also, I'm expecting him to drop like, well, did you look at this? Did you look at this? Did you look at this? And he's not doing it. So like he's trying to suggest that he didn't look at enough.
You
things.
talked a bit about, you have some extensive background in human factors, correct?
Correct.
And as far as visibility, and in particular, have you ever conducted a visibility analysis?
Absolutely, hundreds of times.
And you talked a little bit about conspicuity, is that correct?
Yes.
And part of conspicuity, at least one of the factors, would be a reasonable expectation of, in particular, when you're talking about a pedestrian collision. Part of the conspicuity factors would include sort of a reasonable expectation that a pedestrian would be in the path of the vehicle. Is that fair to say?
I don't understand your question.
Sure. When you're talking about conspicuity or visibility analysis, in particular, you're talking about something called PRT, or perception reaction time, correct?
Well, that occurs after recognition. So first, a driver has to recognize that there's a pedestrian there before they can actually respond to it. So once they've recognized the pedestrian, then you start the perception response time where, again, the driver has identified what the hazard is. They're making a decision about what to do. They might be moving their foot from the accelerator pedal to the brake pedal. So again, kind of that's the action or the time frame in which a driver is undergoing action to potentially mitigate the collision.
And perception reaction time, that's a pretty commonly used industry sort of standard as far as crash reconstruction goes, correct?
Well, I would say that it's used in the field of accident reconstruction, but as I mentioned earlier in my testimony, there isn't a blanket number in terms of perception response time. As I mentioned, it's based upon the hazard that the driver is presented with. Again, if you've got a pedestrian crossing the roadway, that's going to be one particular perception response time based upon studies and naturalistic data versus a driver suddenly stopping in front of you, right? It's not the same perception response time in every scenario.
That makes sense. Also, really quick, I'm interrupting. I'm sorry, guys. I know that this testimony is really great, but I just want to, why is it so grainy? There, it's a little bit better. That's a little bit better. It's just so cute. I'm sorry. I had to. She's just so cute. Okay. Sorry. That had nothing to do with the testimony. No legal commentary whatsoever. I just wanted to capture that moment.
Oh, understood. And there's different variables that may affect that as far as someone's age, as far as the lighting that's available, other things. Is that correct?
Sure.
And one of those things might be the reasonable expectation of a pedestrian being present in the roadway as you're driving along, correct?
Expectancy can play a role, yes.
In expectancy, what we're talking about is sort of the disparity or the difference between driving along a country road where there's no houses for miles and miles versus an urban area where there's crosswalks every 15 feet, correct?
Sure.
Now, in that expectation of privacy, how high would that be if we're talking about a pedestrian that actually exited from the vehicle that then strikes?
I don't understand your question.
Let me ask you this. If the operator of the vehicle has a passenger who then exits the vehicle and goes towards the back, would there be a high reasonable expectation that the pedestrian would be located in that area?
I don't know if I would classify it as high.
What would you classify it as?
I honestly don't know that I have a classification to it.
Now, you never looked at the defendant's vehicle in this case, correct?
Correct.
Are you aware that the defendant's vehicle is still in police custody and available for inspection?
I'm not aware of that.
Did you ever ask to look at the defendant's vehicle?
No.
Now, a typical pedestrian strike, for the most part, involves a pedestrian in front of a vehicle as it's coming down a street. Is that fair to say?
That can be one type of interaction, yes.
Is that more prominently seen as far as your field than a rear collision?
I would say that's fair.
And there are various types of sort of interactions that the pedestrian can have with the vehicle in order to cause and sort of sustain injuries. Is that fair to say?
What I would say is that there's certainly, in terms of how the pedestrian interacts with the vehicle, in terms of whether they're being wrapped onto the vehicle or projected forward, certainly there's different types of interactions, yes.
So there's like a wrap and forward projection type of collision sequence. Is that correct?
Those are two common, yes.
There's also something called a fender vault. Is that correct?
Correct.
And sort of how or where that pedestrian is positioned with relation to the vehicle is somehow or somewhat determinative of the injury sustained. Is that correct?
It can be, yes.
Obviously, you're going to see different injuries if someone fender vaults and goes over the top of the vehicle versus someone who is projected forward from the collision sequence with the front of the vehicle.
Just to clarify, again, in this matter, I was not assessing injuries. That was Dr. Rentschler. I don't have an opinion.
What I'm saying is based on your experience, so that you understand that there's a difference in the injuries that you might expect based on the type of interaction that a pedestrian has with a vehicle.
Yes.
And then if someone is wrapping forward projected and then the vehicle overruns that person, there'd be a whole other host of injuries that you'd expect to see based on being overrun by the vehicle, correct?
There could be, yes.
I mean, he already said it doesn't make sense for him to have been spun out by getting hit by the arm, which is the theory of your accident reconstructionist, Mr. Lally. So like the only possibility of him getting hit by the car then is that he got hit by the car and then was still in the path of the vehicle. So now you yourself are pointing out how ridiculous that kind of a theory is. You're further narrowing the possibilities that he could have been hit by the SUV and gotten the injuries that he got. So like, what are you trying to do here, sir? Once again, what is your plan? What is your strategy with this expert witness?
Now, the testing that you did with respect, these are essentially experiments that you're doing, correct?
That's fair, yes.
And am I correct in saying that in scientific experiments or in the world of scientific experiments, there are certain things called variables that you're trying to account for? Is that correct?
There are certain things called variables. I don't know. I feel like he's not operating on the same level as this witness.
I would say that's fair, yes.
And essentially what you're trying to do is control as many of those variables as you can in order to best replicate whatever the conditions were at the time that what you're testing to see actually occurred. Is that correct?
Correct.
Now, what, if anything, did you do to control variables in relation to temperature?
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees, so that they had reached a steady state temperature before we subjected them to the impact testing.
And where in your report does it say that?
I don't believe that's explicitly stated.
Is it implicitly stated anywhere in your report?
Again, I'm telling you, that's part of what we did for the testing.
I understand that's what your testimony is, but you wrote a report, correct?
Right, and I don't know that I detailed every single part of the test. Again, we summarized it.
Understood. So what did you do to control?
I'm sorry, Lally giving him like, shade at like, well, this part of your testing wasn't in the report, and he's like, we didn't want to put every single part of the test in there. It was a summary of the report, but he's like trying to throw shade as if this guy has skipped over certain important parts of his work and not represented it in the report. Meanwhile, his own expert didn't use math. He didn't use math or physics, apparently anyway, based on what the testimony that we got from him. So like, I don't really, Lally, you're going to throw that shade? What is happening here?
Any variable as far as wind?
Well, when you're talking about a projectile such as a glass, again, that's being projected at 37 miles per hour, again, there would be probably minimal effects in terms of the wind.
Even if there was a blizzard going on?
Again, what we're going after here is ultimately conducting a test such that the drinking glass arrived at the location of the taillight. So if you're trying to say that, okay, he threw it this way and the wind blew it towards the taillight, sure, that could be a possibility.
And sir, I'm not trying to say.
If we're talking about him throwing it over like a massive distance, sure, wind could be more of a factor. But if he's standing like right in front of it, for example, or several feet away, wind is less of a factor. I mean, that's just simple common sense.
Anything? I'm just asking, are you aware that there was a blizzard and that there were wind gusts up to 37 miles per hour during the time that this collision occurred? And that's
At 12:30 in the morning ish, there were not any, no, there were not wind gusts at that level at that hour. Later in the day, sure. But once again, okay, go on, Elsa.
not accounted for in your test.
Were you aware of that, sir?
I'm aware that there was inclement weather at the time, yes.
Now, with respect to what type of glass did you use?
So we used a rocks drinking glass. So that's a glass that has a thicker base and a shallower sidewall.
And so what I'm asking, sir, was it cocktail glass? Was it pint glass? What kind of drinking glass are we talking?
A rocks drinking glass.
And how tall is that rocks drinking glass that you use?
If I had to estimate, I think it was about 3 or 4 inches tall, probably.
And the thickness, did you measure that as far as the thickness of the bottom of the glass?
No.
Was the thickness of the bottom of the glass thicker or more thick or less thick than the top of the glass?
Are you talking about this in comparison to the sidewall of the glass?
Talking about in comparison to itself. So you have a glass, this rocks glass. Was the bottom thicker or the top thicker?
The sidewall would be taller, if you will, than the base.
And so when you're projecting this thing out of the device that you created, the whatever it was,
Air cannon.
are you facing sort of the top of the glass where you would be sipping out of, or the bottom of the glass at the tail?
So in the testing, the interaction between the taillight and the glasses was primarily between the base and the taillight.
Now, with reference to, I asked you a little bit about the video, and you weren't aware of Mr. O'Keefe exiting from the Waterfall Bar at 12:11 in the morning, about 15, 20 minutes before he's struck by a vehicle. You're not aware of that?
I'm not aware of that.
Now, with reference to that particular establishment, was there anything stopping you or the other doctors that you were working with from going to that establishment, finding out what kind of glasses they had, getting an actual cocktail glass from that establishment?
I had no idea that video existed.
He already said that he took the evidence that was there at the scene. So in other words, he knew that there was glass. He took the evidence about the glass that was there. So like, you don't have to go to the Waterfall Bar and Grill and ask them about what kind of glasses they have personally in order to do that. You can just take the glass that was found at the scene, allegedly.
Do you even know that Mr. O'Keefe was at a bar before he was struck by the vehicle?
I believe that in one of the incident reports we reviewed that there was, I think, a narrative about that they had been at a bar drinking, yes.
How is it that you determined where on the taillight assembly to aim?
So we looked at the fracture pattern, and what it appeared to be that it was emanating from basically where the clear portion meets the red cover. We kind of saw that the fracture pattern emanated from that. So that's where we targeted it.
Now, when you did this testing as far as the sort of breakage or the pieces that came off the taillight, is it fair to say that they were of sort of different shapes and sizes, the broken pieces?
Sure.
Consistent with the broken pieces that were found on the scene near Mr. O'Keefe's body?
Yes, I would say that's fair.
Now, I know you may not be the person for this, but just as far as your reviewed some of the autopsy report, medical findings in regard to Mr. O'Keefe, correct?
Correct.
And the injuries to Mr. O'Keefe were primarily on the right side of his body, correct?
Correct.
So there were injuries to his right arm and forearm, elbow area, correct?
Correct.
There was bruising to his right hand. Do you recall that?
Yes.
There was an abrasion to the outside or the posterior of his right leg near his knee. Do you recall that?
I don't know that I recall that off the top of my head.
And do you recall sort of the skull fracture or the laceration that immediately outside of the skull fracture was on sort of the right back of his head?
Yes.
Now, from the reports that you reviewed, were you aware that when Mr. O'Keefe's body was discovered by the defendant and two of Mr. O'Keefe's friends, that the defendant was the only one who could see him in the conditions?
Objection.
Sustained.
As far as the lighting was concerned in that area where Mr. O'Keefe's body was found, are you aware there was no overhead street ambient lighting or anything like that?
Objection.
I'll allow that.
I'm not aware of that.
And you didn't do any visibility analysis or anything in relation to this case, correct?
That wasn't a part of my scope in this case.
Well, as far as part of your scope, did you define that you indicated earlier that there were questions that you didn't find in the materials that you have to conduct experiments to prove or disprove, correct?
Well, again, the entity that retained us in this asked us to evaluate whether or not the damage to the vehicle and the injuries to Mr. O'Keefe were consistent with the interaction or in interaction between the two.
So you were at least somewhat restricted in the scope of what you could do based on the parameters given to you by the agency that hired you. Is that fair to say?
Sure.
What he already said, but yeah.
Now, as far as any statements by the defendant to investigating troopers either that afternoon or that morning when Mr. O'Keefe's body was discovered, were you familiar with any of those?
Objection.
I'll allow that.
I'm not familiar with.
Sure.
Sidebar.
The defendant said to were you, so doctor, with regard to the defendant's statements at any point were you, did you review materials or were you made aware that the defendant said to multiple people on scene, I hit him, I hit him, I hit him, I hit him?
Why would
I'm not aware of that.
Why would that be part of his analysis? What does that have to do with physics? Okay. All right, Elsa.
May I have a moment, John?
Yes.
Now, within the reports that you and the other doctors submitted, there's an indication that if either Mr. O'Keefe's arm or head had interacted with the taillight, there'd be some expectation that either blood or DNA would be contained on that taillight. Is that correct?
I believe, yes, that was stated in the report.
And at any point were you made aware that Mr. O'Keefe's DNA actually was recovered from that taillight assembly from the defendant's vehicle?
No, I was not.
Now, as far as forensic reports, what, if anything, were you provided in reference to that, other than the initial crime scene report?
Are you talking about specific to the scene or forensic reports to the body?
Forensic reports specific to the evidence that was recovered from the scene and from the defendant's vehicle.
Only what would be listed in the report.
Now, you indicated as one of the materials that you were provided and you reviewed was the EDR, event data recorded data.
The crash data retrieval report, yes.
Okay. Now, were you shown anything as far as a crash reconstruction report from a trooper from the state police?
No.
And the EDR data that you observed, did that contain any sort of usable data?
There was no events recovered on the black box.
And with respect to there being no events recovered on the EDR or the black box in a pedestrian collision, is that unusual?
It is not.
And why not?
Well, because you're talking about, excuse me, a very large weight difference between the vehicle and the pedestrian. So ultimately, what the vehicle is constantly monitoring is acceleration, which gets back to a term called delta V. So when the vehicle doesn't experience a big delta V, typically the threshold for a non-deployment event where you're not firing airbags or any safety mechanisms, but the vehicle wakes up and says, hey, there was something that I potentially hit. It's usually at a threshold of about 5 miles per hour. So again, given the weight difference, we usually don't see delta Vs that high with pedestrians.
And is that in some respects because what the EDR and what the safety restraint systems are designed to protect is the occupants of the vehicle, correct?
That's fair, yes.
I mean, there are more innovations as far as vehicles that are more modern or released earlier that have certain pedestrian or protections for other vehicles, but primarily what they're focused on is the occupants of the vehicle, correct?
Correct.
Now, at any point in time, were you shown any tech stream data, Toyota tech stream data from the defendant's vehicle?
No.
So you weren't shown any data indicating that the defendant's vehicle was being operated in reverse.
The objection sustained. Next
Yes,
question.
you can't ask a bunch of details when he already said he was never shown that.
So with regard to the defendant's statements, were you also not told that the defendant told several people that she had just gotten into a fight with Mr. O'Keefe right before she dropped him off at 34
Clearly
Fairview
outside
Road?
the scope.
So that's sustained.
Yeah, clearly outside the scope.
Now, with regard to pedestrian collisions, you're familiar with sort of the physics term, I'm presuming, doctor, as far as like center of mass. What kind of role does a center of mass for a pedestrian play in relation to center of mass of a vehicle as far as how the two interact?
Well, it depends, again, on the vehicle structure. And again, when you're talking about where's the hood height, the bumper height, and the CG, or the center of gravity of the pedestrian, that, again, will kind of dictate how they interact with the between the vehicle and the pedestrian.
Now, typically, a typical pedestrian collision, again, that we were speaking about before, is in relation to a pedestrian struck by the front of a vehicle, correct?
Correct.
And so in a typical pedestrian collision, that involves more of an assumption of the velocity of the striking vehicle than you would see occur in sort of a side swipe. Is that correct?
I'm sorry, can you repeat the question?
Sure. In a typical pedestrian collision, that would involve more of an assumption of the velocity of the striking vehicle by the pedestrian than you would see in a typical side swipe collision. Is that correct?
If I understand your question correctly, yes. If the vehicle is striking the center of gravity of a pedestrian as opposed to just, for instance, a limb, yes, the center of gravity or the body will be accelerated up to that speed.
Now, with respect to the defendant's vehicle, again, you never actually looked at the defendant's vehicle. Is that correct?
It wasn't necessary.
And
There
did
you go. It
look
wasn't
at the
necessary.
actual taillight housing from the defendant's vehicle?
I had sufficient photographs of the taillight.
Did you ever look at the actual physical broken pieces of the taillight from the defendant's vehicle?
Again, I had sufficient photographs that documented the fragments and pieced them together.
Yeah.
And you're aware, at least, that the fragments that were recovered on scene were then sort of put back together and overlaid over the taillight housing that was taken from the defendant's vehicle?
Yes.
And through any of the pictures of the photos that you observed, did you ever see a piece of metal protruding underneath the broken and shattered plastic pieces from the taillight?
I believe it was a plastic chrome piece.
And when you were doing the testing as far as shooting the glass, the drinking glass at the taillight assembly, that taillight assembly was sort of held there by vice grips or something like that. Is that correct? It wasn't actually physically attached to a vehicle, the one that you were shooting at?
That's correct.
One second, guys. I'm going to have to be right back really quick. I've got to do something real quick. Like 2 minutes. I apologize. I know this is riveting stuff. The questions by Lally. Talk amongst yourselves. Answer the poll if you haven't done so already. Like the video if you haven't done so already. I will be right back in like 2 minutes. I promise. Okay, and we're back. Sorry, guys. Okay, let's continue with the testimony.
Now, as far as that, you're familiar with, there was a piece of a broken drinking glass that was recovered from the same area of where Mr. O'Keefe was found. Is that correct?
Amongst the fragments of the taillight, yes.
And are you familiar with Mr. O'Keefe's DNA being present on those pieces of the exterior of a broken drinking glass located near his body?
I don't believe so.
Now, as far as Mr. O'Keefe's clothing, his fingernails, are you aware that there was DNA of Mr. O'Keefe and no one else recovered from both his fingernails and from a variety of areas of his clothing?
What?
That's
way outside the scope. Again.
Now, from the crime scene report that you reviewed, are you aware that there was human hair that was located on the right rear quarter panel near the dent that you were talking about?
Objection.
I'll allow that.
Yes.
Are you familiar or are you aware that subsequent mitochondrial DNA testing found that the mitochondrial DNA profile for that hair was consistent to a probability of 99.895% with the mitochondrial DNA profile of Mr. O'Keefe?
I'm not aware of that.
Now, were you also aware that the broken drinking glass with Mr. O'Keefe's DNA on it was found to be consistent with the broken drinking glass pieces that were found in the street?
Objection.
I'll allow that.
Can you repeat the question?
Sure. Were you aware that the pieces from the exterior of the broken drinking glass found near Mr. O'Keefe's body with his DNA on it were then found to be consistent with pieces of broken drinking glass that were located in the street of 34 Fairview Road?
Yes.
Were you also aware that pieces of glass that you were talking about from the defendant's bumper were found to be consistent with pieces of glass recovered from the street in front of 34 Fairview Road?
Yes.
Were you aware that there were microscopic pieces of red and clear plastic, about a 1/16 of an inch by a 1/16 of an inch, that were recovered from Mr. O'Keefe's clothing that were then found to be consistent with the tailor?
No, I don't believe so.
Now, as far as, again, you weren't provided with any sort of reconstruction report from a Trooper Paul from the state police?
No, I was not.
So you're not aware that he took measurements from the ground to where certain items were on the vehicle?
Objection.
The objection sustained. He didn't see the report. Sure.
Yeah, he keeps doing this. He keeps doing this. This is probably what Alan Jackson is going up there to do, is to complain to the judge, to say, like, you know, he keeps doing this where he asks a question. Clearly the witness says that he doesn't know or he hasn't seen it. And then he proceeds to ask about details in it. He's just trying to elicit, he's just trying to argue in front of the jury. That's why he's doing it. And that's highly improper, because he knows that the witness has already said that he doesn't know about the information that's in it because he hasn't seen it. So that may be what's going on there, is he's complaining about that to the judge, and then the judge is probably going to turn to Lally and say, you got to knock it off. Maybe. That's what I'm imagining anyway.
You are unmuted.
Yes.
So this is just a cross-examination of, I'm throwing spaghetti at the wall and trying to see what sticks, because this was, I got nothing.
Just a moment.
Yes.
Because it's hard to respond to.
Now, doctor, in the
that
course
testing.
of your analysis or review of materials here, were you ever provided with a video of the defendant backing out of a garage and making contacts with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
No.
Now, as far as from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case?
At that speed, no.
It's not even at a low speed. I don't think he was expecting that answer.
Then we can do our 2:00.
So there were about 10 items that you were provided that you reviewed, is that correct?
Correct.
And a number of different items that I just asked you about that you weren't provided with or you weren't aware of, correct?
Correct.
And again, in your report, in the very first paragraph, you indicate, however, ARCCA reserves the right to supplement or revise this report if additional information becomes available, correct?
Correct.
I have nothing further on.
All right, Mr. Jackson.
Thank you, Your Honor.
He didn't. I was wondering if he was going to then ask, what would your opinion change based on any of this information? That would have been dreadful for him because the answer probably would have been no. But, oh my God. Okay. Well, we're through it now. Now we're on redirect.
Very briefly, Dr. Wolfe, you were asked on cross-examination a couple of questions about a hair, DNA on the outside of the taillight lens, the taillight housing, and glass material. Do you recall that?
Yes.
Does any of that change your opinion
There you go.
about your opinions and conclusions in this case?
Objection.
I'll allow that.
Absolutely not.
What is your conclusion as to whether or not the damage to the vehicle and the injuries to the human being are consistent or inconsistent with the vehicle interaction?
Objection.
Sustained. All right, Dr. Wolfe, you are all set, sir.
Thank you.
Okay. All right.
Yeah.
We are going to get probably the next witness here in a second, but
I'll do it back there.
just want to make sure that they actually call him first, and then we'll get some questions before we actually start the testimony.
Yeah.
Yes.
Your Honor, we would ask Dr. Andrew Rentschler to join us, please.
There we go. Okay. Dr. Andrew Rentschler, but first we are going to get some questions here. First, a super chat, Kathy at Raw Bath and Beauty. Thanks so much for the super chat. What do you think the difference between the Lally Show closing and the Action Jackson closing? If the opening statements and the performance throughout direct and cross examinations are any indication, I think that Lally is really going to struggle at providing a cogent, coherent, organized argument to the jury, which is going to make it much more difficult for anyone who is feeling sort of pro prosecution on the jury panel to try to convince anyone else to join them, in convicting Karen Reed. On the other hand, I fully expect Alan Jackson to be very, very passionate, very organized in his arguments. I think that we are going to see absolute fireworks coming from him during his closing. So that's what I expect to see based on what we have seen so far. It's going to be a very big difference, I think. So get ready for it. Allison, question, this might have been covered before, but I don't recall how much blood was around, let me do this, but I don't recall how much blood was around him with his injuries, especially the head injury. There would have been a lot of blood loss, right? You would think so. And so that hasn't really been brought up one way or another all that much. But you would think so. And there hasn't been any found there anyway. So then there's also the blood drops on his shirt, on his shoes. the fact that Dr. Sheridan said here that he would have been knocked unconscious right away from the head injury. So that indicates that there would have been a little bit of time perhaps between him getting hit in the face and then also, sustaining that injury to the back of the head. You would think there's a possibility there based on the blood dropping down his shirt and whatnot. So it hasn't really been talked about. It's been kind of hinted at in a number of ways, but it's an interesting question that just hasn't been answered. And who has the burden here? Prosecution has the burden to answer it. Shelley's Flowers question: is the Turtle Boy assault actually true, or is it a rumor? I do not know. I only know the basics of what I heard. There was some sort of an altercation and cops were called. I don't know too much beyond that. So unfortunately, I'm not able to provide you guys much information on that. Rita D, Legalbytes: who decides the set length for a trial and how? What about jury sequestration? That is the judge. The two sides are going to put their best argument forward in terms of what they think should happen, but the judge ultimately is the one who decides that. Mew question: do you kind of feel sorry for Lally for how competent the defense's witnesses are being, whereas the prosecutor's witnesses were mostly like a joke? He has the ability to call or not call certain witnesses. He has the ability to determine the overall trial strategy. He has the ability to hire expert witnesses, to find expert witnesses to use in this particular case. So I don't feel bad for him. This is the central core work of what a trial lawyer does. And, this is ultimately like, it's the central wheelhouse of what a trial lawyer does. So I don't feel bad for him for being bad at his job, I guess. Yeah, I know that sounds really harsh, but it's kind of true. Also, there have been enough things that have been ethical questions that have that I've seen that also make me not feel too bad for him in terms of like him being an ethical prosecutor. On top of that, it removes a little bit of my extension of empathy for any of the people involved in the case as I put it to him. Shannon, thanks so much for the super chat. Hi, Biters. Thanks for best free speech chat. Was J.O. investigating the crime families? I don't actually know that. I have heard that as a theory, but I don't know if that is actually true. Spider question: this is back to Friday's testimony. Is it possible that Lally argued to exclude certain testimony and then blatantly opened the door on cross to make it look like the defense was hiding it? That would be a dirty move. That would be a dirty move if that were true. I don't know, but I guess it is possible. And we've seen enough here to suggest that maybe that's something that's a strategy that he would be willing to do. I don't know. Mew Legalbytes question: how do lawyers prepare to question expert witnesses? Isn't it difficult to ask technical questions? Yes, you have to learn the basics. You have to learn the ins and outs of it in order to properly question them, whether you are on direct or on cross-examination, because you've got to know what information to draw out, what to focus on, what to attack, what is important to what is actually questionable, because if you don't quite understand the material and you're in charge of, putting questions to this person to tell the jury, essentially to flag to the jury that this is somebody that you can't necessarily hang your hat on, you have to be able to understand it. So it requires really some serious study by the attorneys to truly understand it so that you can do a better job of that. Janet G: Legalbytes: I love when judge says ask it differently. I don't recall hearing other judges do that. Is that somewhat normal? It is. It's they might say it in other ways, but I've heard other judges basically say that to like hint to the attorney, try again, just do it a little differently. James Games Classics: Legalbytes: do we know who hired his company if it wasn't the defense? I think it was the Department of Justice. I think that came out during voir dire, but they're trying not to talk about it in front of the jury. Shannon question: who was John investigating the officers? Oh, you also asked that by super chat. I same answer. I don't know. Brad Hopkins question: would it be better to have pictures to go along with his testimony? Yes. And anytime you've got visuals, diagrams, things like that, it always helps for sure. Triker question: did you see the news today that Turtle Boy was assaulted by the sister-in-law of Chris Albert over the weekend? He exposed her after she allegedly created a fake Twitter account to attack Karen Reed. I didn't know about those details. I just knew that there was some sort of an altercation, like right outside or at McCarthy's bar or something like that. I don't know. Mr. W, Legalbytes question. So at this point, if you're Lally, how do you recover this case in closing? Is there a Hail Mary play that he could use? Well, I would do my best to try to create a central line theory that is based off of the evidence that they've heard. That's really hard to do in this case because there's so many conflicting details, even among like what the expert is saying and what Lally is suggesting on cross-examination of this witness. So I don't know. I mean, basically kind of ignore some of the testimony so that you can create some sort of a through line with the others. It's the best I can say. Letitia made this question. So if the glass that John had doesn't match the glass on the tailgate, but tailgate and ground do, doesn't that suggest that he was inside 34 Fairview? It could. Yeah. Sue B, question I'm still so curious about auto stop in the car. Did I miss that? No one talked about it. I was surprised too. I thought that we were going to hear maybe something about infotainment systems, maybe about auto stop, things like that. Sarkadoodle, Legalbytes, in relation to potential scope of an FBI investigation, would Lally be potentially in view as he's bringing the case forward, or is he shielded from it? I mean, there is such a thing as malicious prosecution if they've got background information to suggest that, like some internalized communications, or I don't know. I'm not sure. I mean, he's someone that they would definitely be looking at as someone involved in all of this for sure. But whether or not that actually results in anything on him, I don't know. Baz 80s, Legalbytes, any sympathy for Lally is totally gone after this cross. Do you think his droning is having an effect on the jury? It's having some kind of an effect. I don't know what though. It's so hard to know without actually being in the courtroom and being able to actually observe them. Whether or not they're paying attention is the biggest one. Does it look like they're actually engaged in watching the people and listening to what they're saying? Or are they, like I've said before, like counting the tiles on the ceiling? Emma-Lisa 4, question, has Lally forgotten again which side he's on? It seems like it sometimes. Daniel Evans, question, is Lally more thirsty than a man stuck in the desert, considering that I hit him question? Could be. Rhinus, Legalbytes, why would Aunt Bev let that question in about I hit him to an accident reconstruction? She's so dirty. She's not necessarily going to act unless the defense has an objection. So not all judges are going to jump in without one side objecting. Elena, question, is it me or does Lally just not have any good questions for this witness? That is exactly how it seemed. He's trying to fill the air. He's trying to throw spaghetti at the wall. Ashley, prosecution has an idea of what defense will be asking, right? Couldn't Lally research prior if low speed impact could wait? Prosecution has an idea of what defense will be asking. Couldn't Lally research prior if low speed impact could crack the taillight? Sure, probably. I mean, regardless, if they talked about it in the report and they said that that's less likely, that's a dumb question. If they didn't talk about it in the report and he doesn't know the answer that he might give on cross-examination, that's also a bad question because, as I've said before, you don't want to ask a question to which you don't know the answer unless you don't care about the answer. Buttercup 203, Legalbytes. Oh, I just enlarged Indy's emoji. It's adorbs. I couldn't tell seeing it. It's small in the chat is awesome. Yes, it's very cute, right? I love it. John Smith, Legalbytes. I think that question was to say that KR didn't crack the taillight hitting JOK's car. I mean, that's a new theory, right? Definitely. Travis James, verdict by Friday. I could see it. Wingy 158, is there a time limit on closing? For civil cases, there typically is. Criminal cases, I don't think so. I have not heard of one before because we're talking about more like somebody's liberty on the line, things like that. Ashley Wynn, Legalbytes, I'm interested to hear what people who think she's guilty have been convicted by or convinced by. Excuse me, I need to breathe better. What if the prosecution's evidence do you think was the strongest? I have to think back now. See, it depends on what you are convinced by. I think that the I hit him testimony is probably the most convincing, but that's assuming that you aren't looking at all of the other sort of nuanced evidence around those circumstances. If if you don't buy the idea that she's lost her mind that morning, that's how I feel personally. If you don't buy that, then I can see how her saying I hit him and assuming that you actually think that she said that, because there's two layers there, right? There's a layer of, did she even say that in the first place? And then there's, if she said it, is that something that we can say is actually indicative of her mental state at the time, because she's actually lucid enough to be saying things that are tied to reality. So, if you're not there where I am in that analysis, I can see that being the most compelling part of this, is her saying I hit him. Let's see, a couple more questions here. Content in 1979, Haas long until Lally throws all his papers up in the air, like in the meme, and says, "What time is it?" It's F at o'clock. I don't know. We might get there. Let's see here. Christina Kirshner. A question. Can the prosecution do a rebuttal closing in response to defense closing and get both the first and last word? Yes. Yes, absolutely. That's typically what happens, actually, because the rebuttal is to give them a chance to respond to the defense. Because the advantage that the defense has going second is they can see everything that the prosecution is arguing and they can respond to it. And then on rebuttal, the prosecution has that limited ability just to add some words to respond to the things that the defense said. Obviously in their own first closing argument, the prosecution can anticipate probably about what the defense is going to be saying, but there might be some things that they still want to be able to respond to. So they'll reserve part of their time. They both get the same amount of time, but the prosecution will reserve some of that block of time for the very end to do that. And that's, in the interest of fairness and all that kind of stuff. All right. I think that is probably the rest of the questions. I apologize if I missed any. Let's get on to the next witness. That's going to be Dr. Rentschler.
While he's coming in, just very quickly about scheduling.
You are muted.
Okay. 1 second here. Okay, let's fast forward a bit.
Everybody's nodding. All right, thank you.
Okay, sorry.
You are unmuted.
Can we go a little past 1 to keep going with this, if that's okay? Everybody's nodding. All right, thank you.
Okay,
here he is.
During the case, now you're the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
May I inquire?
Yes.
Doctor, could you please state your first and last name, spelling your last name for the record?
Certainly. Andrew Rentschler, Rentschler.
And what do you do for a living, sir?
I'm a biomechanical engineer and accident reconstructionist.
And who do you work for?
I work for a company called ARCCA LLC.
How long have you been in that position as working for ARCCA, first of all?
I've been with ARCCA for about 16 and a half years now.
And you indicated that you're the director of biomechanics and human factors, is that right?
I am. I'm a vice president and the director of biomechanics for the Midwest Division.
Can you tell us what education, training, and background qualifies you to perform your duties as the director for biomechanics and human factors?
Sure. Well, I've got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanical engineering from the University of Pittsburgh in 2002. And then I went to get my doctorate or my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Doctor, do you specialize in research and analysis to evaluate specifically the study of the relationships between crash injuries and crash forces?
I do, yes, sir.
And when I say crash injuries, we're talking about to human beings.
That's right. Injuries to human beings, whether it be, in a crash, motor vehicle accident, slip and fall, industrial, any type of setting where there's an injury to the human body. I evaluate basically that event and the mechanisms responsible for producing those types of injuries.
Doctor, does it also include the study of and understanding of human kinematics?
It does, yes.
As well as human tolerances?
Yes, sir.
We all know what tolerances mean. What does kinematics mean?
So kinematics is really just the motion of the human body, and it's the study of the human body, how the body moves under different circumstances, whether you're in a car that's struck from behind, what direction will your body move, slip and fall, how will your body rotate and move. It's really looking at the motion and the response of the body.
Are you certified by any professional associations?
I have again, a PhD. There's no professional licensure for biomechanical engineering. PhD is the highest basically certification you can get. And I'm also a member of SAE, Society of Automotive Engineers, as well as the American Society for Mechanical Engineers.
Have you received additional training and education in further beyond your PhD and the associations that we just talked about?
I have, yes, sir.
Can you describe, without going through all the detail, describe the kind of continuing education that you engage in?
Well, I attend seminars and professional classes with respect to biomechanics as well as action reconstruction, but looking at new technology and research with respect to injuries. For instance, motor vehicle accidents, if there's new safety measures such as airbags, seatbelt pretensioners, auto detection devices on vehicles. So really kind of staying up to date with the current research and literature that's out there.
So your specialty, your subfield, if you will, in terms of your engineering degree and education is literally in accident reconstruction and the effect that accidents and incidents can have on the human body. Is that right?
It is, yes. And biomechanics is really, it's looking at injury to the human body. So, we use traditional engineering principles and apply it to the body because an injury is just an engineering problem. Instead of looking at a piece of steel that if you know the dimensions and size and you apply a force, it'll bend and break. We look at the human body. How much force does it take and how does the force have to be applied to get a humerus fracture or an intervertebral disc injury or any type of injury? There's specific force.
Earbud. I knew it was coming up soon.
Forces and mechanisms you need to produce those injuries. And that's what I do as a biomechanical engineer.
Is there a difference between a biomechanical engineer and a doctor?
There is, yes.
In terms of injuries?
Yes.
Tell us about that.
So we really approach injuries from two different directions. Someone has an injury, you go to the doctor, you go to the hospital, the medical doctor will diagnose that injury, determine the best way to treat it, and determine what the prognosis is. As a biomechanical engineer, I look at that injury from a different direction. Here's the injury. Well, how did that injury occur? What type of loading did you need to actually produce that injury? How much force was required? What happened to your body to actually cause that injury to occur? So we approach it really kind of from two different areas. And certainly the doctors diagnose the injuries and determine what they are. And then the biomechanical engineer will come in and we'll look at that injury. And not only how's it produced, but ultimately our hope is to mitigate and prevent injuries from occurring, whether in motor vehicle accidents, sports settings, industrial settings, anywhere there's an interaction with the body and the environment, we want to try and make it safer for individuals.
So you're not diagnosing an injury as much as you are trying to figure out the mechanics and the forces behind the injury. Is that right?
That's right. I'm not a medical doctor. I wouldn't diagnose an injury, but given an injury, I understand the mechanics of how that injury is produced and what you need to actually cause that injury to happen.
Are you also published in the field of biomechanics and or engineering?
I am, yes, sir.
Can you describe that?
When I did my graduate work at the University of Pittsburgh, I worked at a place called the Human Engineering Research Lab. And it was associated with the VA in Pittsburgh as well as the University of Pittsburgh. And so we looked at people with disabilities. Well, one of the big things that we did, or one of the major points, was people in wheelchairs. So if you have to propel a manual wheelchair, you put a lot of stress and force on the arm, the shoulder, the elbow, the hands, carpal tunnel. So we look at the injuries that are produced during those types of events. How can we reduce the force acting on the body for someone like that? So it's looking at, again, how the body responds, how we can set up a chair differently to actually reduce the amount of force someone might experience doing that type of an activity.
So
Have you
cool.
qualified as an expert in the past in the area of biomechanical engineering and human factors?
I have, yes.
In furtherance of, let me ask it this way. Were you asked to engage in an analysis, ARCCA, to be engaged in an analysis of the incident that is currently before the court?
I was, yes, sir.
Did you produce, or did your team produce a report?
Sorry, guys, hang on. I've got to go and get something real quick. You can hear Indy with her thoughts. I've got to go respond to something real quick. I'll be at like 1 minute. All right, and we are back. I apologize, guys. Okay, we're back. Let's continue on.
About your
Sorry, we're going
opinions.
to
Did you
rewind
that
the
is-
beginning of this question.
Let me ask it this way. Were you asked to engage in an analysis, ARCCA, to be engaged in an analysis of the incident that is currently before the court?
I was, yes, sir.
Did you produce, or did your team produce a report about your opinions and conclusions, including the testing and the methodology that went behind those opinions and conclusions?
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the Commonwealth in this case.
That's correct. We were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You've never heard of the Karen Reed case.
I had not, no, sir.
You were contacted by my office after you provided your report, correct?
That is correct, yes.
Were you ever contacted by the Commonwealth?
Not that I'm aware of, no, sir.
And you and I have never discussed the substance of your testimony, correct?
That's correct. We have not.
Would you consider that your analyses, your conclusions and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
Yeah, he doesn't need to
You've not
get
been
that
paid
far.
by the
He's
defense,
already
is
made
that
the
right?
point.
I have not, no, sir.
And you do not answer to us in any way.
I do not. That's correct.
You indicated that you and your team were asked to undertake a review of the circumstances. What exactly did you review in coming to your opinions and conclusions and performing the tests that you performed?
Well, we looked at, there was police reports with respect to the incident, medical records for Mr. O'Keefe, as well as the autopsy report, photographs of the evidence in this case involving the Lexus, the tail light, the incident scene where the evidence was found, as well as some other documentation.
And you also worked with Dr. Wolfe, who just left the courtroom, correct?
I did, yes.
Did you two have sort of a distinct role in, although working as a team, a distinct role in making determinations and conclusions about the incident?
That we did. There was a distinction. Certainly some of our work overlap, but there was a distinction with what each of us actually did and performed with respect to this case.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
And what did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were, the damage that we have to the Lexus, primarily the right rear tail light cover, as well as we performed testing to evaluate the strength of that taillight cover and look at the damage associated with different types of impacts. And also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report and the medical records.
What, generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that. Just generally, Doctor, if you would, please.
Yes, Your Honor. So 24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. I mean, usually about 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
Is that true for any part of the body that is struck, whether it's center mass or an extremity? 1,000 pounds of force because of the speed of the vehicle?
Well, yes. So force is equal, Newton's second law of force is equal to mass times acceleration. So the acceleration is going to be the same. It depends on the mass of whatever body part's being hit. So from the testing that we did at 15 miles an hour, we used a head form, which weighs about 11 pounds. And that produced almost 1,000 pounds of force, a little under that for the head. So anything that weighs 11 pounds is going to produce almost 1,000 pounds of force. The heavier the object, if you get hit center mass, that's going to be even greater force because that's more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body.
Did you review, in furtherance of your conclusions and opinions, did you review records that indicated injuries to both a head as well as an arm, right extremity, right arm?
I did, yes, sir.
Taking those one at a time, is the injury to the head that you saw consistent with having been struck by a vehicle at 24 miles per hour?
It is not, no, sir.
Can you explain why that is?
There's a couple of reasons. First of all, and the main reason is that to get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the taillight, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit because there's no other significant injuries to the body. If there's enough force to cause a skull fracture, then there's going to be certainly enough force to cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing at 15 miles an hour where we dropped the head form. So that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light. And we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Shifting
So
to the
convincing.
arm, are the same forces at play if instead of the head making contact with the tail light, it's an outstretched arm, for instance, at the elbow area of a human being, the person 73 inches tall, weighing 215 pounds.
Objection.
The objection sustained. Ask it differently. Mr.
Sure.
Johnson.
Shifting to the arm, are the same forces at play if instead of making contact with a head, you make contact with an arm, an outstretched arm?
They are. I just explained the force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get that same force, almost 1,000 pounds.
Does the arm weigh the same as the head?
It does actually, almost identical, because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm, is about the same, weighs the same as your head.
So is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling at 24 miles an hour, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
Allow it. Watch the leading though.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that tail light, you're going to get even more significant fracturing, more damage to that tail light at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
Our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay. I want to shift back to the head injury that you saw. Was the head injury that you saw consistent with falling backward from a standing position onto a rigid surface?
That's certainly one of the possible scenarios. That would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly a scenario where you could produce that damage. If someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So I was going to ask, I think you may have just answered my question. Those kinds of force multipliers require a hard and rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force?
Grass and dirt, no, that would certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
Well, I was going to ask him, but what about some ice? What about snow that's actually ice? And he's probably going to say that also probably is not going to do too much unless it's super, super thick ice that's been there for a very long time.
Injuries, I want to shift back to the arm. I know I'm going back and forth, but bear with me. Talking about the arm, if presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can see significant damage on the arm, especially if it hits at that tail light. Enough force to actually cause fracture of that tail light, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of the arm in this case, of the John O'Keefe's arm in this case, correct?
I did, yes, sir.
All right. Were the injuries that you saw on John O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
That's sustained, Mr. Jackson.
You reviewed injuries specific to John O'Keefe, correct?
I did, yes.
Taking that as a hypothetical, would the injuries that you saw, generally speaking, hypothetically be consistent or inconsistent with having been struck by a car at 24 miles an hour?
Objection.
Sustained.
May we approach?
Yes.
Okay. We're going to fast forward through the sidebar.
If you were to presume, for purposes of my question, that an arm was struck by a vehicle taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions with no bruising?
Objection.
Or just what would he expect to see?
What would you expect to see?
So again, I would expect to see significant trauma to the skin, to the bone, to the tendons. I wouldn't expect to see just abrasions, pattern abrasions. I mean, abrasion by very definition means that it's trauma to the skin, which is created through rubbing or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma, that produces a contusion or a bruising. It's not a laceration type injury where we have a cutting injury that actually produces a cut or a significant laceration. It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. I didn't see any of that. Basically just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm, you would have some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at the abrasions that were noted in this case, they all appear to be of the same force, generally the same direction and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Generally speaking, do you look for consistency in size of an object striking a body and the injury that the body suffers from being struck by the object?
Absolutely. Yeah. I mean, size is a big part of it, certainly. Yes.
So did you do any measurements of the size of the taillight, the width of the taillight that was shattered?
Yes.
And what was that width, if you can recall?
I think the width we looked at was maybe 6 inches or so.
In review of your, in coming to your opinions and conclusions, did you look at the arm of John O'Keefe just sort of laid out, straight out?
I did, yes, sir.
Did you see where the injury started and stopped, or began and ended, however you want to put it, in terms of size?
Yes, I mean it started from the upper arm and then extended down into the forearm, which was greater than 12 inches of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the taillight and the injuries that you see?
Objection.
Sustained.
Generally speaking, would you expect if there was an injuring event that the size of the injury would be consistent with the thing that produced the injury?
Yes, generally speaking, you would certainly expect that. And again, you would normally and usually be able to see an initial point of contact, because that's where the most force is going to occur, where it causes that taillight to break. So you would have an area of severe damage, and then it would extend out likely to the edges of where it would contact the rest of the taillight.
From a biomechanics and or a physics standpoint, an engineering standpoint, is it reasonable if someone is standing with their arm extended to be hit by a moving vehicle at, say, 25 miles an hour, and the body, the center mass of the body, to be projected?
Objection.
Ask it differently.
It's a little too
Is it
detailed.
consistent in your view with engineering principles and physics principles that you know, if an arm is hit, extended, not the body, just the arm is struck, for the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's out, we have contact to the arm. I mean, first of all, it's a ball and socket joint. So the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. But secondly, it all depends on your center of mass. The center of mass is kind of the equilibrium point of your body of where your weight's distributed. And for most normal people, the center of mass occurs at your umbilicus or your belly button. So wherever your belly button goes, that's where your body's going to move. They teach this to football players, right? If you're a defensive back and a running back comes around the corner and it's you against him, they tell them or they teach them to watch the waist and watch the belly button. It doesn't matter what your head or your arms do or what their feet do. Wherever their belly button goes, that's where they're going to go. So that's what you want to tackle. So even if you had your arm straight out, again, we said it would move because of the joint. But let's assume you had a metal pole sticking out of your arm, out of your body instead of your arm, and that metal pole gets hit. What's going to happen to your body? It's just going to spin around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's going to basically spin. In order to get that body, or the complete body, over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.
Assuming that a body was struck with enough force at center mass to project that body 20, 30 feet, what injuries would you expect to be produced on that body?
Objection.
Sustained.
If you did have a body that was projected a distance, what injuries from a car, what injuries would you expect to see on the body?
Objection.
I'm going to see you at sidebar the last time on this.
Last time on this, she is frustrated, it sounds like.
May I, Your Honor?
Yes.
Doctor, do you have my question in mind? You need me to repeat it?
Maybe repeat it, yeah.
Easy for you to say. Assuming that a body was struck center mass with enough force from a vehicle traveling at whatever speed to project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries because let's say you're standing forward and you get hit on the right side with a vehicle. You're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you. It depends on the profile of the vehicle, how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV, it will project or push your entire body to the left. So you're going to get initial contact and injuries to the right side of your body. And then if it propels you into the air, you're going to get airborne and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well. And at those speeds, normally you would also see more abrasions, greater abrasions or road rash along the entire part of the body as your body then would slide until it came to the point of rest.
And you did not see that in this case?
Objection.
May I have a moment, Your Honor?
Yes.
Thank you, Your Honor. I have nothing further to say.
Okay, Ms. Tullali?
Okay.
Good afternoon, sir.
Good afternoon.
Now, you, in conjunction with the other doctors on your team that conducted the analysis and testing in this case, you wrote a report, is that right?
We did, yes, sir.
And that report, excuse me, was issued on February 12th, 2024, is that correct?
I believe that's correct, yes.
And within the first paragraph of that report, the last two sentences state,
It's going to do it again.
this analysis is based on
He's going to go through again to say this is an analysis based off of information that we had, and we reserve the right to change our opinion based on more information that comes in later, blah, 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 blah. Okay, let's go through this again. you droned on and bored us with it for the first time. It's going to have the same effect on the jury the second time.
Information currently available to ARCCA and is only to be only to be issued in its entirety. However, ARCCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
I believe that's correct. Yes, sir.
Now, the information that you received and that you reviewed either individually or as a team, that included some state police reports. Is that correct?
Yes, sir.
Some Canton Police Department reports, correct?
Yes,
Some scene photos. Is that correct?
that's correct. Yes,
Medical examiner dispatch removal report. Is that right?
I believe so. Yes, sir.
Some videos from the location of 34 Fairview Road. Is that right?
Yes, sir.
Some photographs of the defendant's vehicle, the 2021 Lexus LX 570. Is that correct?
Yes, sir.
Photographs of evidence that was recovered from the scene. Is that correct?
I don't know how this is helping the prosecution to go through all of the things that they actually went over in order to form the basis of this opinion. Like going through piece by piece it sounds more impressive. It sounds like, oh yeah, they looked at a lot of stuff. They looked at a lot of things in order to formulate this opinion.
That's correct. Yes.
CDR report from the defendant's Lexus.
Yes, sir.
And then essentially there were some other materials, whether they be literature or other things that you and your team of other doctors reviewed over the course
exactly.
of formulating your opinions in this case, correct?
That's correct. Yes, sir.
Now, in regard to evidentiary materials that indicates within the report that were reviewed, you talk about the lens cap to the taillight assembly, the taillight assembly photographs of that nature, and then there's mention of a black straw that was found on scene, correct?
Yes, sir.
There's no mention in the report of either Mr. O'Keefe's shoe or his hat, correct?
Objection. May we approach?
Yes.
I think that probably
You are muted.
Alan Jackson is getting ahead of it this time. He's like, look, he's about to do the same kind of crap that he did before with the previous expert witness. And he's going to try to go into all of these details that he didn't know about or what have you. You know, so he's getting ahead of it. And hopefully we can cut down the time of this cross-examination with this sidebar here. Also, Mountain Princess 207, thank you so much. 717 likes. Can we get 800? Yes, if you guys are enjoying this, we have almost 2,000 people watching right now. That's amazing. If you guys are enjoying the coverage, please do hit the like button. It really does help to push this out into the algorithm so YouTube understands that people are actually enjoying it and it's high quality content. So please do hit the like button. It really does help. And if you are really, really enjoying it, consider subscribing. We are so close to 250,000 subscribers. We're at like 247, 600 something. So we are really, really close. If we can get 250 by the end of this trial, that'd be amazing. Getting close. But anyway, and also if you're absolutely supporting it or absolutely loving it and you want to know how to support it, consider becoming a member of Byte Club so you can join either through YouTube memberships or as a supporter on Patreon. Either way, you get all kinds of perks. Like you get to join for our weekly members only live stream where we casually chat and hang out. And then also early access to our uploads that are not related to this trial. It's a little different, but under our normal scheduling, early access to the videos, and all kinds of stuff like that. So if you guys are interested, consider becoming a member. Definitely helps with all the resources and everything that we've got to put into all this stuff. Otherwise, liking the video really does help because it pushes it out so more people come and watch. And, we get AdSense from all of that too. So that all really, really helps to support it. And also, John O'Rourke, we've also got merch from this trial too. If you're enjoying the memes and the jokes from the stuff that's all coming out from this trial, that we've been talking about so far. We've also got regular Legalbytes merch too, and also stuff from previous trials also. So if you're interested in that, there's a link in the description to our merch store on Teespring. So definitely check that out as well. And mods have been putting the link in the chat as well. Here we go. There's one. There's one right there. If you guys are interested, definitely check it out there. Okay. This is a longer sidebar than I thought. We can fast forward now.
Do you need a couple of minutes, Mr. Lally, or do you need a minute?
No, it's fine now.
He's got to really rethink his cross-examination, I think, based on that sidebar. From what she just said, do you need a minute? Oh, are we at 800 likes? That's amazing. Amazing, you guys. Thank you so much. Let's see how far we can go by the end of the stream. Okay, we're going to fast forward a little longer because maybe he does actually need a minute to say what
Doctor, are you familiar with
Okay.
a term called compression abrasions?
Compression abrasions?
Yes.
Yes.
And am I correct when I say compression abrasions are essentially when direct pressure from a blunt object together with slight rubbing movements produce skin and epidermal crushing? Is that what your understanding of the term is?
Yes, sir.
And you're familiar with patterned abrasions?
I am, yes.
And pattern abrasions are injuries that show a distinct pattern that may reflect the shape of the impacting blunt objects that you may see with reference to injuries that are left by that blunt object. Is that correct?
That's correct. Yes, sir.
Now, as far as in general terms, from what you reviewed, at any point in time, did you look at a state police reconstruction report?
I don't believe that I did, no, sir.
You weren't provided with that, is that correct?
That's correct. I don't believe so.
You weren't provided with any sort of forensic reports, DNA or anything like that, is that correct?
I don't believe so, no, sir.
And you never actually looked at the physical car, is that correct?
I did not. That's correct.
And you're aware that the physical car, being the defendant's car, is still in law enforcement custody and available for inspection if you had wanted to? Are you aware of that?
I think I'm aware of that, yes, sir.
But you never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
Whether it's necessary or not, you didn't make that request, correct?
Yeah, I don't remember if we made that request or not. We obviously didn't look at the vehicle, but it wasn't necessary in this case.
It wasn't
Did you ever look at
necessary.
the actual taillight pieces or the taillight housing, is that correct?
Not the actual. We looked at photographs of the evidence, yes.
Which should be sufficient based on your witnesses, Mr. Lally, right? Like if anyone is going to be able to rely on those photographs, if the jury is going to be able to rely on those photographs, it should be good enough for the expert witnesses to be able to rely on them. Because it's like the insinuation here is you can't make any conclusions about this stuff because you didn't see it in person. So therefore, if the jury, I mean, I know that there's been physical evidence that has been admitted, of course. There's been taillight pieces and glass fragments and the shoe, and they went to see the vehicle, but they went to see it once. But the question is like, okay, most of what they're relying on, like they didn't go to the autopsy, for example. John O'Keefe is no longer around for them to go up and inspect themselves, thank goodness. But like the insinuation is if you didn't see it in person yourself, therefore you can't conclude anything about it. The question then becomes like, well, what about the jury? They're relying on photographs for a lot of this stuff themselves. So, careful how you tread with these kinds of questions.
Now, the injuries that you observed or reviewed in materials in regard to Mr. O'Keefe were primarily on the right side of his body, is that correct?
Well, sir, on the right arm and the posterior aspect of the right arm, yes. And then the skull fracture was a little bit to the right, the occipital fracture.
Also bruising on his right hand, is that correct?
There was bruising on the back of his right hand,
On the
yes.
dorsal aspect?
Yes, correct.
And there was also bruising on sort of the posterior of its right knee, is that correct?
There was a small bruise, I believe, yes, sir.
Oh man. Lally's been gutted. His cross has been gutted. I can feel it. You can hear it in those
Now-
page turns.
With respect to, within your report, you talk about the numerous linear abrasions on the posterior of Mr. O'Keefe's right arm and forearm, correct?
Yes, sir.
And in relation to those injuries, there is a sentence in which you or whoever authored this part of the report, I'm assuming it's you, indicate that furthermore, any such injuries would be highly improbable if Mr. O'Keefe was wearing a jacket, correct?
Yes, sir.
Are you aware that Mr. O'Keefe was not wearing a jacket other than a long sleeve sort of hooded shirt?
I believe that came to light afterwards. Again, it doesn't affect my actual opinions in this case, but it was a sentence added in there, yes, sir.
And so also within your report, same paragraph, you indicate blood and DNA transfer would also be highly probable under such circumstances, none of which were reportedly found on the tail lamp assembly or any of the fractured pieces, correct?
Correct.
Are you aware that DNA consistent with that of Mr. O'Keefe was actually found on the tail light housing from the defendant's vehicle?
I am aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found, I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing.
See, I was about to say that this is an opportunity for a good question on redirect, which is, okay, but did you find any blood? You said that there would have been a high likelihood of DNA and blood. So did you find any blood? Well, no. Doesn't even need to come up on redirect now because he supplied that answer on cross.
There was also DNA matching Mr. O'Keefe that was found on the exterior of the piece of drinking glass that was found right near his body.
I believe so, yes, sir.
And there was also pieces of approximately 1/16 of an inch by 1/16 of an inch of clear and red plastic that was subsequently found to be consistent with the defendant's taillight that was found embedded within Mr. O'Keefe's shirts.
Within the shirt, I believe, yes, sir. Not his actual body.
And so this is all things that you found out after you issued your report in February of 2024, correct?
That's correct, yes, sir.
Now, when you were talking about...
Here's the other thing, the other problem now with Lally seriously overemphasizing at the beginning of both of these cross-examinations, that little blurb at the beginning of their report where it says, you know, this is based off of information that we have. We reserve the right to update this report based on more information that we get later on, you know, to change our opinions, blah, 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 blah. The downside to that is that by overemphasizing that and saying that we have this particular standard, the jury can then look at that and say, yeah, but this guy is still testifying to this now after having learned about this information. Like, he's like, yeah, I since learned about the DNA. What about it? Right? There's no blood. I learned about the DNA, no blood. What about it? In other words, he still has the same conclusion. So if they have that particular standard to say we reserve the right to change our opinions based on information that comes in later, they didn't change anything. They didn't update it. What does that say? That says it doesn't have an impact on their conclusions. So that's the downside to Lally really emphasizing that paragraph and making sure that the jury remembers that, is that kind of reinforces the opinion here. If they didn't change anything, they didn't update anything, and he's now testifying to the same thing that's in the report, having known about this new stuff that they didn't know about at the time that they formulated the report. He's like, it doesn't change anything. And the thing is, on redirect, I imagine Alan Jackson once again is going to say, okay, so there's this new stuff here. Did that change your opinion? No. Okay, cool.
About the injuries to the back of the head of Mr. O'Keefe, consistent with coming in contact with a hard surface, correct?
Yes, sir.
Would that hard surface include if the ground was frozen?
Well, you'd have to perform an analysis actually, because you'd have to determine how hard that ground was. You'd have to look at the freeze and thaw cycle, probably leading up to weeks of that. You can't just look at ground and say, well, it's below freezing, so that ground must be frozen. I mean, is it a possibility? It may be, but you have to go through an actual analysis and procedure to determine how hard that ground is and whether it could have produced those injuries.
So
also, every single time someone says how something, my brain immediately wants to say Haas instead. Like when he's like, how hard that ground was, I'm like, my brain was like, it wants to correct it to Haas hard that ground was.
Is something that's capable of being done by you, is that correct?
Performing that type of an analysis?
Yes.
You could go through and do it, sure, yeah.
And you didn't do it, correct?
No, I did not do it, no. Because, yeah, there's no need in this case. We don't know what happened in this case. There's no indication of, certainly, it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there, and then the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
Oh no, this is such a bad answer for the prosecution. This is such a bad answer for the prosecution. Lally just asked like he's really trying to work through this cross-examination. And that answer was just like, well, okay, sure, we'd have to do this whole analysis into, the freezing cycle and the unfreezing cycle over weeks and whatnot. And he's like, okay, but you didn't do that analysis, right? No one thought to do that analysis. Like, well, of course, there wasn't any information that was provided that seemed to suggest that. And by the way, that still would even be impossible for him to get to that spot in the lawn anyway, based on all of the other information that exists in this case. So, like, it doesn't even matter anyway. Why in the hell would we do that kind of an analysis? Why would we spend our time on that when there's nothing to suggest he could even get to that spot in the first place? There's all these other possibilities as to how that injury to the back of the head could happen. It could have happened here, could have happened there, could have, and he's just like dropping option, which the multiverse of options helps the defense. It hurts the prosecution. And he's like, there's not enough information in this case to be able to distinguish between any of these other options that could have done it. Like, that is exactly the defense case in chief. Like, that is exactly what the defense wants the jury to adopt. More than anything else, more than the framing theory, more than Trooper Proctor and his disgusting text, more than anything else, this right here is what the defense team wants the jury to walk away with, is this right here. And he is the final defense witness. We're probably going to hear some rebuttal witnesses from the defense, but will they make any sort of an impact? I don't know. Maybe not. But this is just like, this right here is the answer that the defense really would love for the jury to absolutely walk away with. Let me get some super chats really quick, and then we'll continue on. I promise. Okay, let's see here. Going on down. Desiree Morgan questioned the digital forensics expert, spoke about a report showing J.O. walked 3 flights of stairs. Do they suggest the stairs were climbed in Fairview House? Yes, that's what the defense is saying. Heather Miller, thanks for the super chat. Okay, more info isn't going to change the physics of a car hitting a person. Don't be mad, Lally, if the feds don't use all the evidence your troopers uncovered, since they can't be trusted. That's another thing. Rebel Duck, thanks for the super chat. I find it hilarious and insulting that Proctor had Karen as the suspect after 16 hours, but CW won't trust independent experts. Thanks for coverage. Of course, right? It's that's the irony of all of this too. And the same thing with their own medical examiner, who after 90 days, she couldn't make a conclusion as to the manner of death. Wingy158, thanks for the super chat. Does Lally have D8 or D10 and rolls for initiative to object and ask questions? If so, he has a low modifier to his stats rolling. I love the D&D reference. That is so awesome. That is so great. And Mountain Princess 207, thank you so much for gifting 5 more Legalbytes memberships, one of our awesome mods as well. So thank you for your kindness and generosity here. KO Nate, Flashfan85, MJ80s, Amanda Coburn, Andrea Fraley, you've all been gifted memberships by Mountain Princess 207. So welcome, or welcome back to Bike Club. Very happy to have you guys here. Hope you can join us for our next members only live stream on probably Friday, 10 a.m. East Coast time, and enjoy all the perks also in the chat and elsewhere too. So thanks once again, Mountain Princess 207. Okay, let's get back to this testimony, because I want to know if there's going to be any more mic drops after this.
You didn't have enough evidence based on what you were provided. Isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
Oh my goodness. What a question. What an answer. I was like, are there going to be any more mic drops? Yes, there are. I had no idea, guys. I had no idea that that moment was coming. But he just said, he's like, even he's like, okay, but the information that you were provided. Well, there was the information I was provided, but then there's also the information that that we were provided since, that we've learned about since. None of that helps. None of that helps your case. Like, sorry, go away. Go to jail. Do not pass go. Do not collect $200. Right? This is just such a brilliant witness to end with. Brilliant witness to end with here. Grizzly member for 1 month. Thank you so much for being a member for a whole month. Hope all of you are having a great day with a Holmes emoji in there. Thank you so much for being a member, helping to keep the lights on, of course. Wonderful members of Bite Club. Oh my gosh. Yes, seriously. This is just, oh, what a disaster cross-examination here.
When was it that you looked at this additional material and who provided it to you?
We were informed after a report was issued that DNA was found. And that was really the primary issue. I believe that some DNA was found on the housing, which, again, there's numerous explanations or ways that DNA can get on a light housing.
Well, let me ask you this, sir. With regard to the materials that you were provided with, was there anything in there that stated that Mr. O'Keefe's skull fracture on the back of his head was caused by contact with the tail light?
No, I don't believe there was anything in those materials that stated
Is there
that.
anything in those materials that indicated or that anyone stated at any point in time that Mr. O'Keefe's arm was outstretched at the time that he was struck by the vehicle?
No, sir, there wasn't.
Was there anything?
I'm sorry, other than your own accident reconstruction expert? Other than him? Okay. Other than like the people that you put up on the stand, that you reviewed his report, your own accident reconstruction expert, you reviewed his report, you reviewed his testimony, you met with him ahead of time, you knew what he was going to say, and you were like, yep, this is what we're going to go with. Go up there, sit on the stand, and say that. Okay. All right, cool.
In there indicating that his arm was tucked in at the time that he was struck by the vehicle?
You know, there's no indication in any of that evidence of what he may or may not have been doing, how he may or may not have been positioned. I mean, that's the whole issue. There's no evidence to indicate what may have allegedly occurred in this case.
Now, a typical pedestrian collision that you see through the course of your work involves a pedestrian being struck by the front of a vehicle. Is that fair to say?
I see all types of different people getting run over backwards, cars spinning, hitting sideways, frontal impacts certainly occur, yes, but we see pedestrians getting struck by all parts of the vehicle.
I'm sure you see all kinds. What I'm asking you is predominantly when you see a pedestrian collision, the typical pedestrian collision would be a pedestrian crossing a road in front of a vehicle as it's approaching. Is that correct?
That's certainly not uncommon, yes, sir.
Now,
really quick, El Bori, thank you so much for gifting 1 Legalbytes membership. So kind and generous of you to give the gift of membership. So Danny T92, welcome to Bite Club. Very happy to have you here. And hope you can join us also for our members only live stream coming up this week, and enjoy the perks too. Definitely make use of those member emojis too. Those are so much fun.
as far as, I believe you described a little bit on your direct testimony, as far as there's differences in the type of injuries that you would expect or anticipate depending on how the vehicle interacted with the pedestrian in a pedestrian collision, correct?
Yes, sir.
And as far as, you familiar with what's called a sideswipe collision?
Yes, sir, I am.
And am I correct when I say that in a typical pedestrian collision with pedestrian crossing in front of a vehicle, there are a number of different types of interactions as far as a wrap and a forward projection versus a fender vault versus a number of different ways that a pedestrian can interact with the front of a vehicle, correct?
It depends on the position of the pedestrian and certainly the profile of that vehicle and the speed of the vehicle. Yes, sir. There's many different factors involved in it.
And so in a typical pedestrian collision, when a pedestrian is struck by the front of the vehicle, that involves more of an assumption of the velocity of the striking motor vehicle by the pedestrian than you would expect to see in a sideswipe collision, correct?
Well, I mean, yes, generally speaking, a sideswipe means that the person or the pedestrian in the vehicle don't obtain a similar or common velocity. So if you're standing in front of a car and it hits you, it's going to speed you up to that same speed and then disengage. Sideswipe means that there's not this mass-to-mass impact. by its very nature, sideswipe has minimal forces. We see it even between vehicles that just rub against each other. So if there's a sideswipe impact with a pedestrian in a vehicle, there's going to be very little damage to the pedestrian. And similarly, there's going to be very little movement. There's really no force at all acting. For instance, if a car came and swiped by your arm, but didn't have enough force or enough contact to cause any damage, well, it wouldn't actually cause any movement of the person either. So a sideswipe by its very nature involves minimal impact, minimal forces, minimal velocities.
Also,
This is not going well for the prosecution at all. He's trying to find something that I really think that Lally right now is just trying to find some kind of a question and answer that he can get that isn't the worst thing ever for the prosecution for him to end on. Because you want to end with some kind of a response from the witness that is going to help you, some kind of showing of strength at the very end, because you don't want to just walk away after being completely demolished by a witness on cross-examination. That is what's happening right now. So I think he's like searching for some way to end this in a way that is not as embarrassing.
Saying with in the report that you at least co-authored, there's an indication that Mr. O'Keefe's injuries, at least to his skull, the fracture to his skull, are consistent with him having been pushed or possibly been impacted by the subject Lexus and fallen backwards, striking his head. Isn't that correct?
Yeah, so that's another possibility.
Sorry, sir, yes or no?
No, let him answer.
Yeah.
Let him answer the question.
So if we're saying that there's enough force if you fall backwards to strike your head and cause that skull fracture, well, he could have slipped and struck his head. The car could have backed up and not known that he was there and nudged him and caused him to fall. I mean, any event that would cause him to fall backwards obviously would result in him striking his head. So there's numerous, almost infinite possibility of different scenarios that could result in that type of an event.
Almost infinite possibilities. Almost infinite possibilities as to how, and that's, by the way, not inconsistent with what the medical examiner said. Not inconsistent, because she said, we don't know. We don't know what it was that caused the that came in and actually hit his head. We don't know. There's no evidence that can tell us that. I mean, almost infinite possibilities is what he says. This is just like, I mean, he's gutting it. He's just ending the note with just gutting the case.
Thanks.
Mr. Jackson?
Nothing further.
Okay. Dr. Rentschler, you are all set, sir.
Oh,
Thank you, Your Honor.
Okay. Jurors, I want to see
man.
counsel for the last time at sidebar right now.
Sidebar. Okay. What is going to be? I mean, it looks like the stream is actually going to end.
You are unmuted.
Thank you, Your Honor. With that, the defense rests.
Okay.
Defense rests.
Jurors, that is the evidence in this case. After all these weeks, that's the evidence that you will hear in this case. The lawyers and I still.
So there's no rebuttal? I thought that the prosecution was going to find a rebuttal witness for the dog bite, or at the very least, I thought there was going to be some attempt at rebuttal witnesses. Oh my goodness. Oh my goodness. That was the last witness that they hear in this case before closing arguments. Oh my God. This is devastating for the prosecution. Devastating. Absolutely devastating for the prosecution to end with that witness, with that testimony. Yeah, of course, Jackson didn't want to do a redirect. That was perfect. His answers were perfect at the end to leave that. Remember, primacy and recency latency effect, right, of your memory. You remember the things you heard first, the things you heard last, ending with this witness who's like, there is literally infinite possibilities as to what could have happened in this case, because there is not enough evidence to suggest anything, like anything, literally anything could have happened in this case to cause these injuries here. I can't possibly give any kind of an opinion as to what could have really happened other than like the many possibilities in all of the different multiverses that exist in this world. So Buttercup 203, they aren't rebutting Dr. Russell. They apparently are not. Okay. All right. I'm so flabbergasted. Let's let's hear what she has to say to the jury in terms of the instructions. I'm wondering if maybe the afternoon is just going to be a back and forth over jury instructions. Maybe that won't be televised. If not, then we might be done for the day. Actually, I had the whole afternoon stream planned and everything that this was going to redirect into, but I might have to change that. But okay, so we're going to listen to the judge's instructions here on like what's going to happen next, and there may be closing arguments tomorrow.
We'll have work to do for tomorrow. But tomorrow morning, we will have closing arguments of counsel. They'll get an hour apiece to be able to argue this case to you. I'll instruct you on the law, and then 12 of you will begin your deliberations sometime tomorrow. Okay, so with that, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. We'll see you tomorrow.
Wow.
All rise for the court, please. Follow me, please.
Wow. Oh my God. That was just like, right now, I wouldn't be surprised if in Lally's head the song was playing. Hello, darkness, my old friend. Oh my goodness. Oh my goodness. That was insane. To end on that note. Okay. All right, folks. Yeah, I've got questions about the poll also. So we've got the fan spinning. We'll end that there. We'll get these over here. And we're going to answer some questions and whatnot. So okay. Let's see here. Let me get the questions here that are all right. Cool. All right. I'm going to leave the poll open for just a little bit longer and then we'll close it out. Actually, no, now's a good time to end the poll. And we will, I'm not going to start a new one because I want good numbers for the poll so it's more accurate. But tomorrow, going into closing arguments, we'll totally do the poll then also. So, we'll see what the numbers look like going into tomorrow after today. And yes, Ice Cool 2020 closing arguments will be next. That'll be tomorrow morning. So we won't have an afternoon stream. So we'll get these questions done. We'll be done for the day and we'll move on to tomorrow. So throw your questions at me. Let's see how that's going. But also we've got 2,300 people, over 2,300 people in the chat right now. Awesome. Wonderful to see that. How many likes do we have in the chat here? We've got 961. Can we get to 1,000 likes? That would be amazing. If we could get to 1,000 likes in the chat, that would be so great. Okay, let me get these other questions here. We've got more here. Oh wait, actually, yeah. So I will collect your questions here, and with the chat moving quickly. Okay, sorry. I want to make sure that I try to catch these while I'm also answering at the same time. Sometimes I get a little distracted, but yes, if we can get to 1,000, that would be amazing. That really does help with the YouTube algorithm gods and all the things as I've been talking about. If you guys can like the stream, that would be amazing. The Lucian. Here's a question from the Lucian. Legalbytes, can we have Dr. Rentschler do closing arguments for defense? We don't need him to. We've got Alan Jackson that's going to be doing those closing arguments. So that is going to be very, very spicy. Oh, did we hit 1,000 likes? Awesome. Thank you so much, you guys. That is amazing. I love to see it. Okay. So I'm going to try to make sure that I get all these questions. Chat is moving pretty quickly. So if I miss anyone, I apologize. Okay. All right. Let's get the next question here. Jerry Roth, Legalbytes, Lally is another victim of FAFO by not doing research and I hope there wasn't a second chat after that. But yeah, I mean, yes, if you are not familiar with the law of FAFO, or FAFO. Here it
See,
is.
as you can see, the more you around, the more you're going to find out.
I love that meme so much. I love it so much. But yes, it does. It does feel that way. Okay. Pula and Ivis. Legalbytes, maybe they looked for a rebuttal witness and all of them said, I think Dr. Russell is right. That would be rough. Yeah, I mean, it's possible. It's really possible. They said that they thought that they could find someone in a week, but I don't know. Maybe not. A week is actually not that much time. Jenner D, well, the crime scene lied to Trooper Paul. I think it did lie to Trooper Paul. I think it definitely did. And Travis James, OMG, not on my bingo card. Yeah, I didn't expect that either. Ashley Wynn, Legalbytes, sorry if this has been asked before, but do we know what the family thinks? I don't know. I personally don't know. I don't know what what their personal opinions are, other than I've heard that the brother has been pro prosecution. That would be John O'Keefe's brother. So, but I also heard something about like someone in the courtroom, I guess, observed that after the medical examiner testified or something about the brother got up and discussed or something because he kept getting promised things by the prosecution, like just wait. We've got bombshell evidence that proves our case. I don't know if that's actually true, but I don't know. It's possible. Other than that, I don't know. I don't know what the family thinks one way or another. And I don't know if that's changed throughout the trial. Holly B, deliberation time guesstimate. Well, keep in mind, this trial has been going on for like 2 months and there is a death involved. So anytime there's a longer trial and it involves death, either of those two individual factors can factor into a little bit of a longer time in deliberation, because especially when there is death involved, they're going to want to go through things, talk through things, make sure that they have, come to the right conclusion, not too hastily. They want to pay respect to the victim and the victim's family oftentimes. So those are factors that could slow things down, but they also could get in there and realize that everybody has the same conclusion and it's common sense among everyone and no one has to convince anyone else, in which case that would be super fast. So either one of those options. I know I apologize that this is like not much of an answer, because it's like it could be this or it could be that. It's very much of a lawyering kind of answer. But it really could be either one. I've been surprised sometimes at how fast something comes back, and then I've also been very frustrated with how long something takes to come back. So, getting some sort of an estimate on it, based on how strongly we feel about what the evidence says, may not necessarily be the same as how, any of these individuals on the jury feel about it, and how even if they feel very strongly about it, being like, well, I still want to talk about it because this is a very important case, so yeah. Flash fan 85. Legalbytes, what's your prediction for verdict watch? How long do you think it'll take? Do you have a prediction? Like I said, I don't know. I could see it going either way. FlashFan85, also member for 10 months. Thanks for being a YouTube member for 10 months. Member of Bike Club. Hey, favorite law tuber, thanks for being so awesome. Do you think the state will have rebuttal? Well, I mean, I'm sorry I didn't answer this before. I thought that they would. I thought we would see at least one rebuttal witness that would be a dog bite expert, but apparently not. So, crazy. Alex025, thanks for the super chat on this final day of testimony. Can we get a final reminder on what the prosecutors and defense were arguing for this case? I don't know if I worded that right. So, the defense is saying Karen Reed was framed by the Alberts and the McCabe's and Trooper Proctor, and perhaps other people that were part of the police force as well. I think they're also arguing that on top of that, there was a very shoddy investigation on which you cannot rely at all. They're also saying that there's just not enough information that has been presented that can that anyone can rely on to be able to convict someone. If there's any reasonable doubt in this case as to what happened to John O'Keefe, this is still an open question, in my opinion, is what happened to John O'Keefe? How can you possibly say, based on the injuries that he sustained, based on where he supposedly was found, based on where those different taillight pieces and the shoe and all that other stuff happened, based on the fact that the glass in the bumper does not match the glass in his hand, how can you possibly say that all of that points to Karen Read was guilty? Just looking at that stuff, aside from what people testified about, what they heard, what they remember, memory is faulty. A lot of times jurors are going to look at the more objective evidence and rely on that more so than what people testify about their memory and what may or may not have biases involved and things like that. The fact that none of the more objective kind of evidence, that's the scientific evidence, the forensics, the fact that stuff points to the fact that, there was John O'Keefe around the vehicle at some point. Surprise, surprise. They were in a relationship for how many years? The fact that his DNA is on the car is not really all that surprising. And it doesn't necessarily mean that it's from a collision. It could be because he happened to walk around the car at one point in the parking lot, kind of dragged his hand across the back of the SUV and left his DNA that way. How do we know that it wasn't something like that happened? How do we know that it wasn't because he helped her get groceries one day, the day before or something, and, touched stuff on the back of the car to help her get groceries out of the car? How do we know it wasn't something like that? There are too many possibilities to say how that DNA got there. The fact that there wasn't blood there is very helpful to the defense. But the prosecution is, their argument for this case is, mostly what it comes down to, the way that I see it is, trust me, bro. Trust me, bro. Trust me, bro. The red Solo cups don't matter.
Solo cup, I fill you up.
The fact that there was snow everywhere is what matters. The fact that, we know all of the routes that everybody took to get to this particular location is what matters. All of the focus was on all of the wrong stuff. They threw up the spaghetti on the wall, but it's almost like they forgot which kind of spaghetti to use on the wall to make it properly stick. They didn't even do that amount of analysis to try to figure that part out, it seems like. And my fear for the prosecution's sake tomorrow is that the prosecution is going to get up there on closing argument and they're going to try to throw all the spaghetti on the wall again, see if it sticks, but they're going to bore everyone to death and not direct them to focus on which pieces of evidence are the most important. That's what I think is going to happen. So anyway, I don't know if that properly answers your question, but we'll see exactly what they argue tomorrow. The thing about the prosecution's case too is that their argument has changed since the beginning. All the way to Trooper Paul's testimony, right? That doesn't match, right? He said that all of those abrasions on the arm are from the taillight. I thought we heard at the very beginning about road rash from Lally. So whatever happened to the idea of road rash? Where did that come from? There was no evidence to suggest that. Why was that even argued in the first place? It makes zero sense to me. So expect something from the defense to say something along the lines of, they're moving the goalposts on you. At the beginning, they said this. Then the evidence showed this. And now they're arguing this. They're supposed to be the ones proving this case beyond reasonable doubt. And they're moving the goalposts on you. Again, after surprising you, after trying to sneak all this kind of stuff in front of you. Yeah, it's going to be a very, very fiery closing by Alan Jackson. Laura Lee Annie, thank you so much for becoming a YouTube member, supporting the channel, helping out with making sure that we've got resources for all of these trials and all the topics that we want to cover on the channel. Thank you so much. Welcome to Bite Club. Very happy to have you here. The Black Pope, thanks for the super chat. Crazy, the defense proved their case beyond reasonable doubt. I mean, but they didn't even need to. They didn't even need to, right? Because they don't have the burden in this particular case. Sarah Beth, question: how can Lally bring up microscopic plastic that wasn't testified to by the lab people and mention DNA without adding 2 unknown profiles as well? It's lies. I mean, it's that is something that can come up, right? You can say that it, DNA matched 2 unidentified people as well. And that's fine. Like I've seen cases where that has been the case. However, where it is convincing that it says, the DNA matched the defendant and 2 other people, or the DNA matched the victim and 2 other people that we don't know about. Where that's convincing is where we're talking about a victim and a defendant that don't ever come in contact with each other, don't have any reason to come in contact with it, maybe even are avoiding each other, have not seen each other for a very long time, or have never seen each other before. Like that is where that kind of evidence becomes very compelling. But where you've got 2 people that are like living sort of in the same house, at least part-time, spending a lot of time, sharing a lot of DNA, presumably in all kinds of ways, not suggesting anything weird, but just like, they're spending a lot of time around each other. And, she's spending time with his kids in a sense, right? His niece and nephew. It's just the idea that like, oh, okay, so you found his DNA around her stuff. Big whoop. That's not compelling. So the idea that there's these 2 unknowns, obviously it would have been great to for the prosecution at least to be able to say, well, we also tested, we took swabs from all of these other people and it doesn't match any of the Alberts or the McCabe's either. That would have been very helpful to the prosecution to be able to rule them out definitively. But now it does also introduce a question because there's been this theme of the investigation didn't do enough. The prosecution didn't do enough. There just has not been enough on that side of the ledger in order for them to be able to hang their hat on it. And it introduces, space for all these questions when they have these 2 unknown profiles, because there just are so many spots in this case where they just haven't been able to say that they have fully gone down the road that they should have before making a conclusion. Wingy158, question: does the taillight damage look like someone bashed in the taillight? I mean, that's the jury's going to answer that question, right? To me, I don't know, because it's been shattered in all kinds of ways, but it doesn't quite match the ways in which it looked earlier on in the day. Also, there's that kind of an issue, which that can indicate someone bashed in the taillight. So there are ways that you can approach that question and come to a conclusion. And I'd be very curious to see if any jurors speak afterwards about that. Sue B, question: so Karen Reed lucked out because she doesn't have to pay for these 2 witnesses? Yes, she did. She lucked out there on that portion. Quentin Smith, question: why did the feds commission all this research? Isn't the Commonwealth's malpractice malfeasance if any, unrelated to KR's guilt, if any? I think that what they are also looking into is the quality of the investigation itself. If I'm chat, correct me if I'm wrong on that. Some people in the chat probably know better than me because they've maybe been following this case for much longer than me. But that's my understanding. That's my understanding of the circumstances here, is they're also looking into the quality of the investigation, in which case they would also be looking into like, have they properly looked at like whether this is even possible. Mr. Buckshot, question: does Karen get any restitution for illegal fees? No, there's none of that, unfortunately. JB, thanks for the super chat. Given his strained relationship with the Alberts, why did John O'Keefe go to the Alberts' house? Because he was drunk? I don't know. I mean, maybe it was strained, maybe it wasn't. I don't know how convinced I am that it was in fact strained with them. Maybe he didn't quite know them all that well, but that doesn't necessarily mean that you're not going to go to somebody's house if you're like, in the beginning stages of getting to know someone. It makes sense to go to their house, because how else are you going to get to know them more? So But maybe he was drunk. Maybe that did influence his desire to go and hang out with them also. All right, Dionysia Jaclo, Legalbytes, if Karen's found guilty here, can the feds intervene? Well, they kind of already are. That's the whole reason why those last two experts got involved as well. Joel Somerville, will the prosecution be providing a dog bite expert? I thought they were, and then they didn't. I was shocked. Mr. W, Legalbytes defense is short and sweet with their witness questions, but is there a disadvantage to being so quick? I mean, if there's something that you should have covered that you neglect to because you're going too fast, I can see that. But generally speaking, it's better to have a short and sweet case because you hold the attention of the jury more if you have a little bit of a faster pace. I mean, this is why, for example, like during direct examinations by Lally, at some point I started to put it at 1.25x speed because for me it was going so slow, it was making it harder for me to pay attention. So that was trying to aid in my ability to actually get the information better, was by moving it a little bit faster. So generally speaking, I think having things short, simple, to the point, you're also training the jury that everything you're putting in front of them is important. Because otherwise, if there's too much fluff, you're training the jury to say, okay, there's stuff here that I don't need, that I can disregard. Then the question becomes, where does the jury then decide what's important, what's not important? That's a very risky thing to do, is to give that decision to them rather than telling them everything I put in front of you is important. Going on down here, just because, Legalbytes, do you think preloading the rebuttal was a huge mistake? In terms of, what do you mean by that? Do you mean by not doing a rebuttal, or maybe suggesting that there was a rebuttal and then not doing one? I'm not sure that I fully understand your question, so I apologize. Maybe ask a little differently, and I'll try to capture it. MJ80s, Legalbytes, what would your three main points be for a closing statement for the CW? It would be emphasis on the I hit him. So all these people heard her say it. She said it. She definitely said it. It would be something like that. That would be one of the things that I would definitely focus on first, is the I hit him, because that seems to be the sort of thing that tends to stick with people. But other than that, it would be less focus on forensics, focus on the fact that, everyone agrees that there was a blunt force trauma to the head, and that's kind of how he died. Also her voicemails, trying to make her sound very hysterical and angry, as if she's still angry after hitting him. Maybe focus on that, focus on the Aruba incident, I guess, that she had all this motive for it. I guess it's hard, though. It's really hard because there are so many inconsistencies in this case for the prosecution, partly because they've put on so many witnesses, and the forensics don't help them at all. Like, the digital forensics really don't help them all that much. The medical testimony helps them only to the point that it also helps the defense. So, I don't know. Okay, just because I'll get this question now, since it's connected to your question before. Legalbytes, by anticipating the defense case and not taking time to rebut the case and get the benefit of recency of argument, do you think Lally lost a lot of points with the jury and the public? Well, I think that by trying to rebut so much of their argument throughout their case in chief, they ended up spending so much time there and not enough time on building their own case in chief, on building, like, this is how Karen Reed killed John O'Keefe. Like, there just wasn't enough energy spent on that. So it was to the detriment of their own case in chief. So, maybe they could have figured that out by saying, we're going to reserve these other witnesses for rebuttal, as opposed to putting them up front. Like I that could have been a good thing to do, is, put up your witnesses about the Hoslong to die in the cold, put those up on rebuttal as opposed to in your case in chief. Because then it also kind of confuses the jury about, like, what is this case really about? Is it about the Google search that Jen McCabe made, or is it about, the actual mechanics of the car hitting John O'Keefe? So too much focus was placed by the prosecution on these other matters that were actually not really centrally important to the prosecution's case in chief and proving their own case. So yeah, maybe could have benefited by reserving some of those people for the end. Schmelexa 24 question: who will get a better gift, Proctor's from Julie Albert or Lally from Jackson and KR? Oh, that would be so mean. That would be so mean if they sent Lally a gift. Oh, that would be terrible. Jerry Roth, Legalbytes, how long do you think, Hoslong, do you think the jury will deliberate for tomorrow? I don't think that they will come to a conclusion tomorrow. I would not expect that. I would expect them maybe on Wednesday. That's what I would say. Chad. And even then, like, I would give it maybe a full 24 hours for them to conclude. If it's faster than that, hey, that's fine. I'm totally fine with being wrong on that. Because like I said, juries can take all kinds of different time limits on coming to a conclusion. Chad, Legalbytes, I still don't understand how the qualified Dr. Russell was relegated to just testifying to the dog bites when I feel like she could have done and covered Dr. Sheridan's testimony too. Well, they had already gotten Dr. Sheridan in as an expert. And I think that his testimony was also really, really good today for the defense. I mean, obviously for the defense, but I think that he also had a really great series of explanations about the case. And I think that probably also the decision to have her just do the testimony, about the dog bites, that also probably had a lot to do with the fact that she came in so late in the game, that you have a lot less time to get someone up to speed so that they can really do a full testimony or, give a full opinion on all of these other things as well. It's better, like, if she's a late addition, get her just under the narrow scope of this particular thing. It also makes it a lot easier to argue to the judge that this is appropriate to let her in because it's just on this one thing. They don't have anyone else, really testifying about it. And, and therefore, this is somebody who is necessary. She just showed up. This is helpful to the jury. So, yeah. Melissa Garcia, question: the glass on the bumper not matching the glass under him. Do you think he threw his original glass, went inside and got a glass from inside the Albert home? It's possible. I mean, because here's the thing. Remember, like, there's all this emphasis by the defense that no one went into the house to investigate. No one ever searched the house. No one ever looked at what kind of glassware they had inside the house. They definitely had asked that question of at least one of the investigators. And that may come up on in closing arguments too, to say doesn't match. The one in his hand doesn't match the glass on the bumper and the glass on the ground, closer to the street. So how do we conclude, or how do we count out the possibility that glass is from inside the house? Like, there's just so many open questions. So many open questions. All righty here. 50 Shades of Gray. Thanks for the super chat. Shades of J, not gray. Okay, let's try that one more time. 50 Shades of J. I can do this. Thanks for covering the trial. Love the knowledge and reactions. Thank you so much. Really, really appreciate that. Thank you. Right. And other questions. Okay. So, right. Nothing to collect. Let's answer some more here. We got so many. Valerie Lynn, question: was there no home surveillance video at the Alberts home? Sounds unbelievable. Apparently there weren't. Apparently no ring footage. Flashman 85. Legalbytes, I hear that the longer a verdict takes to come back, it's usually good for the defendant. Is that true? I think that generally is true. A speedy response tends to favor conviction as opposed to acquittal. But I wouldn't necessarily say it's a 1-to-1, like A, therefore B. You could theoretically have a very quick reaction where everybody on the jury just agrees and they say, yeah, they have not proved the case. Yeah, there should be an acquittal here. LK Raiden. Legalbytes, I wonder if Lally has seen on the jury that there is no point. Maybe. Could be. Nick Wilson, Legalbytes charge conference is 2:30 p.m. Oh, that's interesting. Okay. Well, I don't know if it'll be, I presume it won't be live streamed, at least not on this particular stream. Travis James, question, can we get a collaboration with Brandy and Kurt tomorrow? Yeah, we can definitely get some kind of a collaboration going. Brandy and I were definitely talking about that, also doing some sort of a dual stream and maybe having some guests on or something if that's possible, for sure, because that would be such a great time to really talk to people about the whole case afterwards. So definitely looking into that for sure. Jay Darkman, Legalbytes, I used to do Muay Thai like 10 years ago, and I remember the first defense training we had was how to fall, and the lesson was tuck your chin in when swept. The back of the skull is soft. Interesting. That is very interesting. Let's see here. Mountain Princess 207 was everything suspicious. I know what you're getting at.
Don't be suspicious. 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 Don't be suspicious.
John Ralphio?
I love it. I love it. Elle Bort, I don't know why that screen is frozen with Indy's face. She has since moved. Elle Bort, Legalbytes, what is the order of closing, prosecution, then defense? Yes. Okay. Thank you for this awesome question. So same procedure as opening statements. It's the two bookend each other perfectly. You start with the prosecution because they have the burden of proof. Then you've got the defense that responds to the prosecution. Then the prosecution has the option of reserving some of their time from the very beginning on rebuttal so that they can respond to the defense closing arguments. So I fully anticipate that Lally is going to reserve some time for rebuttal. He would probably want that, but how's it going to go? I don't know, but that is generally the ordering of things. Buttercup 203 question. Let's rate very best plus 4 CW witnesses. Oh my goodness. Best. Okay. Best CW witness. For me personally, I would say either. What was his name? Robert Nicholas or Robert Nichols. He was the guy that did the blood alcohol testing analysis, like the calculation side of it. He was great. He was really great for the prosecution. So he was one of my favorites. I also really like Dr. Stonebridge. However, I will say, as much as I like Dr. Stonebridge, I liked Dr. Sheridan for the defense more because he kept his testimony to plain English. He really limited the words, like the medical terminology that he used, because medical terminology is great for impressing someone, right? To show I absolutely know what I'm talking about. But you can also do that by just explaining things in a way that people can understand and follow your logic. But, his use of like plain English, I think made him a better expert witness than Dr. Stonebridge and also a Dr. Scortibello as well. So, that would be, yeah. But anyway, they had a few good witnesses. The worst witness probably for the CW, Jen McCabe was pretty bad. She was pretty dang bad. Trooper Paul, I would have to say he probably was the worst one though. The worst one, because it was so important to have him testify well for causation. So that's got to be, and Trooper Proctor too was also really bad. Haley Mouse, question: do you think Lally will try saying things not in evidence in his closing? It's possible. It's certainly possible. But if he does, that's a valid objection. Mr. Buckshot, question: 2 to 4 males touched DNA on JOK and 4 males were confirmed in the house, but Proctor doesn't think that's significant to swab them too. I agree. LK Ryden, Legalbytes, question: where do you stand on conspiracy / what actually happened now? There are aspects of it that I agree are still very suspicious. The taillight pieces, that's something that feels like wrong, like something happened there that was maybe dirty. There's been enough that I've seen that looks dirty. You know, that and the inverted surveillance footage from the Sally port for some reason. Like why was that? Why? What's the point in inverting it? There were just so many weird things there that makes me think like maybe, you know, there's a possibility that, you know, maybe the police had really wanted to try to emphasize this finger that was pointed at Karen. I don't know whether the Alberts and the McCabes were central to it. Jen McCabe certainly seems like the type to want to control a narrative. She showed that in her cross-examination, especially. Like, she didn't want to answer a single question without seeing what was in Alan Jackson's hands first, so that she could control the narrative. That was like what she was trying to do. That's how she came across. But, you know, I don't know how the framing would have started. I don't know. The thing that I am most comfortable with concluding is that the prosecution didn't do nearly what they should have done, and this case should absolutely never have been brought. Patrick Barrett, question: as far as cases you have seen, where does this fall on the list of craziest cases? This might be the craziest, to be honest with you, because it's just such a bad, like, it's just such a terrible investigation, and just everything through and through was just so horrible. I was expecting so much more out of the prosecution. Valerie Lynn, question: who is Karen Reed? I mean, what was her occupation? Is she wealthy? So she yes, wealthy, high income is what I understand her to be. She was a professor, probably isn't right now. She's probably unemployed, to be honest with you. But she was a professor at a time, and also at the same time was working in finance, some kind of job in finance. I can't remember exactly what, but my understanding is she was independently making her own money, and good money. Rhinus, Legalbytes, question: if J.O. went into that house to confront Higgins about texting and kissing KR, is there a legal reason for the defense not to bring that up? You know, it's actually, yes, well, maybe not a legal reason, but it's better for the defense not to bring that up, because like, how do I explain this? You don't want to overplay your hand either. For the defense, it's good enough for there to be a multiverse of possibilities. They don't have to put their hand down on any singular theory other than Karen Reed is framed. Like, that's a pretty strong one for them to go with. Then, you know, they don't need any particular narrative to be more true than others. For them, it's good enough to say this is a case where so many things are possible. There's not enough evidence here to be able to point the finger at her. So sometimes if you overplay that, though, you can end up like sort of I'm really struggling with my explanation here right now. Basically, you can end up trying to tell the jury, trying to like overemphasize something to the jury that they end up seeing through, and they're like, but now I kind of question what you guys are doing. It's better to sort of play a limited game sometimes and just allow them to be like, there just are too many questions. 0.0, thanks for the super chat. Haas long for a defense verdict. Could be hours, could be days. Yeah, I don't know, but thanks for the super chat. Megan Rose, thank you also. I've been away. Where are they witness wise? Finished. Finito. We're done. No more witnesses. Defense closed their case in chief. They rested their case in chief, and the prosecution didn't have any rebuttal witnesses. It's crazy that we're there now. Going on up to the questions again. Flashfan 85. Legalbytes, sorry, autocorrect misspelled your name off topic, but I wanted to let you know that the Black Swan trial is due to start next month. Just want to let you know before I forget. Yes, I do. I think it's like the 22nd or something is what I have on my calendar. So that may be another option as well later on. But we've also got Baldwin. That one I am for sure doing. Sue B, question, what was the total amount of prosecution witnesses? 68. 68 prosecution witnesses. 68 and...
It's been 84 years.
And 84 years. Sheena Ford, Legalbytes, are you going to be live for Verdict Watch? Probably. I think so. Well, definitely. I mean, as soon as there is a verdict that is rendered, yes. But I'm probably going to be sitting and conversing and asking questions and going over stuff as well. So I'm going to take a look behind the scenes and see what I can do to get that organized. Rashi Sikarwar, question, I still don't understand how the taillight pieces were found at the crime scene and on his clothes, especially in comparison to like the photos of the taillights that don't quite match all of those pieces being gone. Nick Andrew, Legalbytes, when the defense witness said the small taillight were on the clothes but not in the body, is this a big moment? Those microscopic taillight pieces, actually, now that the jury has heard this theory at the very end about the glass smashing the taillight, there is a possibility that those taillight pieces, tiny taillight pieces, could have ended up on his clothing, not because he was hit by the taillight, but because he threw a cocktail glass at it, and some of those pieces came onto his clothes. The tiny pieces, right? That's possible. So the jury may have that in their heads. Sheena Ford, question, what happens if the judge disagrees with the verdict? It depends on why she disagrees with the verdict. To overturn a jury verdict takes a lot. It has to be that the jury has done something really improper. Something like, they were talking to witnesses outside of court, or they were bribed, or they, as it turns out, they lied during the jury selection, and they actually knew a bunch of people, or they knew about the case and they had already formed an opinion, and they snitched on themselves by saying something to somebody. There are things like that could take the decision away from the jury. And the judge can also say, like, this is an unreasonable verdict. There's no way that the jury could have come to this conclusion. But that's not possible in this particular case. Like, her decision would be, if she were to say that would be looked at with high suspicion as well. And I don't think that would stand. So, the likelihood of a jury verdict getting overturned is like almost zero. Patrick Barrett, Legalbytes, as far as cases you have seen. Oh, where does it fall in the craziest ones? I answered that one. Also from Patrick Barrett, what can Karen do to get justice if it's proven she was framed? Go on a book tour, like go on a media tour, documentaries, things like that. That's helpful, to get the word out for that. Maybe start up a whole political campaign to enact change in the criminal justice system or in the police force in the area. Oh, is there a charge conference right now on long crime? Okay, hang on, guys. Let me see. Give me a minute here. So, yeah, it looks like they are live in the courtroom. Okay, 1 second here. I mean, this is so far just on John O'Keefe's brother inside the courtroom. So, okay. And there's no sound to it. All right, well, we'll leave this up while we're going through these. Joshua Marshall, question. Any Law 2 friends in court today that you know of? Not that I know of. Gunnar Dennis. 30 days and 30 minutes, not guilty. That is a very, very fast, that's a very fast result. Okay, Nathan Gross, Legalbytes, did you play that meme, don't be suspicious a single time during the defense case? I don't think I did. Karan, Legalbytes, not sure if you answered, but do you think if she's acquitted of second degree, do you think any other charges will stick for her? Let me think on that one. I'll have some thoughts on that for tomorrow. I don't see any charges sticking for her right now, but maybe the DUI charge, that's the most likely. But even that one, I don't see that one sticking. Patrick Barrett, Legalbytes, are either sides allowed to object in the middle of closing arguments? Yes. However, it's risky. You want to make sure that you're right if you are going to object. If you don't, then everybody kind of looks at you with annoyance, like you are just trying to interrupt the proceedings and being rude and all that kind of stuff. So you want to be very careful if you are going to object during those closing arguments. And ironically, I think the best witnesses were the IT experts. And the irony is that they did 0 for their case against Karen. The only thing they did was rise reasonable doubt as to Jen. Yeah, I would agree with that. I think that I agree. Okay, so here's
You are unmuted.
Here's the lawyers now.
All right.
So they are going to be.
So the charge conference, the first question I have is regarding I'll go through them in the order that I have them in my very rough draft. But
this is the stuff.
There's no request of the lesser included offense of voluntary manslaughter to the second degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter as a lesser included of the second degree murder?
I'm sorry. That's correct, Your Honor.
Okay. And neither side has requested an instruction of a lesser included of OUI?
It's correct as well.
And the defense is not requesting that?
That's correct, Ron.
Okay.
Okay.
All right.
So there were some questions about the charges that they are going to be going with. So we're going to get some more information on that. I'm going to reserve any questions on that. Let me get these other questions in first before we continue with this. Quentin Smith, Legalbytes, FYI, Law and Crime Network has it. Oh, okay, there we go. We got it. Lucian, question. Lally kept referencing a taillight piece being found in John's clothes, but I don't recall that coming out through testimony. Did I miss something? It did, because I think it was either Trooper Proctor or Buchanan. One of them testified about that, how when they collected the clothes, there were like tiny taillight pieces in there also that they like put in the same bag. And somebody testified to like having taken out the bag and there were tiny taillight pieces in there. Ice Cool 2020, Legalbytes, what happens if a hung jury occurs? Mistrial with prejudice. It is a mistrial. Mistrials don't happen with prejudice. That just means that they've got to start again if the Commonwealth so chooses. So mistrial, yes, hung jury means mistrial. And that means that the Commonwealth can decide to bring the case again or decide not to. It's up to them. Okay, that's all the questions for now. All right.
All right. So the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and we'll do each one. The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
I'm sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to look on.
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one to you by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect, and circumstantial evidence. So I received today defendant's request, a later request.
Yeah, so Bowdoin instructions, it's about the quality of the investigative work here. So Jillian Simonoto, Bowdoin instruction has to do with how the jury can consider bad police investigative work. What Judge Canoni basically said here was that she's not going to give a Bowdoin instruction. The defense is going to argue about it. So she says that it won't have a bad impact because the jury's going to hear that anyway through the defense's closing argument.
For the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited.
I actually quoted it, Your Honor.
So from which one? From Haunch or?
Haunch quotes McCormick, and McCormick takes the law from Dustin. There are multiple cases that.
Right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. I haven't given that in years, but I'll give that part of it. And just to finish off that paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that. All right. All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe. The second element, first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has three sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes.
Okay, so I am going to put that in there.
So they really needed that Aruba evidence to get that in. Really quick here, Odin's Martyr, thanks so much for the super chat. Why weren't the taillight pieces found in the clothes contained in any of the police reports the last two witnesses received? I don't know. And also, for right now with what they're going over right now. El Bori, I thought you said Bowden and Daubert were expert witness qualifications. Sorry, not trying to beat a dead caballo. No. So I totally understand. Daubert was one, Fry was the other one. So there's a Daubert test and the Fry test. Bowden wasn't one of those, but it's easy to get these things kind of mixed up. And I'm still saving other questions.
And the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Do you want to just leave the whole generic sentence?
I think we can, yes.
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but there's no evidence of drugs either, so do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
It makes sense to me, Ms. Giannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but.
I would prefer just to keep it in and just jump as
all right, so I will think about this one tonight, okay?
Also, really quick, forward thinker. It says, Legalbytes, please explain the difference between murder 1 and murder 2. So murder 1 in Massachusetts is murder with malice aforethought or using extreme cruelty or atrocity. Basically, like you had a plan in advance to kill someone. Second degree murder is when someone intentionally kills someone, but does so without this like motive, essentially, this malice aforethought, premeditation. So, but you still need intent to kill them. You still need to have purposefully done it.
Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Mr. Yannetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element. Yep.
I'm sorry, Your Honor, is there a page number? I'm just going through my...
9.
9.
All right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion one I thought was from the model instructions. If I'm wrong, then we're fine with model instructions on this issue.
All right, what does the Commonwealth say?
The Commonwealth's language comes from the model and jury instructions, I believe, from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read.
On page 5, third paragraph, it's either a similar sentence or a.
Yeah, it's a similar sentence, and I was just having both. It was, a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected or emergencies. So we don't need both, Ms. Gianetti?
I agree.
So you had both, so I'm just not going to do that.
We're perfectly fine with that.
Okay? So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless. So for the fourth element, Ms. Gianetti, this is where your language. You have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
No, yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
Yes.
Okay. All right. So I'll keep it. I mean, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Gianetti, okay? All right. I am going to give the lesser included offense of involuntary manslaughter. So there's additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those 2 sentences I find go better together, Ms. Gianetti. Is there any objection to that?
No, I understand.
Okay, any objection from the Commonwealth?
So in case you guys are a little confused as to what's happening, they're going through all of the elements. They're going through all of the elements that they have to go through in front of the jury, and they're going to verbally go through it in court. I think probably before closing arguments. I can't remember what she totally said. It's either before or right afterwards. But they'll go through it verbally, and then they'll get a copy of it to go into the deliberation room so that they can go through element by element. So they're going through what is the proper language to be using for all of these different instructions. So that's what's going on here right now is they're kind of going back and forth, and does the case law support this kind of language, or do the model instructions support this kind of language? Like, what is the basis for wording this jury instruction in this particular way? And sometimes it can make a big difference based on what kind of inclusive or exclusive language you use. And this is very, very lawyerly stuff where it's very dry, but it's very important for the case.
So, Ms. Gianetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So,
I think you're right.
So,
Yeah,
okay, so that paragraph that begins with that, we'll just cross that out.
Yeah.
I think that's fine.
Okay.
That's usually for a case where somebody gets pulled over by a cop.
In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth, if you could consider it, please.
Yep, so that will be in that last paragraph of that offense, Mr. Linetti.
I'm going to start fast.
Okay, then the lesser included offense, motor vehicle homicide, felony OUI, liquor, and negligence. I'm going to give that. So I don't have anything because you didn't, the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Tianetti. I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. It's obviously the law, right?
Right, that's the law of negligence, and I do understand the law of lesser included.
Okay.
Right.
All right, thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident.
She's not saying that the evidence.
So,
did that.
Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
One way or another.
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, and they don't need further instruction.
Yeah.
I think it would be sort of redundant or unnecessary to explain to a juror what failure to provide documentation of registration and things like that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Tianetti?
We're in complete agreement, maybe for the first time in this.
All right, so we'll just leave it. You've offered 6, 2 pages or 3 pages of definitions, so we won't do that.
That's fine.
Okay. All right. Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law. Tell me about your request to have that.
Your Honor, the request goes to the defendant's state of mind. Also, it would go to any intent or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If they understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon, and in using that to strike an individual, that could be used in their deliberations, assessing the defendant's intent or state of mind at the time of the collision.
It seems to make sense, Ms. Tianetti.
My position is it's unnecessary, but I'm going to waive argument beyond that.
Okay. All right. I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears on the Commonwealth's request. All right. So that's basically it. The longest part maybe is the general instructions in the beginning. Anything specific from the Commonwealth that I did not include?
Do you intend to give a conscience of guilt instruction?
Oh, I'll hear you on that. I don't, but you can try and convince me if you want.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to a consciousness of guilt. There's an inference that the defendant deleted portions of the Ring video, a narrow area of Ring videos that are missing. They begin with Mike Camerano picking up his daughter at 11 a.m. They resume at 5:07 when the defendant backs her vehicle into John O'Keefe's. Then there's a period missing where the defendant shows the broken taillight to Jennifer McCabe and Kerry Roberts, and then the video resumes again when the victim's niece gets picked up. But not only the missing Ring videos, but also the defendant's behavior. What began as testified to from the Dighton police officer, the defendant's father called the Dighton Police Department and requested a ride to the Good Samaritan Hospital due to the weather conditions. He then drove himself to Brockton to pick up the defendant and perhaps bring her home. What they do in the middle of a blizzard is now Dighton to Brockton is half a distance. Then they travel further all the way back to Canton to retrieve the murder weapon. Along with the defendant's brother, they all meet at the victim's residence to remove the murder vehicle and bring it all the way down to Dighton, Massachusetts. That would go to concealing evidence and intentional. There's also evidence of the defendant's statements going to her consciousness of guilt. Within hours after John's death, the victim's sister-in-law calls the defendant, reaches out, wants to make sure she's okay. The defendant says to her, "I only have to remember the bad times. You'll likely never hear from me again." Erin O'Keefe testified that she tells the defendant, "Of course we are, we're friends." She's never heard from the defendant since. So I think that goes to the defendant's state of mind in the hours after the death. But in addition to the Ring video, I think there's strong evidence of consciousness of guilt to move the murder vehicle within hours of John's death.
That does not indicate consciousness of guilt. Like, look, something that's going to indicate consciousness of guilt is if they hid the murder weapon or they got rid of the murder weapon, or something like that is going to, they deleted their entire phone. Oh, wait. Yeah, this is there has not been nearly enough evidence about the Ring footage to suggest that she has deleted it to say that is something that can indicate consciousness of guilt. And then other statements that she made, no way. That's, you got to stretch before you try to reach that far.
Ms. Giannetti?
Well, first of all, with regard to the Ring video, Trooper Guarino, who was certainly no friend of the defense in this case, testified that there was zero evidence that Karen Reed had access or had access anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. Yes. So I would say that is a red herring. Yep. This is the one case, I think, a very rare case where there's much more consciousness of guilt evidence with regard to the Commonwealth own witnesses than there is with regard to the defendant in the criminal case. With regard to the other arguments, I'm having trouble following.
So the moving the car extra distance during a blizzard.
You went to your
that part of the argument that the Commonwealth made.
Right. I mean, the evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time there. To say that moving her car to her own home, where the police later found it because she was there and picked up the phone and said that the police were coming, and she stayed there and they were able to seize the car. That does not rise to the level of consciousness of guilt.
Yes.
Okay. But the defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support.
Raise your hand in the chat if you had just found out that your significant other had died out in the cold, that maybe you would want to spend time with your family the rest of the day. Who else would want that? I know I would. Does that mean you're guilty of anything, or just that you need emotional support from your family? Like, sorry. That's ridiculous.
Or an inference that she was concealing evidence.
Right. Well, even if it's her parents' house, Your Honor, again, if she's no longer dating John O'Keefe because he's passed away, then, it makes sense for her to have her vehicle at her parents' house or her own house. Again, it does not rise to the level of consciousness.
Nor does she stay at the home of her boyfriend to grieve with the family who just lost a job. She quickly comes back to the house, brings her family members, goes upstairs for about 20 minutes by herself with her father, and quickly leaves the residence.
Come on.
There's no evidence that she did anything upstairs or that she had access or the ability to change anything.
Okay, it's a little bit more robust argument than I expected from the Commonwealth, so I'm going to think about this. I'll let you know before closing argument tomorrow, and if I don't instruct on it, Commonwealth's still able to testify to it. Witness pretrial preparation, that came out on both sides. I'm going to give the second alternative. Okay, Ms. Giannetti, I'll hear you on your instructions.
So I believe that we covered the vast majority of it.
I'll give you the opportunity to argue the Bowden one, just so you can make a record.
Sure. Let me just pull up.
I'll find your page.
Okay, so yeah, I mean, with regard to the Bowden evidence for instruction, Your Honor, having done this for as long as I have, it's requested a lot and not given, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this is closing argument.
Right.
But I think that if there's any case where a Bowden instruction should be given, it's this one. We start with the conflict of interest that existed at the start of this case, and the fact that Michael Clarkman was allowed to not only continue with the case, but to be the lead investigator or police officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then move to the fact that, he never, as a lead investigator, went into the house at 34 Fairview. He never looked around. He never checked for any signs of struggle. He never checked out the basement. He never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. He never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's arm. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed together, that they were not separated out on numerous occasions. Brian Albert, Paul Albert, John McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Julie Albert were interviewed together. And then we have all this, evidence, the way it was handled, or I should say mishandled. Starting with the leaf blowers and the solo cups and things being pictured on the floor of garages, but not being properly handled, and the fact that there are no chain of custody laws for the evidence before March of 2022. So I just highlight those, Your Honor, as examples. I believe there's more, but that's the record that I would make.
Okay, so you satisfied you've made a complete record on this?
I mean, so.
All right, but I did include some specific bias language that I read to you early on that sort of ties into this. Okay, so nothing else?
So I have one question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or not.
Thank you for bringing that up, Ms. McLaughlin.
I agree that it's not appropriate.
Okay. All right, so I will see you tomorrow morning.
Question, Your Honor, is, and I haven't tried this before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. I do give 2, maybe 3 copies to the jury afterwards.
There was some question as to the use of chalks for closing argument.
To prevent use of chalks for closing argument?
So can we focus on this? So does the defense intend to use chalks?
I'm going to defer myself on that. 2.
What do you intend to use?
photographs of the vehicle and photographs of the taillight. So 2 side-by-side photographs of the taillight that are in evidence, and photographs of the vehicle, still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it for me.
Yeah, I couldn't tell if they were saying charts or talks either. Charts
Okay.
seem to make more sense.
Commonwealth have any objection?
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events from January 28th through January 29th.
Okay. Any?
The request is I'd like to see that.
Sure, you should both exchange them, okay?
Judge, my other question is that at one point during the trial, there was a changing of 2 jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number. They may not remember what that is.
No, I have absolutely.
No, they may not.
Okay. They may not know their old juror number?
Their actual 3-digit number.
Right. They may not know that. Do you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay.
All right. Why did you want to move them into? We'll talk about this.
Okay.
All right.
When is that done?
At the end of the instruction, before I give the instruction on be fair, the SJC instruction on be fair.
Can I ask a question?
Yes.
You pick a full person?
Yes. Yeah.
So sometimes it's done by lottery. I just wonder.
No, so, right. In Massachusetts, it's supposed to be chosen by the judge. So I know. All right. Anything else?
I need to learn more about Massachusetts law.
Yeah. All right. Thank you. We'll see you tomorrow.
Okay.
All rise.
All right. And then we've got the fan again. Okay. A few more questions and then we are going to call it quits for the day. Look at this. Indy is spent. She is done. Stick a fork in her. She's done. Daniel Nagy question for Legalbytes. If it's a hung jury, how long do you think it will take them to come to it? Like how long will they, long will they try to convince each other about her being guilty or not? So this is an interesting question. How long does it take for them to be considered a hung jury? They can be in disagreement for quite a while. It can take several days for them to be in disagreement. The one of the biggest factors in determining whether it's just a hung jury or whether they should continue deliberating is, well, number one, the judge is going to ask them, like, do you guys feel like you want to continue talking about this? And if they come back and they say, yeah, no, we feel like we're making progress here, then the judge will say, okay, we'll give you more time. So that's really one of the biggest things is do they feel like they're making progress? Are they moving subject by subject through what they think they need to go through, and they've made decisions along the way? Then they're progressing forward. Then they're more likely to say, okay, then let's continue on. Otherwise, if they're stuck on one particular subject, they've gone through a bunch of different stuff, looked at it from all kinds of angles, and you've just got like several people, 2 people that are just completely disagreeing and saying, nope. No one is changing their mind. They are very convinced with the way that they see things, and they're opposed to one another. And then you've got a hung jury. Jay Darkman, Legalbytes sidebar. I specifically started watching this case since I'm doing a master's in digital forensics and I suck at iPhone forensics. Boy, has this case gotten rid of my imposter syndrome. It's so funny how that happens, right? It's great. Elena question, have they decided who will be closing for each side? They have definitely decided. They probably decided that even before trial began. They haven't specifically said. It sounds like Alan Jackson, even just from, him talking about what he would need for the closing arguments, it sounds like he's going to do it. I don't anticipate that Miss McLaughlin is going to do the closing arguments because the jury doesn't know her. They have not heard her say a single word. We've heard her talk several times, but that's always been outside the presence of the jury. So that would be very strange if the prosecution decided to have Miss McLaughlin give the closing arguments, although she was the one to talk about what they would need for their closing arguments for visuals and whatnot. So I anticipate it's still going to be Lally because it's been Lally the whole time. But yeah. Nebraska Jeff, how long, Haas long, until the jury is back once they start deliberating? It's up to them. Jay Darkman, Legalbytes, I forwarded this trial's VOD playlist to our iPhone testing specialist yesterday, and she just messaged me they can take glasses outside of their pub. Talk about a sidebar. I know, right? That's great. That's a great joke. I like that one. Evil Bunny 7603, how long do you think they will deliberate? Could be hours, could be days. I really have a hard time trying to predict that. It could be either. HKR, Legalbytes, how long before they give the verdict will the court announce it? How long do we have to find out they are going to give a verdict? So what happens is the jury will deliberate. They'll go through stuff. Oftentimes they'll send notes to the judge through the bailiff. They'll send a note saying, you know, we're at an impasse for the day. We're exhausted. We want to go home. You know, if it's like 5 o'clock or what have you, that, you know, there'll be that. Or if they have a particular question about the instructions or a question about a piece of evidence or something, they'll send the question through the bailiff to the judge. The judge will read it out loud in front of both of the legal teams, and the judge will basically say, like, this is what I'm going to respond, or I won't respond, or something like that. Then there will also be, you know, at the end of the day, if there's no decision, oftentimes like, okay, do you guys feel like you're making progress, and like that kind of thing. So there's that too. Then also, when they have actually reached a decision, they will also send a note to the judge, and the judge will let the legal teams know, and the media will find out. They basically will say, like, there's 20 minutes notice or 30 minutes notice until the jury is in the courtroom and they have their decision done. So that's basically like how much time we'll have is enough time for the media to sort of scramble into the courtroom, and everybody fills it in, and that's going to be what happens with that. Oh my gosh, Indy looks so cute right now with those little toe beans. Oh my gosh, so cute. Jay Darkman, Legalbytes, this is just me, but if I was handling this, I would have gone with it's easier for prosecution to prove that Karen accidentally hit John in a drunken state that led to the death by exposure. Yeah. It would have been a lot easier to prove that. But they wouldn't have been able to go for the same firepower in terms of punishment. Janet G. Okay, I need to go back and finish up listening to Dr. Wolfe, but glad this is going to jury tomorrow. Legalbytes, are you putting up a poll for how long for the jury to come to a verdict? I can definitely do that. I can definitely do that tomorrow. DeMajor LDN, Legalbytes, if you could predict one question the jury might come back with from the deliberation room, what would it be? I don't know. Maybe something in the instructions is what I would say. Like that's the best that I could do is, you know, there's something in the instructions that kind of confuses them a little bit because they're not used to reading jury instructions. That would be my best guess. So yes. Okay. All right. Anyway, so that about does it for me. This has been a fantastic stream. Thank you so much for joining me in this trial. After 30 days, we are finally going to closing arguments for day 31. And also, okay, we'll get this one to close it out here. Oh, I guess there's two more questions. Danny Duclos, in case you missed it, can you remind us the charges? So 3 charges. There is murder in the second degree. There is DUI, so driving while impaired, leaving the scene after a collision. So those 3 are the charges. The Lucian Legalbytes question, I recall the judge saying that she would add a lesser charge. Can she do that? Well, there was no request to add a lesser included offense. So no. It sounded like she said no, we're not adding one because no one wanted one. So okay, that is about it. If you guys haven't done so already, please do like the stream. Definitely helps with the YouTube algorithm gods. If you want to continue seeing trials like this and continuing with other legal topics on the channel, definitely subscribe. We are so close to 250,000 subscribers. And the poll, oh my gosh, thank you. Going into day 30, how do you lean regarding KR's murder charge? 3,600 votes. 91% said not guilty. 4% said need more information. 3% said guilty. So tomorrow I'm gonna have this poll going into the closing arguments as well, but there will not be that option for need more information, because if you say need more information at that point, that means not guilty. So because all of the evidence is now in. So, alrighty. And yeah, that's everything. Okay. All right, folks. Thank you so much for everything. Thank you for joining me. Thank you for all the super chats, the memberships, all the good stuff. Thank you to the mods for helping to make sure that dialogue is facilitated in a way that people can agree and disagree and do so in a way that is, helpful for all of us to get to the truth with a capital T, get to the bottom of it, right? Anyhow, thank you so much for joining me. And we'll be getting a recap out for day 30 as soon as possible. And otherwise, I will see you guys tomorrow for closing arguments in this case. We're finally here. We are finally here. Okay. So thank you once again, and I will see you guys in the next video.